Can I just say something about Andrea?
Good morning, everybody. Welcome back. We are just waiting for court to get started over in Provo as we're continuing to work through a bit of a backlog in motions in the Tyler Robinson case. It's not 100% clear what we're dealing with today, but I am expecting that we're going to be dealing with the defense's motion to hold Christopher Ballard, the prosecuting attorney, in contempt, not the prosecutor, but one of the deputy prosecuting attorneys on the team. And they're arguing that he violated the gag order by making a bunch of statements to different news outlets after it was reported that Tyler's gun didn't match the bullet fragment recovered from Charlie's autopsy. He made a bunch of statements to explain what the inconclusive result was. And the defense is taking issue with a number of those statements, arguing that they are violation of the gag order. They involve things like test results, which are, specifically there under the ethical rules that you have to follow. And then also that they're expressing their opinions on guilt and so forth. So the reason why I think we're probably going to see this motion is because it's the one that's like fully briefed. Now, having said that, just yesterday, the defense filed their reply on this issue of whether the preliminary hearing should be closed and then the exhibits sealed, so that once again we the public wouldn't be able to see all of the things. Now that one I wasn't really expecting it to come up today, because where they had left that at the last hearing was that the defense needs to be more specific about what exactly are they wanting, eyes off, what exactly do they want to close. All the briefing has just been in these kind of general principle sorts of terms. But that said, the state did file an opposition and they did file a reply. The news media also filed an opposition, which is helpful, by the way, because the state is agreeing with sealing the exhibits. They think we should not be able to see the exhibits from the preliminary hearing. The media is opposing that. So we'll see how all that fleshes out and how much of this we actually get to work through today in court. So I will just briefly share with you guys the filings that that I'm expecting anyway, we're going to be going through. This is the order for contempt. We did look at this a little bit at the end of at the last hearing. And so they're basically two things that they want. They want a hearing. An order to show cause hearing basically puts the burden on the prosecuting attorney to explain why should we not be held in contempt. So this is a real similar procedural context like we had with the motion to disqualify the prosecuting attorney's office, where it's like you kind of have to meet a basic threshold of like, okay, there's enough here to suspect that there's a problem. And then if there is, you have an evidentiary hearing and the burden is kind of on the party who's opposing disqualification, or in this case contempt, to show why should that not be the case. So he's arguing, Tyler Robinson is arguing that just based on the statements that Mr. Ballard made, that he should be held in contempt. And so this is based on obviously the gag order that's in place, but then the specific statements that are made. These are the prohibitions from the gag order that the defense thinks has been violated, because the comments relate to performance or results of any examination or test, any opinion as to the guilt or innocence of the defendant, and the fact that the defendant has been charged with a crime, unless there's a disclaimer that this is merely an accusation and the defendant is presumed innocent until and unless proven guilty. And so everybody's been unaware of this. There was motions to clarify what the gag order requires. Gag order requires the prosecution and the defense to notify their witnesses and the people that are kind of like affiliated with their team about the provisions of the gag order and to take reasonable measures to try to get their own people to voluntarily not make statements to the press as well. So the state did that, and the defense is using that to argue, hey, they know what the rules are. They're telling other people what the rules are. And so we looked through these at the last hearing towards the end there. These are generally the public statements. He made them to TMZ, made it to USA Today, made it to Fox News, PolitiFact, got an email from him. And so they're more or less the same thing in the sense that he is couching it as a general, not like I'm telling you specifically about the results of this particular test. He's casting it as a generally, here's what this type of result means. And it just basically it's a can't rule it out type of situation, but you also can't rule out the universe of other firearms either. It's included, but it's not included like to the exclusion of everything else in the world. But then there were some like added comments that are maybe a little close to the line here. These things like, the state's doing more testing, more investigation. They're expecting supplemental reports. This one was just kind of a general about the result, the one to PolitiFact. This particular statement, I'm sure that the defense doesn't like this one at all. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder, and we will present some of that evidence at the upcoming preliminary hearing, and then we will present all of that evidence at the trial. That's not really the disclaimer that the rule calls for. Like, yes, we're acknowledging that the burden is beyond a reasonable doubt, and but he is presumed innocent. And is it okay to say you have enough evidence to meet that standard? Not real crystal clear. So that's what the defense is unhappy about. The state has responded, and they've basically said this is fair. This is fair response. So they're first off trying to turn it around on the defense team and argue that all of this is because the defense team originally filed a document where they mentioned this result, but their characterization of the result was incomplete because they said it wasn't able to identify the firearm, but the actual result is that it couldn't identify or exclude the firearm. And so the prosecution is saying all of this derives initially from the defense's kind of mischaracterization of what the test result was. And then because of that, the news media, specifically, I think the Daily Mail, jumps on it. So here's all their stuff about what the defense said. It's in the motion to continue. ATF was unable to identify the bullet, and it might be exculpatory. We might be used it, but the report actually says it can't be identified or excluded as having been. So they're saying this is a mischaracterization. Based on that, the news media jumped all over it, primarily this Daily Mail article here. And so then that went viral. There was all kinds of misinformation about it. None of this was initiated by the prosecution. This is misinformation that's out there that is not caused by them. So, they're clearly, guys, those of you wondering, they are clearly on both sides, like intensely monitoring the news coverage, the media that's out there about the case, because we're kind of starting to see this as a pattern now. Document after document is just full of media references and stuff. And that's continues to be a big focus in the litigation. So they're arguing they responded to the inquiries. They explained the full context of the ATF report, expressed that it had confidence that it had sufficient evidence to proceed and prove its case. And so they're saying that it's not a violation under the fair response provision of the ethical rules. And that's section of the rule that says a lawyer is allowed to make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. So they need to correct the record, is the basic argument. So I find this is going to be a very interesting argument for me. And the reason why is because this whole fair response aspect of the rule and kind of the ethics and the limitations on what you can say and so forth, to me, that's like where the most interesting part of lawyers' public statements kind of sits. And this all, I mean, for me, oh, it looks like they're getting ready to go in the courtroom. So let me get that up right away. It started for me like all the way back with Adam Waldman in the Johnny Depp trial. And in that, we should have sound when it comes on. In that particular situation, you know, the issue was that there's like a ton of this you know, media that's out there for years that's just Amber Heard going to TMZ and whatever and kind of litigating her side. And so then he just kind of started, you know, correcting the record with the evidence, a lot of the evidence that they were getting that wasn't confidential in the case, things like the recordings of the fights and so forth. And this was like one of the early instances in my memory of a lawyer like really having a kind of full court press media strategy, like we are going to publicly correct the record. And it was very noticeable because you didn't see lawyers doing it a lot at that point of time. There's still this culture that like it's just unseemly for lawyers to, you know, litigate their cases in the public eye and so forth. But at the same time, you had this extraordinary situation of this guy who's so incredibly famous, and these stories are everywhere, and the misinformation is everywhere, and it's a defamation claim, which, you know, relies on damage to his reputation. And there's kind of these counterpoints that like, well, he needs to, you know, mitigate his damages. Like if he can sort of fix the problems with his reputation, maybe he should be doing that. Maybe this is just all fair response to what's already out there in the media.
Okay, so Stacy's here.
So I saw
Richard's here.
but the whole like First Amendment aspect did not get litigated. This appeared to me to be a kind of a conflict on the team about how they wanted to handle just the media management side of the case. Adam Waldman had a very aggressive approach. Ben Chu seemed to not particularly be on board with that and wasn't going to like advocate real strongly for Adam Waldman's right to make those kinds of statements. So the right to respond is kind of,
and your acknowledgement.
this is annoying. I mean, I don't know. I guess people like the hot mic stuff, but I'm not going to be listening to it. Anyway, so this is like the first time I think that I can remember seeing the right to response being like kind of front and center in the litigation on what lawyers get to say. And so the scope of what that means and how far do they get to go, how well within the lines do they have to stay? These aren't issues that like really get argued to a great extent. You don't necessarily get a lot of rulings on that type of thing. I think it's also interesting, just given our context, where we already know the judge has kind of cautioned. We've got the gag order, and the judge has already kind of cautioned people, you know, be careful, watch what you're going to do. It seems to be a signal that if you're going to get close to the lines, you know, you'd better be real sure that you stay on the right side. And so it's not, I can't imagine the judge is like thrilled that anybody is making statements to the press. But are these, you know, close enough to the line? I'm just going to mute it. Sorry, guys. If you want to listen for hot mic stuff, go ahead. But I can't talk over that. So anyway, that's kind of our context for the gag order. I'm definitely interested in that. The motion to close the hearing, like I said, we only just got the reply on this one yesterday. In fact, I haven't even posted it on the Substack yet, but I will before the end of the day today. And so, yeah, they're both agreeing that the public shouldn't have the exhibits, which is kind of alarming to me. Oh, we're getting started.
6, State of Utah versus Tyler James Robinson. Counsel, could you please enter your appearances?
Good morning, Judge. Chad Brunander, Ryan McBride, Chris Ballard, Lauren Hunt, and Jeff Gray for the state.
Good morning.
Good morning, Your Honor. Kathy Nestor, Richard Novak, Stacy Visser here for Mr. Robinson, who's seated at the table.
Good morning.
Good morning, Your Honor. Jeff Hunt and Mike Judd on behalf of the news media.
Good morning. And the court also recognizes Mr. Robinson. Good morning to you. All right, before we address the motions before the court will take up a couple of preliminary matters. First, with respect to courtroom protocol, to maintain security and decorum, any individual who exits the courtroom during the proceedings will not be permitted to re-enter until recess. All counsel are expected to take reasonable measures to safeguard confidential communication. Such measures may include the use of screen protections on electronic devices and care to avoid the inadvertent capture of privileged or private discussions by recording equipment or by those present in the courtroom. I will note that for today's hearing, we're going to turn off the microphones at the jury box and at counsel table. And so I ask, in order to avoid picking up inadvertent conversations or communications, and as you speak, if you wouldn't mind just coming to the lectrum, and that will be the microphone that will be live for this hearing. Next, turning to the camera operator and still photographer. So would the two individuals responsible for video and still photography please come forward and state their names for the record.
Do our daily shaming of the media.
Your Honor, Trent Nelson with the Salt Lake Tribune is still photographer.
Good morning.
Your Honor, Jeremy Dubas, KUTV 2 News videographer.
Good morning. All right. The court's purpose is to ensure the clarity regarding the expectations governing today's proceedings. And could you have you reviewed the court's standing decorum order dated February 24th, 2026?
Yes, Your Honor.
Yes,
All right.
Your Honor.
And do you understand the requirements set forth in the order as they apply to your activities today?
Yes, Your Honor.
Yes.
All right. Do you require any additional time to review the order or to adjust equipment to ensure compliance?
No, Your
No.
Honor.
And do you anticipate any difficulty complying with the order or the court's instruction?
No, Your Honor.
All right. Well, Mr. Nelson, Mr. Dubas, I appreciate your cooperation today. Thank you.
Thank you.
Turning next to discovery for the state, could you provide a brief status update regarding discovery? Mr. McBride.
Well, we had provided a I'm sorry.
Go ahead.
Okay, good. I was like, please go to the lectern because I can't hear.
As of May 12th, we had provided 100% of the material in our possession. We received additional discovery from the State Bureau of Investigation over the last week, and that material will be transferred to the defense very soon, probably this afternoon.
All right. Thank you, Mr. McBride. Turning to defense, do you request the benefit of the record?
Thank you, Your Honor. Since our last status update on May the 4th, we have received a total of 2,462 more files. Over 2,300 of those were residential surveillance camera videos. Many of those we did have previously. The remaining files were ATF and FBI without the DNA data, reports and files, and then some 1102 statements, some jail records, some other law enforcement reports. I appreciate that the state has given us 100% of what they have. We really don't have a feel for how much they still have not gotten. I don't know if they know. It seems like it's just constantly coming in, but we do appreciate how fast they're turning it over. But when you say we have 100%, I think what they're saying is they have 100% of what they've received has been sent to us.
That's what they
but
said.
There's still maybe quite a bit out there that we just don't know how much it is.
All right.
Thank
you,
you,
Ms.
Your Honor.
Nestor. All right, well, let's turn to defense's motion for an order to show cause for alleged contempt of court and for an order compelling discovery related to the alleged contempt. And just for management purposes, each side will have 30 minutes to present argument. If defense intends to reserve time for rebuttal, counsel should plan accordingly. Afterward, we'll take a 10-minute recess. And because this is defendant's motion, defense will proceed first. And again, as a reminder, this argument is in regards to whether the court grants an evidentiary hearing to hear additional evidence. And that's the decision that's before the court. With that, turning to Mr. Novak.
Thank you, Your Honor, and good morning.
Good morning.
I think as the court stated, there really are two issues before the court today. One is whether under Utah Code Section 78B-6-301 et sec, this court has an obligation to issue an order to show cause and set an evidentiary hearing. And the second question is whether in preparation for that, the court makes a finding under Rule 16 of good cause to compel the state to comply with our informal discovery request. And what I would like to say is that it seems beyond debate, based on the evidence before this court already, that the court does have an obligation to set an OSC evidentiary hearing. It's important also to note that the statute 78-6-309 actually says that the court investigates the alleged contempt and may call witnesses. So I'm actually, if I may, gonna address the two issues in reverse order, which is the discovery issue and then the hearing issue. The communications, the events, the conversations, the state of mind of the various members of the prosecution team with respect to the decision for Mr. Ballard to go on what I will call a media tour is central to not only the core question of whether there's been a violation of the court's order, but frankly, the egregiousness of that violation. While we pointed out in our papers, and the state did not take issue with this in theirs, that because the court's orders, the court's pretrial orders, are injunctions, we don't actually have to prove there's been an intent to violate the order. The fact that what I'm going to call an alleged contemner knows of the order and has failed to comply with it, those two elements are all that is necessary. But the question of the seriousness of the violation, the sanctions that should be imposed in light of the violation, do get at intent. So intent is not irrelevant, but it's not an element of what I might call the alleged offense of contempt of this court's orders and violation of Rule 3.6 and 3.8. So we think that this court can't really fulfill its statutory duty to investigate without the parties, well, without the court and Mr. Robinson knowing what communications the Utah County Attorney's Office had with various media outlets, what the nature of those conversations were, what the nature of the internal conversations were concerning whether Mr. Ballard should go on Fox and Friends and have a nationally and internationally televised interview, whether the Utah County Attorney's Office should issue emails to media entities, and The Supreme Court's decision, which has been cited to this court in the briefings in the
Archuleta.
matter of Levitt,
Oh, no, love it.
clearly show this court that the alleged contemners' awareness of problems with their conduct is central to the inquiry. So one of the first things that the Supreme Court said in its opinion was that after Mr. Levitt had his press conference and he went back to his office, people in his office said, wow, that's a problem. And so that internal communication is central to this court's assessment of what we would call the seriousness of the violation.
Well, Mr. Novak, let me stop you right there. Is the violation what happened allegedly? Because I haven't watched the interview or what's been purported. Are you saying the violation for the potential sanction is what happened on the news or what happened behind closed doors?
The violation is what happened. The violation is extrajudicial statements that have a substantial risk of impacting the proceedings. Okay, and the two specific violations are Mr. Ballard's statements on behalf of the Utah County Attorney's Office. So the question really is, and I'm not suggesting that this is the case, but the question is, did Mr. Ballard go off on his own and do this all by himself, or was there a management decision to go do this? Okay, but the conduct that is a violation of this court's orders is to make extrajudicial statements about forensic evidence, not only what the forensic evidence is and the testimony will be, but if the court looks closely at especially Ms. Visser's declaration filed in support of the motion, Mr. Ballard commented on what future versions of ATF and FBI reports will say after future testing is done, as if he somehow had a crystal ball as to what the evidence ultimately will be. And the second violation is statements that clearly are expressions of opinion as to Mr. Robinson's guilt. And these are two of the examples highlighted in the comments to Rule 3.6. I mean, this is textbook, don't go out and say these things extrajudicially. And if the court looks at the exhibits to our motion, what the court sees is the Utah County Attorney's Office was very cognizant of the fact that Rule 3.6, Rule 3.8, and this court's orders prohibit those kinds of statements because they sent letters to what I will refer to as their law enforcement partners, basically saying, don't go out and make extrajudicial statements. So I'm going to get back to the court's question. The court's question is, where is the violation? The violation is the extrajudicial statements. What I'm saying about the need for this court and for Mr. Robinson in order to meaningfully participate in the OSC hearing, to understand how it is that Mr. Ballard came to be going on this media tour, because that gets to the seriousness of the misconduct and the types of sanctions that are appropriate. So I'm not saying that a conversation between Mr. Ballard and, let's just say hypothetically, Mr. Gray, that's the question, is where did these conversations start and where did they end that led Mr. Ballard to send emails to media entities and agree to sit in a studio or at least online and talk to Fox News? That's not, the conversations are not the violation. The conversations guide this court to the state of mind with respect to the violations.
It's arguing past the sale
sanctions
is
that
the
are
problem.
appropriate for violation of the order. The other question, which is related, is what is the harm to Mr. Robinson, which is something that this court is going to have to grapple with now. And as the bomb litigation demonstrates, and we attach what we think are the relevant orders from the bomb litigation, the remedies that are necessary to attempt to return Mr. Robinson to the place he should be in terms of the presumption of innocence, in terms of having a jury that hasn't been impacted by these violations. So the discovery request is narrowly tailored in time It's from March 26th until whenever the production that we requested was made, March 26th of this year. We were not asking the state for every single communication they've ever had with a media outlet since September. We were asking for communication since March 26th because it was clear that the moment we filed our motion to continue the preliminary hearing, the state decided that the way they would shape the media conversation about Mr. Robinson's case was to issue emails to the media and have live interviews.
So, counsel, you mentioned 78B-6-309, and it states the court shall proceed to investigate the charge and hear any answer which the person arrested may make. So would you agree it's the court's duty to investigate and decide what is necessary for the court to make that decision?
The court is entrusted with deciding whether or not there's good cause to require discovery. And I'm saying that in order for the court to conduct the investigation, which is required by the Utah Code, the court needs the materials that we were requesting. And good cause means materiality. So clearly, the communications between the Utah County Attorney's Office and the media and the internal communications, not about case strategy, not about witnesses, not about evidence, but about communications with the media, which led to what we think clearly is a violation of this court, 2 violations of this court's orders, is germane and necessary to the court's investigation. However, that doesn't mean that this court conducts an in-camera proceeding that Mr. Robinson is excluded from. We are the moving party. We have very serious constitutional rights, which we need to make sure that this court understands the nuances of in terms of the impact of the conduct and the seriousness of the conduct. So this is not a situation where the court, in my view, should receive the materials we requested in camera, not share them with Mr. Robinson, and not permit Mr. Robinson to participate in the OSC. I don't know if that was what the court was suggesting. What I'm suggesting is that the court should compel the state to give us the materials which we requested. If there is any question as to whether some of it may be privileged, the court can review it in camera, which is what we said in our papers. But that doesn't mean that the court conducts its own ex parte in-camera proceeding without us participating.
Sure. No, I'm not suggesting that. I'm simply saying
then I read something into the court's question that was unnecessary.
right. What I'm saying is
Right.
would you agree as part of this investigation in a hearing that the court determines what is necessary for the court to make that decision in regards to your request for discovery?
Yes, I think the court has to exercise discretion, but it's our position that the appropriate exercise of discretion is to compel the disclosure, for the court to review those materials, for Mr. Robinson to review those materials. If the court is concerned that internal deliberations produced in discovery need to be subject to some sort of protective order before there's an evidentiary hearing, that's fine. We've always been fine with protective orders. I think that we've been the party in this case that's always said less premature public disclosure of sensitive materials is best. Okay, and that, if I may, actually leads me to this, what I'm going to call a diversion about this ATF report. Okay, so our motion to continue did not mischaracterize the ATF report. What the state wanted to do is expand upon the inconclusive nature of the ATF report. And instead of doing that in this courtroom, they went on a media tour to do it because the media misinterpreted what we said in our motion to continue. Our motion to continue is accurate with respect to the ATF report. And I would also point out that it was Mr. Ballard, and this is an email from Mr. Ballard to us attached to Ms. Visser's declaration, which says that the state thinks that that ATF report should stay under seal because to publicly file it would be a violation of 3.6. It would be an end run, to quote Mr. Ballard, around Rule 3.6, because it would be filing in the public record a forensic report.
But then you did.
Okay.
You did file
So,
it.
but at some point in time, for some reason, the state decided that report should become public and everything should become public.
That's not, no,
And
no,
the
you
court
filed
granted
it.
that motion. And so that ATF report became a public document. And so in a court filing, we accurately characterized what's in that ATF report in support of our motion to continue. The court is well aware that there has been a dispute about the FBI's desire to do destructive testing without documenting that testing or allowing one of our ballistic experts to observe the testing. And so that's sort of like sitting there. But that's why that ATF report was initially lodged with the court in camera until the state decided, or I should say privately, to use the appropriate Utah term, until the state decided that it wanted it to become a public record. Okay, so the other thing that I want to say, and I'm going to save a few minutes, is that the state tries to take refuge in the notion that because we've made public statements, albeit in court filings, about something that the state thinks has been mischaracterized, that they get to go out and talk to the media to correct things. And that is not what Rule 3.6 permits. And that is not what the Supreme Court in the Levitt situation and in the Baum litigation sanctions. If Mr. Ballard and his colleagues thought that we mischaracterized the ATF report, which we did not, but if that's what they really believed in good faith, they could have done at least three things. One, they could have filed something with this court, a judicial communication, which said, we think that Mr. Novak and his colleagues have mischaracterized this ATF report. And our view of the correct characterization of the ATF report is as follows. Number two, they could have reached out to us and said, we think that you have either inadvertently or intentionally misconstrued or mischaracterized this ATF report, and we would like the parties to file something, or we would like you to consider amending your filing. They could have done that. Neither of those things happened. Instead, what they did was they drafted an email and they sent it to media entities like TMZ, and they scheduled an interview for Mr. Ballard with Fox and Friends, where he characterized it extrajudicially. And that's exactly what 3.6 prohibits. The fact that they didn't agree with the way we characterized evidence to this court is not an excuse for violating 3.6 and not an excuse for violating this court's orders. And this court will remember, I'm going to conclude now, that when the state challenged this court's pretrial and trial order and said that it was a prior restraint and that it was vague, I stood here and I defended the court's order because it wasn't a prior restraint on anybody other than counsel and their investigators. It's not a prior restraint on witnesses. It's a prior restraint on counsel. So there is no doubt that they understood that they can't be making extrajudicial statements about Mr. Robinson's guilt or innocence or about the forensic evidence. Those are two comments that are right there in Rule 3.6. Mr. Robinson has a right to a presumption of innocence until the matter is submitted to the jury. This court's done jury selection, I'm sure, in many different ways. And when the jury is in the box being selected, he has a presumption of innocence. Every day he has a presumption of innocence until the matter is submitted to the jury for deliberations. And that is something that Mr. Ballard knows, and he and his colleagues violated that right. And this court, in my view, needs to get to the bottom of why did this happen? Who was involved? What was the state of mind? Why didn't they do what the law requires, which is file something if they thought a correction of the record is necessary? The ATF report is in the public docket. It's there. It doesn't matter what Fox, CNN, MSNBC, TMZ, it doesn't matter what they think of the report. or what they think of our pleading. The only person who judges our pleading is Your Honor, not the media.
And it's
I've saved 3 minutes.
all right. Just a quick question for you.
Of course.
Assuming the court grants the request for an evidentiary hearing, how much time do you anticipate needing to present what you would like to present? Assuming, and if there's a difference, assuming you do get discovery that you're requesting, or if you don't get discovery, I just want to take that in consideration as well.
Thank you, Your Honor. I appreciate the question. And unfortunately, the discovery will tell us how many members of the Utah County Attorney's Office were involved in this decision. If it was Mr. Ballard all by himself, then there may only be one witness. I think the media evidence speaks for itself. We've lodged some of it as exhibits and some of it through hyperlinks, all in Ms. Visser's declaration and the attachments to it. If the discovery shows that there was a team meeting and there were a bunch of emails about it, then it may be that there has to be, that from our view, multiple people need to be examined under oath. So I'm not trying to dodge the court's question. I think that it's definitely no greater than a single day. I mean, I don't think this is a multi-day hearing. But I think the question is, how many people were involved in the decision for Mr. Ballard to go on national television and send emails to the media? And I can't answer that question. And so I can only give the court this general idea that I think it's a serious hearing that should take no more than 1 day.
And if the court doesn't grant the request for discovery and it's that sole witness, and I'm not holding you to that, obviously, how much time would you anticipate that would take?
So then, if I may, the examination, and I can only start with Mr. Ballard because he's the one who made all the public statements. The first questions would be, who did you discuss this with and when? And then we're going to get into hearsay, and then we may or may not have additional witnesses. I mean, it's like kind of like an onion. So I actually think that we should see what's in the soup before we figure out how long it takes to make it. I apologize for the food analogy this early in the day, but I think the court understands what I'm saying.
Thank you, Mr. Novak.
All right, thank you, Your Honor.
Turning to the state.
Well, I think they're going to get the hearing. I mean, I kind of would expect they would anyway, just because it is close enough to the line and it's a death penalty case and you got to let them make their record and so forth.
May it please the court. I think the first question is has the defense shown adequate basis to merit further proceedings here? Whether those further proceedings are discovery or an evidentiary hearing, the reality is that defendants has already mustered the prejudicial statements, right? That's what we're talking about here is the statements that have been made in the media. The defense has investigated that. They've reported the most prejudicial statements that they can find. And that's what the real question is do those statements violate the court's order and Rule 3.6? It doesn't really matter what other discovery shows. Maybe it does to a sanctions hearing, but certainly not to whether or not there's a contempt violation here that Rule 3.6 has been violated. So the question is, has the defense mustered that evidence and that information necessary to merit additional proceedings? And I think the best way to do that is to look at the statements and determine on their face whether there is a good faith basis, whether there is adequate evidence the defense has mustered to require additional proceedings. And so I think we start with the law. When there is pervasive media that misrepresents the evidence, that misrepresents the facts, and that creates a material risk of prejudicing the rights of a party, an attorney has the ability under Rule 3.6 to correct those statements. And in fact, they have the duty, under a duty of zealous advocacy to their client, to respond.
I said that about Adam Waldman.
In this case, there was a tidal wave of media garnering more than 10 million views in a matter of hours that mischaracterized the evidence, that misrepresented the evidence, that misled the potential jury pool as to what the evidence was. That media, of course, reached Utah County. It was widespread, and it created an undue risk of prejudicing or tainting the jury pool. As a result, the Utah County Attorney's Office had the ability under Rule 3.6 and the duty as a zealous advocate to respond and to correct those mischaracterizing statements, those inaccurate and misleading materials. Now, when we think about prosecutors, often we refer to prosecutors as the state. And that's because prosecutors have one client, and that's the state of Utah. But it's important to remember that prosecutors are attorneys who have a duty of zealous advocacy and an ethical duty to their client, just as stringent and as rigorous as any other attorney, an attorney for a civil client, an attorney for a criminal defendant. And their duty is to ensure that their client's legal rights are upheld and defended. And when an attorney sees that their client's legal rights are attacked, that attorney's whole job, the reason they have a job, the reason they are paid by their client, is to protect and uphold those rights. Usually, this is performed in the courtroom, but occasionally it must also be performed in the media. That's what Rule 3.6c is all about. An attorney cannot stand idly by while his client's legal rights are undermined and trampled upon by mischaracterizations of the evidence, by misrepresentations of the evidence, by misleading media reports. Instead, the attorney has the duty to protect his client's legal rights by correcting that misleading statement. Now, I've mentioned the misleading reports by the media, but I want to be clear, I don't place the blame on this for the media. These are reports the media has repeated from defense counsel's misleading statements. And I disagree wholeheartedly with defense counsel's statement that their statements in their pleading was not misleading, because it absolutely was. In defendant's motion to continue the preliminary hearing, the defendant stated this: the ATF was unable to identify the bullet recovered at autopsy to the rifle allegedly tied to Mr. Robinson. Okay, so let that sink in. That's the statement they included. The ATF was unable to identify the bullet recovered at autopsy to the rifle tied to Mr. Robinson. That statement is not inaccurate. That statement is accurate. They were unable to identify that bullet to that rifle, but it's incomplete. It's not the whole truth. And as a result, it's misleading. It actually has two material omissions. Material omission number one is that the ATF was unable to identify or exclude that bullet as having come from that rifle. Okay. And then defense counsel compounds the misleading nature of that statement by following it up with this: the defense may very well decide to offer the testimony of the ATF firearm analyst as exculpatory evidence. We all know what exculpatory means. That means evidence that proves he didn't do it, right? That's affirmative evidence that shows he didn't do it, right? That's the misleading nature of this statement, because it is not exculpatory evidence. If that omission, that material omission was included here, that the ATF was unable to identify or exclude the bullet, everyone would know that this is not exculpatory evidence. And that leads me to the second material omission, which is the analyst reported that the bullet was a 30 caliber class bullet jacket fragment. Okay, 30 caliber class. What does that tell you? Well, that excludes a whole bunch of weapons from possibly being the weapon in this case. And on the short list of weapons that are included is a 30-06, right? The weapon that was found at the scene. The reason that omission is material is because it shows that this evidence is not in fact exculpatory. This report and the testimony from this analyst will be inculpatory, because on the short list, from that bullet came from a weapon that is on the short list, which includes the weapon that was found at the scene. That's inculpatory evidence. By no stretch of the imagination is the testimony of this witness exculpatory. Your Honor, that's a misleading statement. And it's not surprising that the media covered it and covered it the way they did, because any reasonable reading of those statements with those two material omissions leads to the conclusion which the media drew, which is that the bullet does not match the gun. This is exculpatory evidence. That's what the defense claims. Under no stretch of the imagination could this witness be exculpatory. The result of the analysis substantially narrowed the class of weapons that could have fired the fatal bullet, and the defendant's rifle was on the short list. That's the truth. Now, the media ran the story, and it gathered extraordinary attention. I've noticed that the monitors are turned off. Are we still on the record? Okay, thank you. The Daily Mail ran a story garnering 22 million views on X in a single day. And the headline was, "The bullet used to kill Charlie Kirk did not match the rifle allegedly used by Tyler Robinson." Okay, the bullet did not match. Major networks throughout the country and even throughout the world picked up this story and echoed this statement that came from defense counsel's pleading. I don't lay that blame on the media. That's accurate reporting of what the pleadings stated and a reasonable inference. But they echoed that misrepresentation, that misleading news. Major news networks reported that this ATF report exonerated Robinson, that the prosecution's case had fallen apart. There were quippy headlines like, "If the bullet doesn't fit, you must acquit." And that, of course, reached Utah, reached Utah County, where our jury pool resides. The Deseret News, a Utah agency, had a story entitled, "How One Headline Shaped the Narrative in the Tyler Robinson Case." I mentioned these to tell you, I'm not over-exaggerating. I'm not overstating the breadth of the media coverage here and the risk of prejudicing a client's legal rights and the right to a fair trial. So what does an attorney do? You see this happen to your client. Your client's case the evidence is being mischaracterized, misrepresented. We all know it because we know what that report actually says. We have the report in our hands. It's actually public information, but now the media is relaying the same information, mischaracterized by defense counsel, and prejudicing your client's right. What do you do? Well, you do what Mr. Ballard did. He looked at the rule, looked at Rule 3.6, subsection C, and it states, "A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client." That's the law. Let's go through it and apply it. A lawyer may make a statement, which Mr. Ballard did, that a reasonable lawyer would believe is required to protect a client from the substantial, undue prejudicial effect of recent publicity. Is there substantial publicity here? Yes. 22 million views in a day. We've covered that. Undue prejudicial effect. Is it undue prejudicial effect? Yes, it is, because it's a mischaracterization of the evidence. The report does not say that the bullet did not come from that gun, which is what the media was stating, right? That's undue prejudice. It's unfair and it's not accurate. And that is recent publicity. Not initiated by the lawyer or the lawyer's client. Mr. Ballard didn't start this, right? The state didn't start this. This began because of a pleading the defense counsel filed in the court, right? And the rules don't require that defense counsel, in order for an attorney to respond, it doesn't require that the opposing party make the prejudicial statement to the media. All that's required is that the media is making some prejudicial statement that's reaching your jury pool and prejudicing your client's rights. So Rule 3.6 is directly on point. It allows an attorney to make statements to correct this misleading material, to correct the facts. And I would say it's not only permitted, but it's a duty to respond.
You did
As an
say
attorney,
that.
you have a duty to watch out for your client's interests. Zealous advocacy is enshrined throughout the rules of professional practice. Comment 1 to Rule 1.3 states, a lawyer must act with commitment and dedication to the interests of the client and with zeal in advocacy on the client's behalf. When your client is being unfairly attacked, when their legal rights are being undermined, you as an attorney don't have the luxury of sitting there and watching it happen. You have a duty to stand up and represent your client. Again, usually that happens in the courtroom, but occasionally, like Rule 3.6 says, you have to do it in the media too to protect your client's interests. And Mr. Ballard performed that duty by making a statement that accurately characterized the evidence. He had the report in front of him, and he told the media in these interviews exactly what that report said, which is how defense counsel actually characterized it today, unlike their motion, which is that this was an inconclusive report. He characterized the evidence as the test characterized the evidence, that it was inconclusive. There was not sufficient material to compare with test-fired rounds to either draw the conclusion that it was included or excluded as having been fired from that rifle. The bullet was either included or excluded. The evidence didn't have adequate characteristics to make that comparison.
No, that's not right. It was
That was an
included.
accurate statement in the evidence. But to show that Mr. Ballard was circumspect in his response and was abiding by his ethical rules, he did not go a step further. He could have, but he did not go a step further to explain the inculpatory nature of that report. Right? What he did is he corrected the misrepresentation the defense counsel had in their pleading. He said, nope, that's not what the report means. It does not mean the bullet did not come from the gun. It means that this is an inconclusive finding. He could have gone a step further and included the other fact defense counsel omitted, which is, but the report shows this bullet is a .30 caliber class bullet, which is consistent with having been fired from the rifle found on the scene. He didn't say that. He could have, but he didn't. Why not? Well, because he's being circumspect. He's abiding by his ethical duty. He's not putting forward additional evidence that proves guilt. He's just correcting the misinformation that was out there.
Well, let me stop you right there. You use the word zealously, but isn't that referring to defense attorneys to advocate for their clients? And under the rules, user prosecutors are to act as ministers of justice. Is there a different standard?
I would say there's a greater standard of zealousy for prosecutors than any other attorney, to be honest, because their duty is to the truth, right? Not just to represent the interest of a client, whether that's a criminal defendant or a business or a civil client, but they have a zealous duty to their client and to the truth even, right? And that's why if Mr. Ballard had come out and said, no, the report says it came from that gun and had some kind of misrepresentation, and he said, no, I'm being a zealous advocate right now because that's what I think is going to be shown in the long run, that would be a problem. But this was zealous advocacy and a commitment to the truth here. He was representing the true nature of that report, right? The duty of zealous advocacy does apply to attorneys for the state, but they are ministers of justice. And I think it means that their duty of zeal possibly even exceeds that of other attorneys. Certainly, they're not accepted from being zealous advocates. So he did. He made that statement, a statement that accurately characterized the evidence, corrected the misrepresentation, the misunderstanding, and the mischaracterization of the evidence. He stated the test was conclusive, and he did not go a step farther or further to then pile on and say, this is what the evidence actually shows, and talk about the inculpatory nature. Maybe you're right. As a zealous advocate, maybe he could have gone a step further, but he didn't. And I think that was balancing his duty as a prosecutor and a minister of justice against that duty of zealous advocacy. Now, his second statement was he is presumed innocent. That is a statement that the Rule 3.6 and the commentary in particular of Rule 3.6 talks about. You should say that when you're talking about that somebody has been charged with a crime. He is presumed innocent, he said. The ultimate decision will be up to the jury. Those are appropriate textbook examples of how a prosecutor should talk. He then made the following statement. We believe we will be able to overcome his presumption of innocence. We have ample evidence to demonstrate beyond a reasonable doubt that Tyler Robinson committed this murder. The defense has also criticized this statement as a statement of belief or opinion. This is not a statement of belief or opinion of guilt based on personal knowledge or experience. Instead, this is a statement tied to the evidence, which was directly relayed to rebut the mischaracterizations and the claims in the media that the state's case was falling apart, and this evidence was exonerating the defendant. This was offered in direct response to the claim that there was not adequate evidence, and the evidence that existed was exculpatory. Now, this was nothing more than the certification required by Rule 11 of Rules of Civil Procedure. When an attorney signs a pleading, the attorney is certifying that to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the claims are warranted by the existing law and the allegations and other factual contentions have evidentiary support. So the statement that we have the evidence to prove our case is nothing more than reaffirming and confirming that certification that we made when we filed this case with the court. To do otherwise would be unethical, to file a case that we don't believe is supported by the evidence. And this is nothing more than saying we believe that we have adequate evidence to move forward in this case. There's nothing wrong with that, and there's case law that says so, and we cited that in our brief. It's a statement tied to the evidence. Now, defense counsel has said, no, that's an opinion, and compared that with the Levitt decision. And I will tell you, there's nothing further apart than Mr. Ballard's statement and Mr. Levitt's statements.
I gotta agree
Mr. Ballard
with that.
says, based on the evidence, we believe we have the evidence to go forward. Mr. Levitt says, we have reviewed the evidence the jury will never hear.
Never hear.
And we believe this witness, in that case, the eyewitness to the murder. We believe this eyewitness based on evidence the jury will never hear. So Mr. Levitt asserted his personal belief in the credibility of a witness.
Yeah.
Right? That kind of statement would be inadmissible, would be a mistrial if that statement was made in opening statement or in closing argument, right? Mr. Ballard's statement, on the other hand, is we believe we have the evidence to prove the defendant's guilt. That's an appropriate statement in an opening statement or in a closing statement. And I should say, his statement was even more mundane than that because he said, we have the evidence. He didn't say we believe or I believe. He said, we have the evidence. And that's the type of statement that attorneys are trained to say in their opening and closing arguments rather than saying anything about beliefs. Regardless, the point is the same. This is not, I believe this witness. This is, we have the evidence, right? That's an appropriate statement. It would be appropriate for an attorney to make at trial. And it's an appropriate statement to reassure the public that that attorney is proceeding on good faith, that there is the evidence that supports the charges, and that this misrepresentation and mischaracterization of the evidence does not undermine the filing in this case, the filing of this case.
Well, let me ask you a question in regards to, you use the term inculpatory and exculpatory. Isn't that to the interpretation of the fact finder, whether something is or is not?
Yeah.
Well,
because
ultimately,
it's
yes.
advocacy.
And I think right now that's you for the purpose of this proceeding. But yes, ultimately it is. But I don't see how any person could say that the conclusion of the report that this round came from a 30 caliber class weapon, which a 30-06, the gun found at the scene, is. I don't see how anyone could say that's exculpatory.
Because you weren't
You
able
say
to match
that
it.
round is consistent from coming from that gun.
Well,
They
that's
weren't
your
able to match it.
interpretation. You're saying I can't see, but do we need to be cautious in putting ourselves in place of the fact finder or making an interpretation of what the fact finder should assume it to be?
Well, of course, we need to be cautious about that, Judge. But I mean, you're the fact finder in this case. My money is you're going to say that's inculpatory evidence. I mean, because exculpatory evidence would say this bullet could not have come from that gun, right? That's exculpatory evidence. And that's what defense counsel claimed it was, exculpatory evidence. it's a logical impossibility for that to be exculpatory evidence. I don't think there's a reasonable way to interpret
able to
the
match
evidence
it.
to say that's exculpatory.
Very
This
straightforward.
bullet is consistent
weren't
with
able to
coming
match
from
it.
that gun. That's inculpatory evidence. I can't wrap my head around a rationale that would
Because
find
you're too much of a
otherwise.
prosecutor.
I don't know if defense counsel wants to make an argument afterwards, but I can't see it
I'm
logically.
sure they will.
I can't see it. The test was inconclusive. The bullet came from a 30 caliber class weapon. The weapon found on scene is a 30 caliber class weapon. Defense counsel has said, well, the state's only avenue, or the state's appropriate avenue, I think they're actually saying the state's only avenue from response to the statement, what I'm saying is a mischaracterization of the evidence in defense counsel's pleading. They say the only appropriate response is to respond in pleadings or contact defense counsel. That's all fine. But when it comes to responding in the pleadings, this was a motion to continue the preliminary hearing. The ATF report wasn't even mentioned in oral argument. When I responded to that pleading, I thought that's a non-starter. That's an issue that's ancillary to the core issue of this motion to continue, which was discovery of DNA evidence and underlying DNA data, right? So when I'm responding to their motion, I'm going to pick and choose what arguments are going to carry weight, and I believe will carry weight with Your Honor. I'm not going to address every single argument that's out there, and that's not, and beyond that, responding in the pleadings does nothing to correct this media frenzy that's happening out there that's just echoing this mischaracterization of the evidence, right? It just doesn't. My office is getting calls from the media after they read this. You know, they run the story, it gets 22 million views. All the media says, wow, this is getting a ton of publicity. Let's jump on board. They start covering this.
Like a
They
lack
call our
of
office.
patience problem.
And as an attorney with a duty to your client, do you just say, nope, I'm going to let the media run with this and continue to mischaracterize the evidence in the case? I don't think you can do that. I think that violates your duty to your client. I think you have to be careful in what you say, of course. But responding in the pleading doesn't protect your client and doesn't protect the jury pool from unfair and undue prejudice, which is what Rule 3.6 directly addresses, 3.6c. And that's what happened here. The rule allows response to media coverage, and filing a pleading does nothing regarding the prejudicial media coverage in this case. I will tell you, this motion has caused the state to closely review and to revise the way it interacts with the media. From the outset, defense counsel is right. We knew the rule from the outset, Rule 3.6. The day defendant was arrested, we sent letters to law enforcement agencies within the state and federal agencies as well, asking them, hey, you've got to abide by these rules and outlining what those rules are, including the comments to Rule 3.6. We're very aware of that. We're very cognizant of that. And that's actually why we had the response we did, is because we looked at Rule 3.6. I'm assuming that's what Mr. Ballard did. He looked at Rule 3.6c and said, look, this allows me to respond. And he did. He responded as the rule allows. Your Honor, we are committed to, as we stated at the outset of this case, to abiding by the rules. We are committed to ensuring the defendant gets a fair trial. But we're also committed to ensuring that our client, the state of Utah, gets a fair trial. And when we see our clients' rights being trampled and the right to fair trial being potentially undermined, we are going to fulfill our duty to zealously represent our client. If that means correcting the statement in the media, and if that's the only way to do it, I think that that's appropriate and that's allowed under the rules. I will say that we are very cautious, and we will be more cautious in the future. In summary, Your Honor, given the state of the law, given what has happened in this case, given the state of the media and the context of the statements, and given the statements that defense has alleged here, the defense has not shown enough evidence to have additional proceedings in this case. The statement is soundly and squarely within Rule 3.6c. The statement falls within what is allowed by the case law that I cited, a statement that we believe we have the evidence to move forward with the case is appropriate under Rule 11, as well as the case law that was cited in the pleading. For that reason, Your Honor, I'd ask you to deny the motion for the order to show cause. The point is well taken, and we are, as I said, have revised the way we are addressing the media, and we intend to avoid anything that could be construed as violating the court's order in the future.
All right, just a question
That's not going to be possible.
You stated earlier that if an order to show cause, and I'm summarizing, I'm not quoting you, the order to show cause was found at the sanction stage, discovery about communications may be warranted. What's your position on the request of defense for communications, internal communications should be requested or ordered to be produced?
Yeah, that's work product, Your Honor. The conversations that we have about any strategy is work product. I think there's an at-issue exception to the work product doctrine. I think the amendment to Rule 16 actually gets rid of all exceptions to the work product doctrine if you read the language of Rule 16. But I think that there's, if there is an exception, it would be the at-issue exception, which is, are the attorney's communications, internal work product communications, at issue in the allegation of misconduct. But I do think that, if there is a violation, that's the only way that those communications could be discoverable, would be after the fact, after a finding, and with regard to what sanctions should apply. Frankly, defense counsel hasn't shown any basis to believe that those are relevant, and that they haven't even shown they exist. And I think that they have that burden under Rule 16. But I would also say this: those are relevant to a separate issue, right? That they're not relevant to this case under Rule 16. There is no good cause for the discovery of that material under Rule 16, because Rule 16 deals with the defense's need in this case, the state versus Tyler Robinson, not defense versus the Utah County Attorney's Office.
Fairness of his trial
So
is
under
your
Rule
case.
16, they're not allowed. There's no good cause here. There's good cause to discover the statements that are in the media, but they already have those, right? Because that's what's at issue here, is defendant's rights. I don't know if that answers your question, Judge.
No, I appreciate that. And final question, same one that I asked to defense. If the court were to allow an evidentiary hearing, how much time would you anticipate the state would need? Obviously, there's variables, as the defense is the moving party, but how much time would you need?
Well, probably, time to cross-examine any witnesses they have. This is the unique situation defense is going to be in, as they, what are they talking about? They're going to call every attorney that represents the state in this case. They're going to call every news agency that did an interview with any state's counsel. They're going to, they could make this thing go on for weeks if they wanted to.
They can't. The court manages the calendar, and so theoretically,
if allowed to, I should say.
All right, thank you.
So, I would think that it would be probably Mr. Ballard probably be the only witness, and in that circumstance, we'd be talking 3 hours. Probably half a day would probably do. Again, I don't think the court would be, frankly, in much better position to render an opinion than it is now. What's important here are the statements that the media has reported, and defense has already mustered those. So I don't think there's a whole lot of additional discovery that would be needed, whether it's in the form of testimony or production materials.
Thank you, Mr. McBride.
Well, the willfulness
All right,
does matter.
Mr. Novak, I did state went over by 1 minute because of my question, so you have 7 minutes instead of 6.
Thank you, Aaron. I want to go back to this court's order dated September 16th of 2025, which says, lawyers who have participated, who are now participating, or who will yet participate in the investigation or litigation of this case in any way shall abide strictly by Rule 3.6 of the Utah Rules of Professional Conduct. Rule 3.6 prohibits a lawyer from making, quote, an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Close quote. This court did not give counsel leave to decide whether extrajudicial statements correcting what counsel has argued are media misinterpretations of pleadings are an appropriate exception. And so actually, what counsel's argument reminds me is that there was another option that the state had. The other option which the state had, which is probably this court's preferable option, would have been to say, Your Honor, we need to have a hearing. We need to have a hearing to find out if this court believes that when the media misinterprets the content of a pleading, we can go do media interviews and send emails correcting it. Your Honor, is that an exception to 3.6 that this court sanctions? And if the answer had been yes, then there would have been a judicially supervised crafting of that. My suspicion is the court would have said, no, 3.6 is intended to allow one party to make extrajudicial statements implicitly where another party has already done so, and we need to balance the playing field. Mr. Robinson's defense team, and I've said this before, has strictly adhered to the principle that we will have no contact with any media and we will not make any statements to any media entity of any type. And in the same way that Mr. Ballard apparently was getting this influx of media inquiries, so are we every day. And we never ever respond at all, because to do so would be a violation of 3.6 because there is no exception under the situation here. We did not say in our pleading that the ATF report concluded that there was not a match. That is not what it says. And of course, our pleadings speak for themselves. The massive media interest in this case is not an escape hatch on Rule 3.6. It doesn't matter how much media attention there is. It doesn't matter whether it's accurate or inaccurate, as long as it's not something generated by one of the parties. That's just what we are all dealing with in this case. And there is nothing that we have done in connection with the media that justifies what the state did here or excuses it. I'm going to talk briefly about views of exculpatory evidence. The state, as Your Honor knows, has a burden to prove a defendant's guilt beyond a reasonable doubt. The absence of evidence that a fact finder might find probative of guilt is itself exculpatory. So in a hypothetical case, there's no fingerprint evidence. The state doesn't offer any. That's exculpatory. In a hypothetical case,
It's weak,
there's no
but it is.
confession.
And that's a big part of
The
defense.
state can't offer it. That's exculpatory.
So where's the CSI stuff?
The absence of evidence is exculpatory. So the ATF's inability to match is exculpatory. The state can say that there are parts of that analysis which are inculpatory. That's fine, but it is for the finder of fact, and it is well established that the absence of evidence pointing at guilt is by definition exculpatory. And so what this court obviously has is two different views on what evidence is of what value. And a devoted, well-skilled prosecutor sees one piece of evidence one way, and a diligent defense attorney sees it the other way. And the question is, what do the people in the box think about inculpatory versus exculpatory? And finally, on this discovery question, Your Honor, counsel has made references to what Mr. Ballard may have done and may have thought about and may have considered. We don't have a declaration from Mr. Ballard. We don't have any testimony from anybody in this office about what led to this play, if I may, this media play. We have argument. And that's why this court needs to investigate. And this court can't allow the state to hide behind this notion that there's no good cause for disclosure under Rule 16A4. This is a classic situation where a well-founded, not frivolous, serious allegation of a violation of this court's order in a capital case requires looking behind the curtain as to what did and did not happen. This court cannot fulfill that obligation without knowing that. And this is the case. Counsel suggested that this is not the case. This is, Mr. Robinson versus Mr. Ballard. That's not what's going on here. This is a case about Mr. Robinson's constitutional rights, his presumption of innocence, and whether the violation of 3.6 requires various types of sanctions. That is this case. It's not a different case. Thank you.
Thank you, Mr. Novak. All right. Thank you to the parties. The court is going to take this decision under advisement, and as this court typically does, we'll schedule a future hearing to render its decision, and we can discuss it at the conclusion of today's hearing. At this time, we'll go ahead and take a 10-minute recess, and then we'll turn to the other matter. Court is in recess.
All right. Going 10-minute recess. Fix my banner here. Okay. Well, that was interesting. That was quite interesting. Now, guys, I'll tell you why I don't really have a clear one way or the other how I think this should go type of perspective on this hearing. And the reason why is because I'm so accustomed to seeing this issue from the other side. Okay, because the typical timeline of a criminal case means that what normally happens is, okay, you have a high profile crime like this and there's tons of press about it, and the police and the prosecutors, they're talking to the press, they're updating them about the course of the investigation, and then somebody gets arrested and you hear about it and you get little bits and tidbits about that, and you get the probable cause, and then the gag order comes down. And so all you have is the state's version of events out in the public, and then like as soon as defense counsel is on board, everybody has to shut up. And so my context for this issue as a whole is coming out of the situation where it's the defense whose right to respond is kind of typically being impaired. And one of the classic examples of that for me is the Richard Allen case, where like for years, all you had was hearing from law enforcement and hearing from investigators and interviews that are being done and requesting tips and all this stuff. And then you finally have this arrest. And then it's like defense has to shut up. And the very fact that they went out and issued a press release to say, client is innocent, didn't do it, there's going to be a lot of problems with the evidence, so on and so forth. He's the guy who's been working at the public facing job at the pharmacy right across the street from the sheriff's department for 5 years since the crime took place. Nobody ever identified him. Nobody ever was like, oh, he looks like that bridge guy person. They got in the shit because they exercised the right to respond. And so that's why I struggle with this particular issue, because it's normally the defense that's getting penalized by it. But if it's a rule, it's supposed to apply to both sides. And that's why a lot of times these situations, they can just be awfully tricky, because it might seem really clear, okay, I don't like it in this context, but you have to think about it, how it's going to apply when the tables are turned. And so that's why I struggle with the issue with the right of response and how much of it there should be, because normally that's to the benefit of the defendant. If they have exculpatory evidence and information and so forth, it's to their benefit to correct the record publicly so that the jury pool isn't coming in for the selection process having only heard the 5 years worth of crap that has come from law enforcement. And thank God they finally got the guy. So, I mean, yeah, I struggle with that because it's there in the rule. It does say, and it doesn't say they only get to respond to things that the other party said. The rule says they get to respond to media or, extrajudicial statements or whatever that were not caused by that particular party. And I don't think there's an argument that the state caused this. To misinterpretation. Now, okay, where are there good arguments? Did they stay close enough to the line? Did they do it in the appropriate way? Probably, I can absolutely see this judge buying into the idea that he should be involved in crafting the response, or that that it should be collaborative. It should be a collaborative and cooperative thing. Just overall, that's such the vibe in this court anyway. That's so different than so many cases that we watch. And I have to say, this is something I've been thinking about. I've seen a few comments go through the chat. I don't know how much other people are thinking about or aware of, or just any how Mormon this courtroom is. Okay, we're in Provo, Utah, arguably one of the most Mormon places on the planet. And I mean mainstream. I don't mean the little fundamentalist communities, that take over a small town down by the Arizona border. I mean mainstream Mormon. Provo is 85-90%. They run the town, they're going to run everything there. This is a Mormon community. These people are all going to be Mormon. And that does kind of mean something to me, just in terms of how Mormons behave to each other and to others and so forth. They're very, very nice, very polite, very community focused. We're all in this together. We're going to look out for our own. And they do look very, very, very good care. Mormons take extremely good care of their own people. But that to me is this is just one more aspect to me that it makes this particular courtroom unusual, is how nice and collaborative everybody is kind of being about everything. Even though we're having these disputes, there's not really that many of them. And they tend to carry a lot of disclaimers. I remember one of the arguments that we were having about the discovery and the state of discovery and the problems with getting things from the feds, and Mr. Novak's explaining the 2E process to the court and all that. And I remember very specifically Mr. Novak wanting to disclaim, I want to be real clear, the problem isn't these prosecutors right here. Okay, they're great. The problem is the federal partners. So I can see that being appealing to this particular judge, this idea that it should be a collaborative process if there's a problem to identify it and figure out how to respond it. But I, as a defense attorney, I don't like that at all, because if I want to respond, I don't want the judge telling me how I get to respond or don't respond. I'm the one with the duty to my client. He doesn't have a duty to my client to zealously represent. So he's not going to see the case the way that I do. And that's just part of being professionals. Giving each other the respect that you show other professionals is that you expect them to handle things professionally. And then if they don't, okay, we can take issue with it. That's the struggle. That's the struggle. I don't want him to say, no, there's no right to respond, because I want defense lawyers to always have the right to respond. At the same time, do I love everything about what these prosecutors did? Definitely not. I don't love it. I don't think they were fundamentally wrong when it came to the ATF stuff. But I also think you just got to be really super careful if you're going to cross that line, that you stay inside the line. You can't color outside the lines with this stuff. And if you're not using, doing the disclaimer correctly, he's entitled to his presumption of innocence. This is merely an accusation. We have the burden to prove it beyond a reasonable doubt. I don't like this idea that can just be accomplished implicitly, I don't love that. I definitely don't love the whole there's going to be more ATF testing that's, implicitly going to bolster our case. These to me are not okay. So that's sort of where I'm sitting on it. There is a right to respond. It's there in the rule. Okay. They literally put it in the rule for a reason. If you didn't have a right to respond, they wouldn't put it in the rule. But it's there. And so since it's there, it does have to mean something. I think my issue is really just whether they fell squarely within the line there or not. But we did get a little bit of a interesting role reversal today, didn't we? Because the defense is saying, look, if there's all this misinformation to correct, you can just put it in a filing. Just put it in a defense filing. Put it in a pleading. So where's all your defense pleadings correcting all of the public misinformation? Where have you countered, the probable cause affidavit and so forth? Well, so our discovery update today, I'll just kind of recap a little bit where we were at, but our discovery update was a little bit less fulsome than some of them have been. But we get the update that everything that the state has, they have now turned over. But there is some additional stuff that will be probably turned over this afternoon. Ms. Nestor then clarified, obviously, that just means what they receive, not everything that's in the universe that's potentially discoverable. Nobody really knows how much is still out there. That's kind of always the problem. You don't know what you don't have. And, to some extent, the prosecutor shares that as well. They just have a greater duty to figure it out. But also, getting the numbers, 2,462 more files have been produced. 2,300 of those are residential surveillance cameras. The rest is ATF and FBI information, but still not the DNA data. Last time it seemed like they were saying the ATF DNA data had been produced. Now it's very unclear. They're being rather vague with what's there and what isn't, but seems like at the very least the FBI DNA data, they are still waiting for. That's still outstanding, and that was after at the last hearing, we were told they're aware of it, that they're processing the request and it should be coming soon. But it seems that it has not been produced to the SBI, at least at this point in time. So You guys in the chat were once again giving hell to my man, Mr. Richard Novak. Okay, I know. Slovak, you guys are like not appreciating the leisurely style that a man accustomed to a federal court is going to use with his argument. But so bottom line for the defense is they kind of consider the fact of a violation to be a foregone conclusion. They didn't even really argue. They didn't spend any time really arguing. This is all. They just treated it as obvious. It's obvious that this is a violation, and so the question really is, what do we do about it, and should we get discovery about it, and how much and when? And I think he does have a point that certainly if it goes to sanctions, they need to know, because you need to know, yes, if you did this accidentally, then a sanction isn't going to necessarily deter you from doing it in the future. And we're in a civil contempt process. We're not like, nobody's going to jail for contempt of court. So what they're really focused on is what needs to be done to fix any immediate problem, and what needs to be done to ensure that there isn't a repetition in the future. And that matters, how bad it is. Did you do it on purpose versus you just accidentally, or you read something wrong, or, whatever your excuse is, that matters with respect to the sanction. But I think there's also a pretty good argument that it goes to the willfulness of the violation in the first place, because contempt, you're not in contempt of court if you accidentally violate the order. It has to be something deliberate that you've done. And so the extent to which they evaluated the order and the rule, and did research, and basically exercised good faith to try to stay cleanly within the lines, kind of matters to how willful it is. Because the court can always find, well, it's a violation, but they didn't do it willfully, so not going to do anything. Not going to do anything with a sanction about it. So the communications, I mean, obviously the state doesn't want to give those up. I wouldn't want to give those up. Either way, if I'm the defense side and they're saying we want your internal investigations before you went to the press,
Court is now in session.
better believe I'm going to be taking issue with that.
Give me just 1 second here.
So we're back, but not real clear yet what we're doing.
All right, let's next turn to the issue of the motion in limine to close those portions of the preliminary hearing testimony which would be inadmissible at trial, or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial, and sealing preliminary hearing exhibits which would not be admissible at trial, or which, if publicly disclosed prior to trial, may prejudice Mr. Robinson's constitutional rights to a fair trial. To each side, you'll have 60 minutes to present evidence and argument. If defense would like time for rebuttal, please plan accordingly. And as this is defense's motion, dissent and defense will proceed first. And turning to defense, Ms. Visser.
Thank you, Your Honor. I can tell you I am definitely not taking an hour here.
All right. Those are words that every judge wants to hear.
It's not the attorney 5 minutes, but it definitely won't be an hour.
All right. Thank you.
So yes, Your Honor, the two issues before the court in this motion are the handling of the exhibits at the preliminary hearing and the motion to close the hearing itself, or portions of the hearing. I'm going to work backwards because I actually think the state and the defense are mostly on the same page about the exhibits. It seems that the state does not intend to offer the exhibits in such a way that they will be viewable by the gallery. That was our primary concern with the exhibits during the hearing, and making those publishable online through the live stream or recording. That issue is not before the court at this point. I don't believe there has been a request for electronic media coverage. We do anticipate that that will happen.
Yeah, there will be.
But that was our primary concern about the exhibits. and how they are kept in the record if they are kept in the record. I know that standard protocol is that they are withdrawn after the preliminary hearing. That's what I anticipate to happen here. However, if for some reason they need to remain in the record, we have provided a detailed table to the court of what is already categorized under the rules of judicial administration as private, protected, and safeguarded. And we're asking the court to ensure that the records are held that way if the state desires to keep them in the record for any reason. We don't believe there is any reason for that. If there is post-preliminary hearing litigation where we need to reference exhibits, we'll handle that at that time in the appropriate way, make sure they're classified according to the rules.
Okay.
So I think that actually addresses that concern. The other concern, of course, is closing the preliminary hearing, which is a little bit more nuanced and is tied in some ways to the other motion that is not fully briefed yet about the use of reliable hearsay in a preliminary hearing in a capital case. I'm going to try very hard not to delve into any of that. I know that the state still needs an opportunity to respond. Going to the two factors from Kearns, I'll address those. The first is the evidence relevant to the nature and extent of the adverse publicity that may be generated from providing evidence in an open setting in a preliminary hearing. Now, we've overwhelmed the court, I will say, with the adverse publicity in this case. We had a whole hearing about it. We submitted lengthy briefing, lengthy presentations, copies of all of the videos. So this court, I think, has a very good idea of some of the media that is being generated around this case. I also think that the argument that we just had demonstrates how sometimes the media can misconstrue the evidence in one way or another, and that can get into the jury pool. So our goal here is to prevent that from happening by avoiding publication of evidence before there has been admissibility determinations. There will be litigation about the admissibility of a lot of this evidence. There are chain of custody issues that will have to be addressed that are not appropriate for the prelim. There is 702 and Daubert issues that will be addressed as far as expert reports and testimony. And most of the preliminary hearing, as far as we can tell, is going to be based off of reliable hearsay. They're calling 5 officers to discuss a very extensive investigation, basically throughout the state of Utah. The reports are lengthy and contain lots of statements from other officers and people that collected evidence and people that talked to witnesses. And unfortunately, we're not in a very good position right now to know what of that testimony is going to be based on personal knowledge versus reliable hearsay from other officers as defined by the rule. So our solution, what we see, is closing the preliminary hearing, and this court thereafter providing a transcript of what occurred during the preliminary hearing that can account for all of the evidence that wouldn't be admissible at trial. That's the solution that we're proposing here. That's the only way we see that we can protect our clients' right to a fair trial and avoid evidence getting out that potentially is going to be challenged in the future and may not ultimately be used or admissible at trial. So that also addresses the second Kearns factor. I also wanted to note, just for the court's understanding, when we talk about Kearns and we talk about Archuleta, both of these cases happened at a different time, before the use of reliable hearsay was allowed by the Utah Constitution in the way that it is now. So when we're talking about those cases and their discussions of prejudice and what open and closed looks like under those circumstances, they were very different. There were more witnesses testifying as to their facts as opposed to hearsay from other individuals. And there was more opportunity for cross-examination and the exercise of our client's right to confrontation. So now we're dealing with basically just a presentation of evidence from the state. And again, without any determination about admissibility at trial. So we are asking for that solution. We think the landscape of the evidence at this point versus those prior cases, while they are still, the guiding procedure for this court to follow, we believe the instances in this case, the circumstances of this case, the media presence in this case, and how the media has already, in some instances, taken information out of this court and misinterpreted it and facilitated misinformation about the case. We believe the only way to really prevent that is to control what's coming out of this courtroom. So that is why we're asking to close portions of the preliminary hearing if we can narrow it down. Honestly, I think that's a question only the state can answer, or the entirety of it, and we can pick through it after.
Well, so let me stop you right there. So in looking at Kearns, we have to align with the narrowly tailored, like simply saying closing the whole hearing. I don't think that would conform with narrowly tailored and saying, let's just close the whole thing and then pick it apart afterward. Wouldn't you agree that that's a bit broad? And that kind of, that's not the intent of the case law or the rules, that we get to just shut it all down and then figure out afterward. Or do you have a different interpretation?
Well, Your Honor, we've kind of talked about different solutions here, but the alternative is we essentially make objections as we go through the hearing, which will probably take quite a bit of time and extend the proceedings significantly.
You've got a week.
So if that's the preference, we can absolutely do that. I do think that it would interrupt the flow of the evidence and the presentation before the court to do it in that way. But if that's the preference, we're also open to that solution. But our concern, again, is that a bunch of inadmissible evidence is going to be presented without any sort of testing before it is presented and put out into the world to the jurors and biasing our clients' right to a fair trial. Does the court have any additional questions?
No.
Okay, thank you.
Thank you.
That was definitely less than an hour.
Mr. Grunander.
Thank you, Your Honor. The state has tried to make it abundantly clear throughout this process that we favor open hearings so that the public can trust what happens in this courtroom. And public confidence increases when people can see justice at work. So that's our general argument. This, in many respects, is largely the media's fight, Judge, but the state is interested in weighing in on these issues here. We've talked a little about the Kearns Tribune Court, and it's clear from that decision that the public, including the media, possesses a constitutional right to access preliminary hearings. And the overall question there as far as closure is there a realistic likelihood of prejudice to a defendant's right to a fair trial? That's the overall question. And then we get into the factors that the court should consider, which are, will the evidence shown during the preliminary hearing create such negative publicity that it's impossible to hold a fair trial because an impartial jury cannot be seated at some point in the future? And the second question is important. The second factor speaks to, are there feasible and effective tools available to this court to ensure a fair trial? And we've had extensive arguments about pretrial publicity in this case. We've talked about voir dire. We've talked about extensive jury questionnaires that can be used as well. And as it applies to here, we've talked about the idea of shielding the public from some of the exhibits that are going to be offered into evidence. So let me just kind of pivot to that. We do favor, Your Honor, we favor, Your Honor, denying access to the public and the media from physically handling the exhibits and copying the exhibits that are admitted during the preliminary hearing. And the reason for that is expressed in the Archuleta case. And the language there is that we believe that allowing the media or the public to physically inspect or copy these exhibits may disrupt the efficient performance of justice, hamper judicial interest, or jeopardize defendants' right to a fair trial. And that is because we have not yet tried the case. Those are likely exhibits. Many of the exhibits will be used at the trial at some point in the future. And having the media access those and try the case in the public, if you will, I don't think serves the administration of justice. So I think we concur with the defense with respect to that. Now, when it comes to the closure of the proceeding, that's where we differ, I think significantly, Judge. Because the public has a right to be present, including the media, as articulated in Archuleta, they have a right to report on all that occurs there. So there's a difference between the public being present for the hearing, observing the hearing, the media being present and reporting on the hearing, and having access to the actual exhibits. But there's real merit in the public being invited into this proceeding to watch how it plays out, to see the exhibits introduced into the evidence. They're allowed to listen to the arguments between the parties on the admissibility of it, the arguments at the close of the hearing on whether the state's met its burden to bind the defendant over for trial. And that's part of opening these proceedings, making them transparent so that the public can trust the process, what happens in this courtroom. If the court were to close the preliminary hearing, the court would necessarily be making the decision to limit electronic media coverage. So I think that Utah Code of Judicial Administration Rule 4-401.01 is in play. The court's going to have to undertake that analysis if the court is to close this hearing or even close portions of it. And there's a number of factors that the rule asks the court to consider, some or all of these factors. And some of them clearly stand for this idea that it should be opened. The media should be allowed to cover these proceedings. For example, the adequacy of the court's facilities for electronic media coverage. Check, that one is satisfied. The public interest in and newsworthiness of the proceeding. We all know the newsworthiness of these proceedings. The potential benefits of allowing public observation of the proceeding through electronic media coverage. Again, we think that opening these proceedings creates confidence in the system. Questions of whether there is a reasonable likelihood that electronic media will jeopardize the safety or well-being of any individual. I don't think that's in play here. Whether there is a reasonable likelihood that electronic media coverage will jeopardize the interests or well-being of a minor. I don't think that's in play. Whether there is a reasonable likelihood that electronic media coverage will constitute an unwarranted invasion of personal privacy of any person. Again, I don't really think that's in play here, Judge. So I don't think that the presumption that the media can be present and report on these proceedings has been overcome under that rule. Reliable hearsay. Judge, reliable hearsay is a staple of preliminary hearings. It's important that we all recognize that this is a probable cause hearing, akin to a grand jury in many respects. Does the state have enough evidence to move this case forward to trial, forward to 702 hearings and different challenges on the evidence? And so that's why reliable hearsay is allowed.
Well, Mr. Grunander, and I know that this is a subject of the other motion, and so I want to,
sure.
Both sides will have ample time to argue that, and I don't mean to interrupt you, but just that's being reserved for a different hearing. And again, don't mean to interrupt your flow, but we're not, that's a decision for a different day.
Fair enough. I'll pivot to my main point in bringing up Rule 1102, Judge. Okay. And that is that if this court were to close the preliminary hearing or even portions of the preliminary hearing because of using reliable hearsay, that would essentially swallow the rule, swallow the constitutional rights that the public has to be here and to witness these proceedings. So I just think that that's an absurd result, Judge, that a procedural rule that allows for evidence to come in would negate the constitutional rights of others. So that's my primary point with respect to this motion, Judge.
It's a fair point.
It's also, and I make this point in our written pleading, but the practical effects of introducing evidence at a preliminary hearing is different than that of trial. We oftentimes don't publish the exhibits like we would at trial to a jury, where it's broadcast up on a screen for the jury and the public to see. Many of the exhibits that will be introduced at this preliminary hearing through 1102 are like an autopsy report that would not be published. Lab reports would not be published. Written 1102 statements that the court will receive will not be published. And so this idea of prejudice is mitigated for that reason alone. And then on top of that, of course, we would ask the court to essentially seal those exhibits and not allow the public and the media in the future to inspect them and make copies of them. But again, I believe the public, well, the law is that the public has a right to be present, to observe the proceedings, hear what's going on, watch the arguments, etc. And while some of the specifics of those lab reports, for example, will likely come up in argument, perhaps on maybe the admissibility of it, if objections are raised, or certainly at the end of the hearing when arguing bind over. There's a difference between being present in the courtroom and hearing those arguments and hearing references and even partial quotes of that evidence versus examining physically and copying those exhibits.
Yeah, one is
having those
selective and incomplete, which you just said could be misleading.
So again, I'm going to defer. The media is present. It's my understanding that they want to be heard on this motion. This is largely their fight. But again, the state wants to give the public the opportunity to critique these proceedings and to have confidence in what's happening in this court. And I'll submit it on that, Judge.
Well, I do have a question for you, Mr. Gernander. Being that it is the state's burden to present the evidence at the preliminary hearing, do you anticipate any of the evidence being presented that would require a closed portion of the hearing? And if so, what mechanism do you anticipate or you would advocate for to ensure that it's handled appropriately?
Judge, I don't anticipate testimony that would require closure for it to be admitted at the preliminary hearing. Again, there are going to be exhibits presented. For example, we have 2 videos. We have 5 officers that are subpoenaed to testify. With respect to 1102, we expect to rely heavily on 1102 in presenting our evidence. But these are officers who will testify to personal observations from other officers. They will also provide some foundation for exhibits that will come in. We do have one video recorded 1102 statement from Lance Twiggs. But I don't believe there's any reason to close that portion of the preliminary hearing. And Your Honor, we have provided Your Honor with the physical copies of those exhibits, and the electronic copies are on a thumb drive, which has been provided to the court for your review as well.
Well, just to be clear, I actually had the exhibits returned because I wanted to wait till the prelim to look at the exhibits, and I haven't. And a lot of what's been proposed as potential evidence, the court has explicitly not viewed, even if it's in the public sphere, just so the court can go in with a clear mind. So I appreciate that, but I just want to put on the record, I did note that folder and I appreciate that preparation, but the court has not, and it will not review it until the prelim to ensure that, you know, as a magistrate, I want to make sure that I go in only considering what's been properly admitted, and not to say you wouldn't properly admit it, but I just want to go in with that clear mind and only considering what has been admitted into evidence.
Okay. Should the court change its mind and wants to view it beforehand to make a
Sure.
determination, that information and evidence is available.
I appreciate that. Thank you.
There are 2 videos as well to answer Your Honor's question. There are 2 videos which depict the killing of Mr. Charlie Kirk that were taken by people that were present at the event. Those are sensitive in nature.
Mm-hmm.
You're watching the death of another individual, the violent killing of him. I wouldn't describe them as horrific. It's not a torture killing, as was described in the Archuleta case, but that material is sensitive. And so if that is received by the court, it would need to be published, at least to Your Honor.
Sure.
And if it's in an open court proceeding, the monitors could be turned away from the public's view so that that's not viewed, for example. But I don't believe that the hearing needs to be closed, or there's even portions of the hearing that really needs to be closed. Again, I think there's a middle ground here where the public and the media can be shielded from some of the sensitive stuff, but it doesn't need closure.
Thank you. Thank you, Mr. Gernander. All right, to Ms. Visser.
Media.
Or, well, to the media, and then we'll
Thank you,
return to
Judge.
Ms. Visser. Counsel?
Thank you, Your Honor. The court has a challenging task when it comes to requests to close portions of a hearing. The court knows the distinction that's been drawn. The court ruled on the motion to exclude cameras. It made note of the fact that we were at that time in a bit of a different world. At that point, we were not talking about a constitutional right to access. In this case, we're back in that world where we are, right? Where the public has a constitutional right to access court proceedings and court documents. When we were talking about the question as to whether or not the public would be present for the cameras motion before, the state said something in its briefing, and it said different hearings operate different ways. And with respect to certain hearings, we're not sure where it falls on the spectrum, how strong the recognized constitutional right of access is for that hearing. Preliminary hearings are one of the small categories of hearings in Utah and nationwide that are expressly recognized as set apart. You know, it's criminal trials, and then what comes next is preliminary hearings. And there's a reason for that. The lead case that the court has seen and will see more of is Press Enterprise. That's a U.S. Supreme Court case, 478 U.S. 1.
Well, that was suppression.
In that case, the court was remarking on a 41-day preliminary hearing that had taken place in California, and wanted to make sure that the public had access to that, in that case, to the transcript of it. And so the reason is that preliminary hearings are often the sole occasion for public observation of the criminal justice system. In a lot of cases, that's as far as it goes. That's all the public may have the right to see. And stripped of the opportunity to participate and watch that, the public may get no insight at all. Recognize in that case something that this court has recognized, that access into a preliminary hearing and to other court proceedings enhances both the basic fairness of the criminal trial and the appearance of fairness, so essential to public confidence in the system. We aren't relying on a U.S. Supreme Court case alone, as the court knows. In Kearns Tribune, this has been brought into Utah. And we were told something similar. In addition to kindling public misperception and eroding public confidence, closure of significant pretrial proceedings, like a preliminary hearing, perpetuates general ignorance and cuts off public knowledge necessary to a full understanding of the criminal justice system. It's really important that the public be allowed to access proceedings like this one. We've heard the parties reference, the defense reference at least a little bit, part 2 of a Kearns Tribune test. The idea here is that when you are seeking a departure from a recognized constitutional right of access, the party who's seeking closure, in this case the defense, needs to come forward with specific evidence about the thing that they're asking to seal and or close, and what the interest is that would justify that departure from the constitutional norm. As the court certainly recognizes, if there is going to be some sort of closure, the court has to go say in a written finding, here's why I am closing this piece off. It's why this wait and see approach, let's just get to the morning of the preliminary hearing and make this decision, won't work. How at that time would the court be able to say, I'm going to go make a written closure finding, balancing these interests, if you're asking me to do it on the fly? means we need to do it now. And that's why this idea of listing every line of testimony, every bit of witness time on the stand, every potential exhibit, and saying, let's seal and close all of it for 5, 6, 7, 8 different reasons, makes for a real mess, right? It makes a real challenge to say, so to be clear, you want me across 34 exhibits and 8 potential objections to make written findings that justify each one of those. I can imagine a world, and I know the court can too, when there is an exhibit, a portion of a bit of testimony, where it may be truly unique and special enough that the court would then need to hear a specific argument. But the burden to do that is on the party seeking closure because of the constitutional rights at issue here. In order to do that, the party seeking closure needs to have evidence of 2 types. One, evidence relevant to the nature and extent of adverse publicity that may be generated by the open pretrial proceeding. So I need to come show you what it is that's so problematic about it. And then, as the court recognized, specific evidence relating to the availability, feasibility, and efficacy of alternative means of selecting jurors and conducting the trial to assure the integrity and impartiality of the jury. That's from page 523 of Kearns Tribune. You need to show up with both those types of evidence. The court knows what the normal alternatives are because the court has thought through those and mentioned those in its ruling before. If there is evidence, as it should and as it can under our system, that becomes public during these pretrial proceedings, you hear a witness testify about something, you hear about a piece of evidence that's introduced. The expectation is that to the extent that that has some potential prejudicial power, you deal with that through these normal tools of jury selection, an expanded voir dire, detailed jury questionnaires, things of that sort. You mentioned in our briefing what you often see in Utah cases is they say by the time you get to trial, parties may, potential jurors may say, I remember hearing something about this case, but I no longer recall any details, right? And I certainly feel comfortable being able to set aside any prior knowledge that I had and focus solely what is in front of me at this case. That's the preferred narrowed means. So in order to justify a sealing, a party seeking that sealing or that closure needs to come and say why that isn't enough. Why for this specific piece of evidence, why for this specific stretch, that won't work. Again, I can imagine a world in which a showing like that is made, but we are nowhere close to that as far as granularity, as far as satisfying that burden, as far as with specificity here. I do want to mention briefly Archuleta. Both sides have talked about this different type of request, right? I want to stress that in most cases, and in this instance, what the media is asking for is essentially occupy the role that a member of the public would occupy if they were sitting in this courtroom. So if things are said out loud or presented to the court in order to justify or try to meet the burden of a preliminary hearing, the press, acting as a proxy for the public, would have the opportunity to watch, listen, consider, and report on that. The court knows that if a member of the public, as much as we appreciate them being here, said a preliminary hearing, that piece of evidence up there on the stand looks interesting to me, can I come up and hold it? The court would say, no, we're trying to preserve the integrity of this proceeding. And so you can listen to what you're seeing in the courtroom, but you can't come touch it or copy it or take it home with you, right? That's what was at issue in Archuleta. There were some pieces of physical evidence that there had been a request by the media to actually handle, inspect, copy. And in that court, the court said, well, we'll treat that differently. We think there's some different considerations at issue when you are asking to physically handle exhibits. Nothing like that is at issue here. The press has not in its briefing and does not here today seek to be able to do that type of hands-on examination of evidence or copying that was at issue in Archuleta. What the press is asking for here is what the press so often asks for, which is we are a proxy. We are here to help assist, to be the eyes of the public, to help them observe those sorts of things. So for that reason, the language in Archuleta that says there's no constitutional right to access the exhibits in that way is simply not in play. It's simply not before the court. And the court does not need to reach that question of what if somebody asked to hold or copy one of the exhibits that's being introduced at this preliminary hearing, because no such request has been made here. I know that there's been a lot of hypothesizing about what will happen with these exhibits, a lot of exhibit-specific arguments about Rule 4, 202, and various subcategories of private or protected justifications. I don't want to get in the weeds here. You could go through exhibit by exhibit, argument by argument. But what I want to stress, though, is that I think that the cleanest path and the only path that the court is really equipped to be able to take at this point is to be able to say, listen, what is presented in that hearing, absent any sort of narrow showing of closing or sealing a specific moment, should be open. The press should be able to see what a member of the public would be invited to come in and see on that day. And that would be discussion of these exhibits and being able to hear the testimony. The fact that some of this information may eventually be inadmissible does not constitute a link to showing reasonable likelihood of prejudice at trial that would deprive a defendant of a fair trial right. The party cannot simply say it's possible that at a preliminary hearing, some evidence that is eventually deemed inadmissible may be presented. As the state pointed out, that would be true in every case. That can't be used as a basis for closing or sealing a hearing.
We also dealt with that in Press Enterprise.
The stakes here are high. Kearns Tribune says it bluntly. Democracy blooms where the public is informed and stagnates where secrecy prevails. Closing these proceedings to the public will not improve the efficacy of these proceedings. In the Press Enterprise case, they went 41 days in order to make sure the presentation was done appropriately. No, the court has no intention of using 41 days in this case, but saying it might slow things down if we had to be careful every time we close the proceedings is not a justification to close the entire proceedings. It might slow things down. It may force parties to, on occasion, say, let's talk about this specific piece of evidence. But because that's hard, doesn't justify saying, let's close the entire thing. The court has correctly not taken that path in the past, should not take that path now. Thank you for hearing us, as always, Your Honor.
Thank you. Ms. Visser.
Thank you, Your Honor. I just want to address a few things. First, I would propose that there could be a solution whereby we have portions that are closed, like preemptively closed, and portions that are preemptively open if necessary. I just also want to caution the concern about admitting some of these exhibits that are protected, private, safeguarded, and the testimony that may accompany those being admitted. It sounds to me like the state doesn't intend to essentially do an end run around those classifications and have people describe those or read those out loud, and that would be our preference as well, because those are classified as private, protected, and safeguarded. So we would ask for that solution to be implemented as well.
And to that, just as you're talking about that, I'm just kind of thinking out loud. And I always encourage parties to see if there's any stipulations to exhibits. You know, for jury trials, I always encourage the parties to get together and to see. And I'm not saying you need to, but perhaps that could be something that would help resolve some of these issues. If there is that removes the need to go into detail or even to go into what could be problematic foundation laying again. But I'll leave that to the parties. The court is not intending to insert itself in those conversations.
No, that's a good suggestion, Your Honor, and we're definitely open to having those conversations in anticipation of the prelim to make things simple and move quickly, for sure.
Okay.
As far as the Rule 4-401.01, the electronic media coverage, I just want to reiterate that issue is not before the court right now. There may come a time when we need to address that when the media files their request, as they inevitably will. This court made a detailed order about how we are to address that, and so we'll address that at that time. I don't think it's a basis for this court to deny our motion for closure. It is a very different issue, right? Whether or not the media are allowed in the courtroom versus filming and live streaming is very different. So we did not go through those factors. Potentially we will in the future. So, Your Honor, we are asking for some reasonable solutions to prevent information being out in the public from the preliminary hearing that likely will not be admissible at trial, hearsay from other officers, is obviously not going to be admissible at trial. Those individuals will have to testify. 1102 statements, clearly not admissible at trial. Those individuals will have to appear. We will have the right to confront them, cross-examine them. So we're asking the court to take measures to ensure that that information is not published from the preliminary hearing. That is our primary concern with the motion to close. So we are asking for that. Thank you, Your Honor.
Thank you. All right. All right, thank you to the parties. I appreciate the argument and briefing that was done. Acknowledge your hard work and diligence. The court will take both matters under advisement and issue a ruling on WebEx. And counsel, I want to check with you. I have, I anticipate approximately 30 minutes as I've done in the past in either a morning or afternoon setting on June 1st. Is there a preference of the parties? Mr. Novak.
Only that I presently have a hearing scheduled for the afternoon, late in the afternoon of June 1st, California time.
All right. And first, is there, I mean, we've had a traditional way of doing this, but do the parties have any objection for my ruling to be on WebEx to accommodate all the parties?
Not for Mr. Robinson.
All right. And
First, the morning of June 1st would be preferred by the state.
all right. How about 10 a.m. on June 1st for a WebEx hearing? And again, I wish to be thorough to defense. What is your election as it relates to Mr. Robinson for that hearing?
Your Honor, if he could just be present with no video, just like in
Okay.
the past. Thank you, Your Honor.
All right. All right. Let me look to. All right. So I would like to set an in-person hearing for defense's motion to challenge the constitutionality of the Utah Rule of Evidence 1102, Utah Constitution, Article 1, Section 12. And if granted by the court, if I rule on June 1st for an evidentiary hearing, I would also like to hold that at the same time. Again, the court is not making its mind up. It's just indicating that if the court elects to hold that hearing, it would be on that same date. And we're looking at June 12th. And the availability of the parties.
Works for the state judge.
June 12th works.
All right. All right. And what I'm trying to do is address these issues prior to the preliminary hearing and allotting time to take the argument on consideration. The court intends to give serious thought and consideration to the motions and to the oral argument. So I'm trying to space it out so the court can do that and issue its ruling prior to the preliminary hearing. So for the June 12th, we'll start at 9 a.m. and we'll set aside the majority of the day. On the day of the hearing, I'll state the time constraints that we have, but as done today by counsel, I appreciate your succinct arguments. It is appreciated, and that reflects your experience and professionalism as well. With those two dates set, June 12th at 9 a.m. for the evidentiary hearing on the motion and potentially evidentiary hearing for the order to show cause, and ruling on June 1st, 2026 at 9 a.m. on WebEx for a ruling on today's proceedings. Do either party wish the benefit of the record at this point?
I'm sorry, you said 9 a.m. on the first? I thought the court said 10 a.m. on the first. Is that right?
I did. I wrote down 9 and I said 10. So it is 10 a.m. on June 1st.
Thank
Thank you for that
10 a.m. on June
clarification.
1st.
And on June 12th at 9 a.m. All right. And as it relates to June 12th, as it relates to Mr. Robinson, what is the request of defense?
We would ask for an order to transfer.
All right. All right. I'll go ahead and grant that. All right. Unless there's anything further, again, thank you to the parties for being present today. And the court will be in recess until June 1st at 10 a.m.
All right.
Okie doke. So we are left with coming back on June 1st for the ruling on his motion. So he will tell us at that time what's his position on closing the hearing and or sealing the exhibits. I will rant momentarily about the media not going to bat for us on the right to the exhibits. But so we'll get that ruling. And then also the order to show cause, whether he is going to require this order to show cause hearing where they will take evidence on whether Ballard is in contempt. And if so, what the appropriate remedy should be. That will be June 1st at 10 a.m. Then on June 12th, he is setting an evidentiary hearing on the motion that we did not argue today, which is the defense's argument that basically reliable hearsay, even though the Utah Constitution allows it and the Utah rules of evidence allow it, nevertheless, it violates the federal Constitution for that type of evidence to be used at a preliminary hearing. They're having that argument on June 12th. And then if he does grant the order to show cause and require an evidentiary hearing on contempt by the prosecuting attorney's office, it will also be June 12th. I think he's going to do it. We have sort of some tells from just how he said it. What if I did? How much time do you need, etc. I mean, it's obviously under consideration that it's appropriate. And I think if he was already kind of on the side of just looking at the statements themselves on their face, and they don't give rise to any concern about contempt, they're squarely within the rules, etc., then we wouldn't be considering having a hearing. It wouldn't be necessary. So I think there's enough gray area there that he's going to let them make the record. And that, of course, is just the other piece of it, the caution side of it. It is a capital case. You give the defendant the benefit of the doubt when it comes to being able to make his record of these different issues, so that you're doing it now and not 10 years down the road when some federal habeas court says you should have addressed this issue and you need to develop the factual record now. And of course, in the meantime, all the people are gone and the emails have been purged and so forth. So I think we're probably going to get the hearing on the order to show cause. But, we'll see. We'll see. So he'll tell us on June 1st, and then we will go forward with the additional hearings on June the 12th. Well, I was just kind of starting my recap of the whole day as we came back in for that second session. So I'll just go ahead and take up where I left off. We were just starting to go through the motion for the order to show cause regarding the contempt. And we were talking about how Mr. Novak has kind of treated the fact of the violation as a given. He's really arguing about whether we should, what's the process to follow from that. He's pointing to a statute that says that the judge, the court, has a duty to investigate whether there's contempt of court. I tried to pull up the statute he was looking at, but there's like several of them, and so I'm not entirely sure what he was getting at here. I think he said 306. No, 306 is bond. Yeah, there's like a lot of procedural stuff. Okay, it's this one. Let me go ahead and pull this up and I'll share it. Utah Code 78B -6-309. And this is the proceeding for contempt. If you're going to have a hearing, then this is what he's focusing on. The court shall proceed to investigate the charge, and the court can examine the witnesses and so forth. And so it's a process that's maybe a little different from what we're used to seeing in court, because the court itself is kind of treated as a party here. If the judge is asking questions and taking testimony and stuff like that, it's a little bit of a different context than we are normally accustomed to. And obviously, the prosecution isn't going to litigate itself, for being in contempt and so forth. So you end up in a little bit of an awkward situation. But so he's relying on this language to argue it's the court's duty to do that investigation. And so based on that, he thinks they need to know what Mr. Ballard's state of mind was when he did his media tour. He says it's central to the existence and the egregiousness of the violation. He says that because the pretrial order is kind of the equivalent to an injunction, at this point, all they have to show is non-compliance with the order and knowledge of it. And that is enough to justify the hearing. But the issue then is what sanction should be imposed. And that gets to the intent that the parties had when they made the decision to speak. And so he's arguing the court can't investigate. You can't investigate, the contempt and the severity of it and so forth unless you have these internal communications that they had with each other about, assuming there are any, which, I mean, the state makes a good point. They haven't established that there are any. Nevertheless, that's kind of normal in discovery. You don't know if they have it or not. You say, if you have it, produce it. So I kind of suspect there are some, but, internal communications about whether he should go on Fox and Friends, what they should say, how they made the decision, and so forth. Defense thinks that's relevant. And they rely in part on the Levitt case because that showed that the contemnor, the prosecuting, the elected in that particular case, was aware of potential problems. Levitt was such a train wreck. They went through this whole process of vetting and pre-writing his formal statement to make sure it falls crystal clear within the lines. And then he takes one question from the press and just blows up the answer with, oh yeah, we totally believe this witness is reliable. And frankly, it's because of a lot of stuff you're never going to be able to see. Those statements are a big problem. And I don't particularly find them that equivalent to the statements that we're dealing with in this particular situation. But that doesn't mean just because the Levitt statements were so obviously bad, it doesn't mean that Mr. Ballard's statements weren't bad because they weren't that bad. They can still cross the line. And like I've said, I think there is a fair argument to make just based on the lack of acknowledging, this is just an accusation, and getting into the future testing and things like that, that don't seem to me to fit real well within the limitations of the ethical rule. So the judge is pushing back on this a little bit, though. He says, I haven't watched any of the interviews. The judge is trying to keep himself as clean a slate as possible, which I think we can all appreciate. And so he's saying, well, are you saying, though, that the violation is what he said on camera or what he said in the private conversations with the other prosecutors? Because I think he's going to be skeptical. It's guys, it's intrusive to go in and try to get the other side's communications. Like, everybody knows that that's intrusive. If the prosecution was doing it to the defense, they would be absolutely freaking the flip out. yes, it's a kind of a little different because you, the defense attorney, have a client and you have confidentiality with the client, and the state isn't really in that same situation. But they do have, yes, they have work product protections and things like that as well. So the judge, I think, is he knows that if he allows this, the prosecutors aren't going to be happy. They aren't going to be happy. And remember, this is a very happy Mormon courtroom. We want everybody to get along and work together for the greater good. So I get a sense that the judge is a little bit hostile to this suggestion. Not that he's not going to order it, but it doesn't feel good for him to think about, sure, I'll just go ahead and hand you over all of their internal email communications. And so Mr. Novak's explanation was that, well, the violation itself is the extrajudicial statements, the things that he went to the court, went to the press and said. But there are questions about the egregiousness of the conduct. Was Mr. Ballard just doing this out on his own, or was this part of a management decision that was considered and evaluated? The problem from his perspective with these statements at all, okay, he made them on his own, but he said there is a violation just based on the fact that he's making these public statements about the forensic evidence, the future testing, the versions, what they anticipated was going to show up in future versions of ATF reports. And I don't necessarily disagree with the defense about that. I don't like that statement at all. But then also, what he says are clear expressions of opinions on guilt. I don't know that it's that clear. We did talk about this last time as well after the last hearing, but because opinion on guilt tends to be construed really narrowly. Like, we think that this. That said, they did say, we believe we have the evidence to overcome his presumption of innocence. But yeah, it's based on the evidence. It's not, well, he looked really shady, or he said some things, or based on evidence that you're never going to get to see. We think he's guilty. But it's a kind of fine line. It's a kind of fine line. The whole purpose of the trial is to argue from the evidence. You, the jury, should find the defendant guilty or not guilty. So it's kind of consistent with that. But at the same time, you cross a line when you say, based on how I interpret this evidence, jury, I think he's guilty. And so therefore you should do the same thing. You don't get to do that because your personal opinion isn't relevant. So they really did slip in and we believe we can overcome his presumption. I'm not sure. I'm not sure that's squarely within the lines. Pointed out they're aware that this conduct violates the gag order because of, the communications they had sent out to their own witnesses. So the issue then comes to what is the harm to Mr. Robinson, what remedies would be necessary to return to Mr. Robinson his presumption of innocence. So that's when the judge asked if I agree that it's the court's duty to investigate. How much time do you need? What's necessary, and so forth. Mr. Novak saying, if you're going to do that, you need the materials that we're requesting, because this whole investigation, he argues, it's not an ex parte thing that the defense is excluded from. They should have notice and an opportunity to make their own arguments about it. And if there's concern about privilege, some of the communications might be covered by, more specific privileges that the judge can just look at that in camera, doesn't necessarily have to share that with the parties. But defense clearly thinks they need to know what the entire prosecutor's office was saying about this, how the decision was made, to get a sense of how much do we have to punish them, basically. So he acknowledges that it is within the discretion of the court, the investigation, and what exactly it consists of and so forth. He's just saying our position is that for you to exercise your discretion appropriately, you would need those communications that we're asking for. Pushes back that the motion to continue mischaracterized the ATF report. No, it didn't, he says. He says the state just wanted to expand on the meaning of the inconclusive result. But They did that by going on a media tour instead of by contesting it in the pleadings or using any of the other methods the defense suggested would be appropriate. He said that the state thought that they sent this communication early on that the ATF report should be under seal, but then they made it a public record. No. Got to push back on Mr. Novak on this one. The state did not make it a public record. You made it a public record because you filed it. You filed it in the court file. You filed it in support of a motion that you filed. You filed the motion under seal. The state didn't contest that. The public did. The media did. And it became unsealed. And now we have it. You did that. If you don't want it in the public record, don't file it. It's really kind of the bottom line. So, regardless, I don't have a whole lot of sympathy on this one because regardless of what the state thought about the ATF report or whatever, the defense chose to file it. That's on you. That's on you. So he says they correctly characterized it in the motion to continue, but really doesn't explain, how, doesn't give analysis to that, just says they correctly characterized it. I'm somewhat sympathetic to the state's argument here that, well, it's not a complete characterization. The problem is that it's advocacy. It's always going to be advocacy. The defense is always going to interpret evidence one way, and the state is going to interpret it another. That's why you have trials, and that's what trials are about. So this whole issue, like whether it's inculpatory or exculpatory is such a matter of perspective and argument. It's not a fact that you can just go out and correct. I think that's really where it came down to for me, is that if the issue is just that it's implied that it's exculpatory when the prosecution thinks it's really inculpatory, that's just your opinion, man. It's not a fact that you get to go out and correct. He points out that the whole issue with the ATF report came about because there's this ongoing problem. The FBI wants to do this destructive testing. They don't want to record it. They don't want to allow a defense expert in to witness it. So that has been the kind of hold up on that testing process. And it's just apparently sort of sitting and not really being litigated right now. Don't know why. I just assume the whole testing proposal is on hold, and maybe the state's not going to go forward with it at all. Who knows? If it's of marginal admissibility, like arguable admissibility anyway, if it's not, if they're going to have to go through a whole process to validate scientifically what they're trying to do anyway, they might just decide, forget it. It doesn't really matter that much. So the defense kind of characterizes the state's position as saying that because the defense made statements in court filings that are then misinterpreted by the media, that they get to respond by going on a media tour. And he's arguing there's alternative things they could have done. Number one, they could have simply filed something where they say, we think the defense mischaracterized the ATF report, set the record straight that way. They could have reached out to the defense to request a correction or a clarification. But instead of doing those things, they drafted an email to the news media and conducted an interview where he gave extrajudicially his own characterization of the evidence. Points out that when the state challenged the gag order previously as a prior restraint, Mr. Novak, defended the gag order. Yes, he did. In fact, he argued they wanted to expand it to maybe include the politicians and stuff, but that obviously never went anywhere, prudently, because that was a terrible idea. But he did defend it at the time that it's not a prior restraint on anybody but the lawyers and their witnesses, meaning their investigators, their law enforcement witnesses, and so forth. But it also specifically identifies in Rule 3.6 in the limitations specific types of statements that are presumed to be prejudicial, and those include statements about forensic testing and statements that are opinions on guilt. He gets the presumption of innocence all the way up until the case is submitted to the jury for deliberations. And so the prosecution should not be undermining that at any stage leading up to that point. But ultimately, it's like they should file something to correct the public record. And I did have to put a little asterisk in my notes, like, oh, the irony, the irony, because we've heard so much complaining about misinformation from the defense, but they're not setting the record straight in their filings. If these things are like a problem or wrong or whatever, not really doing what they're advocating the other side should do. Does raise some questions for me about exactly how misleading the public record is. Bottom line, doesn't matter what the media thinks of the filings, the process isn't for the media. So the judge wants to know, how much time do you need if the request is granted? And Mr. Novak is like, well, kind of can't answer that because it depends on what, that's why we've asked for this discovery, because if Mr. Ballard is the only one who was involved in this decision to make the statements, then we would just need him. But if there's other people involved, we might have to call more witnesses. The media itself, speaks for itself. The statements are already out there. They're already in the record. So really don't need evidence about what happened, just why. But ultimately doesn't think it would take longer than a single day. The judge kind of follows up, well, but if I say no to this discovery and you just get to put Mr. Ballard on the stand, then how long is it going to take? And Mr. Novak's like, well, my very first question to him is going to be, who did you talk to about this and why? And he's going to, decline to answer on the grounds that it would implicate work product. And then we'll be having this whole conversation all over again with him there on the stand. So, Well, I'll get through the state's recap first before I get to my prediction. So Mr. McBride then, of course, argued for the state, and he characterizes the issue as whether the defense has shown an adequate basis to warrant further proceedings because the defendant has already mustered the prejudicial statements. I liked the use of the word mustard. No, it's not mustard like the condiment. It's mustard as in like a cattle muster. It's so Old West. It's a very Old West feel for me. A muster. That's what you do when you go out and you get on your horse and you circle the herd that's out there free ranging and you bring them all in together in the same place. That's your cattle muster. Very colorful. But anyway, they've already done that. They've already got that herd of statements brought back into the corral. And so that's the real question to the state, is simply the statements on their face. Do they violate the order in the Rule 3.6? I kind of agree. So I agree with the state that procedurally that's where they're at. And that's the question that the judge has to decide. Do these statements on their face? Oh, I guess I should take this banner down. Do the statements on their face justify some concern about whether the gag order has been violated? And I think the issue here is that, I think they do. And I think the judge is likely going to think that they do. It's just that he can agree with them that you don't necessarily need discovery into your emails to establish that, but you could potentially need discovery in the emails to look at the sanctions issue. If we go through this evidentiary hearing and we find there's contempt, we might need to have a separate process on sanctions. And so Mr. McBride seems to be kind of inviting that. He acknowledges the discovery they're asking for, it might go to sanctions, but it doesn't go to the fact of a violation. So this is kind of a kick the can down the road, Judge, please. Get through the preliminaries before you make us turn over our conversations, because maybe we won't get there. So he says instead the judge should just look at the statements on their face, and if there's a good faith basis from those statements to require additional proceedings because there might be contempt. So turning to the law, he argues when there is pervasive media that mischaracterizes the case or the facts, the attorneys have not only the right, but arguably the duty as zealous advocates to respond. And the rule contemplates that. And this is at the heart of where I struggle, because I remember crystal clear when Adam Waldman, his conduct was at issue in the Virginia court. Amber Heard was trying to get him kicked off of the team, get his pro hac vice admission revoked, and not a single time did Johnny Depp's defense team raise Gentile versus Nevada, the ethics rules, any of that stuff, the First Amendment implications, including the right to respond that's there in the ethics rule. And I remember so clearly arguing at the time, you could make the argument that Adam Waldman has a duty to put this stuff out there, because you have a duty of good faith and fair dealing in civil cases. You have a general duty to mitigate your damages. And so if you can fix your reputational damage yourself, mitigate it by making sure the public is aware. Here's what the screaming banshee does behind closed doors when she doesn't think anybody is listening, it's recorded. And that's like the real story of like, she actually admitted she's the one that beats him up and not vice versa and everything. That might mitigate his reputational damage. And then you're not just throwing yourself on the court, playing helpless and making things worse and then expecting the court to fix it. So I remember arguing that at the time. Yeah, I can very much see an argument that he not only has the right to say this stuff, he has a duty to do it. And I do. And it's just, this is where I struggle, because yeah, I want the same rules to apply to both sides. That's why you have rules. That's what they're for. They are to be universally applicable, and not we have one set of rules for one side and one set of rules for the other. And so I want the defense to have the right to speak, to correct the record when there is just a slew of inculpatory, incriminating stuff that's out there. And then suddenly you're supposed to just sit down and shut up and not be able to point out either facts that the state has chosen not to point out or problems with their facts and so forth, so that your client can get a fair shake and that people can go into the jury selection recognizing there is actually some kind of argument here. Don't necessarily know what it is. It's not necessarily going to be fleshed out until you're in trial, but at least not being completely blind to the possibility of some kind of factual dispute. So he argues the duty, and I'm like, I don't really like that from the prosecutor, but I have to say I've made that argument in different contexts, so it has some appeal to me. So here in this case, there has been massive media, creates an undue risk of tainting the jury pool. And he says that based on that, the prosecuting attorney has the right and the duty to respond. I do see a little bit of a difference. I literally just finished saying the same rules need to apply, and now I'm going to talk about why they're different. But I do see a little bit of a difference when it comes to the prejudice from pretrial publicity. Because the reality is that I think the big concern and the biggest problem is the pretrial publicity that gives rise to the just assumption that he's guilty. Of course he's guilty, knee jerk. He's probably, he's guilty. He's going to have to come in and prove me innocent. All of these kind of misconceptions about how the process works that are so difficult for the defense to overcome. And so you flip the script, and now it's the state, quote unquote, that's being prejudiced. And why are they being prejudiced? They're being prejudiced because people think the defendant is innocent. The defendant is supposed to be presumed innocent. We're supposed to start from the standpoint that he's innocent. and you have to prove that he's guilty. And so, yes, I do see the argument that it's bad if you reach your fixed opinion, the mirror scenario, if you walk into the courtroom and there's absolutely nothing the prosecution is going to be able to present that would convince you that the guy is guilty, you're a biased juror. You're not going to be qualified to serve. But at the same, if you're just like, oh, I didn't really know there was this other side of things. Maybe there's going to be, maybe there's going to be more to it. Maybe I'll keep an open mind. Maybe he's not like reflexively guilty. That to me is like consistent with the fair trial. So I don't see the prejudice really being equivalent between those two positions. Nevertheless, that's his argument. His client, the state of Utah, is prejudiced by the misleading statements that were out there. Arguing that his duties as a prosecution are just as stringent as a defense, I'm never going to be on board with that. Sorry. Just never going to be on board with that, because you don't have a client. You don't have a client. You have this nebulous representational position, the people, but that's not a person. That's not anybody you have to consult with. That's not anybody you have communications with. It's an idea and an aspiration. And so I struggle. I struggle so much with this argument, because I don't want to disagree with these aspirations that, yes, the prosecutor's duty is to justice and it is to truth. And they do need to put that above and beyond boring concerns like just winning and losing, mere ambition. Is this going to improve my case to someday run for governor if I prosecute this case or not? But it's just kind of been around too long to see that as how things really work a lot of the time. So I'm just in this conflict where I agree with the aspiration, and that's what it is and that's what it needs to be. And I very much want to encourage prosecutors to continue to live up to that, to aspire to live up to that, to really take that seriously and internalize it and act accordingly. While also kind of feeling like it's sort of super rich to always wave that flag, because the prosecutors who are like deep in the depths of violating my client's rights are also waving the flag about, what ministers of justice they are, and that's why they're behaving the way they are. When you're a minister of justice, you get caught in that black hat, white hat mindset very, very often, that I'm the minister of justice, therefore I'm the good guy, therefore whatever I do is good, and the ends justify the means. And so I'll withhold evidence and I'll cover things up and I'll encourage my clients to lie on the stand because I believe that's going to get the right outcome. I, as the minister of justice, I'm the one who's right. And that, of course, is like a really super messed up way of thinking. I struggle with this aspect of the argument. So then he says he doesn't blame the media for this problem arising. He's saying they're just repeating counsel's misleading statements. I don't know that I agree with this either, or think that it's really smart as a strategy. I think it would have been much safer to, and they did in their briefing, they leaned on the language of the rule, which just says the right to respond is in response to, publicity that's initiated by someone, not by the person who's making the response. So it doesn't require that what you're responding to be attributable to the other party. It just requires that you not be the reason why you're now having to go out and respond in the first place. So it really, I think, would have been safer to not kind of turn this into a their side or my side. It could have been just more generous to kind of focus on the media. It doesn't matter. It doesn't matter if the defense initiated it or not. The bottom line is that what was being reported was getting massive attention and it was untrue. And it's going to create a risk that people are going to have this idea in their mind when they come in to potentially sit on the jury about what the evidence is, and they're going to be wrong. And that's going to affect their ability to serve. But they're going to go all in on blaming the defense counsel. It says it absolutely was misleading that they said ATF was unable to identify the bullet recovered from the autopsy as being fired from the rifle. And he says that's accurate as it is, but it's also incomplete because there's material omissions. The fact that it did not say, as the report did, unable to identify or exclude, meaning can't rule it out. It's included. You can't rule it out. It's just not exclusively identified as the one, which is kind of a problem with this type of tool mark analysis anyway, but we're going to have plenty of time to talk about that in this case, I'm sure. He doesn't like the fact that they said, they may offer the testimony as exculpatory, but he says it's not exculpatory. And the other piece of information that they omitted that he thinks is very important, and it is, I mean, factually, it is important that they were able to identify a bullet jacket fragment as .30 caliber class. And so that would exclude a lot of potential weapons out there in the world, but it includes the 30-06. I saw a question come through the chat, and I'm not sure, I don't think I had a chance to highlight it. I was going to pull it up, but I think it just flew past me too fast. But somebody asked, how are you going to be able to do that? How are you going to be able to make that identification? And with something general like a 30 caliber class, with the bullet jacket, the bullet jacket is shaped. And so it just depends on how much they have and kind of what they're able to measure from that. But there's a couple ways they can do it. They can look at like the most common one is just going to be, if it's shaped, it's going to follow the shape of the bullet. And so if there's enough there that they can measure, the curves, basically, you're doing essentially geometry. Then from that, you can extrapolate what the full volume of the lead component would be. And so that's what I anticipate is going to be their basis for it. We don't know, but we'll have to see. There may also be things like manufacturers' differences between like the thickness of the jacket fragment and stuff like that as well. But it doesn't sound like it's kind of getting down to that level of granularity. It's just in general, this includes 30 class caliber bullets. And so I'm going to assume that's based on there being enough shape in the bullet jacket fragment for them to be able to extrapolate the full amount. So in his view, this shows the evidence is inculpatory. That's just your opinion, dude. That's just like your opinion. The defense is going to argue they weren't able to match it. And if you expect that they would be able to match it, then them not being able to match it is exculpatory. It's plain and simple. If you expect it and it's not there, this was I have in my margin a little note. This is advocacy. This is what a trial is. We're looking at the same facts. They're arguing this is inculpatory. I'm arguing this is exculpatory, and the jury will decide. Of course, it's a matter of opinion. But he says it's not surprising that the media reported it the way they did because of how the defense characterized it as being exculpatory, and then they had also, omitted the certain parts of it. So based on that, the Daily Mail ran this story. It garnered 22 million views on X in one day. So they're watching X, guys. They're watching X. We kind of already knew that, but now we know. And it reported that the bullet didn't match the rifle. And, based on that, he says they reported that it exonerated Tyler. The case had fallen apart. There's quippy headlines like, if the bullet don't fit, you must acquit. And that all of these things, he says, are a reasonable inference from the statements that Robinson's attorneys made in their filing. He says, so now we have the report, and the report itself is public, became public, and the media is violating your client's rights. So what do? You look at the rule. He looked at the rule, and he sees 3.6C has that right to respond. And so you look at, has there been substantial publicity here? Yes, there have. 22 million views on X in one day. Does it have an undue prejudicial effect? Well, he says yes, because it mischaracterizes the evidence. I don't know that I really like the idea. This is another bit I'm going to struggle with. Who gets to decide if it has an undue prejudicial effect? The state's position here is that they get to unilaterally decide and then go out and make a statement about it. Now, if I'm the defendant and I'm doing this kind of analysis, there's a newspaper article about my case. It's got a whole bunch of stuff wrong. Who gets to decide if it has undue prejudicial effect? My situation, I want to be the one to decide. I don't want to have to go in front of a court who's going to come up with a million excuses about why it's not so bad for my client. And really it maybe even probably helps them, I want to be the one to decide if it's unduly prejudicial, because I'm the one that has the big picture view of my client's case. The judge doesn't have that. The prosecution doesn't have that. They don't know about my case. And so I don't necessarily like the idea of having to vet, get the judge to decide ahead of time, is this publicity substantially prejudicial? But I also don't like the state being able to decide for themselves unilaterally, oh, we have a right to respond now. Because even though, from my perspective, this has been a pretty good prosecutor's office, so far, what I've seen. And again, this is relates to the this is super Mormon country thing. They're nice. They seem to be playing pretty much fair. The disputes are nominal. But that's almost like what makes it so exceptional to me watching this case is how little I expect that elsewhere. I expect it to be just the gamesmanship and the wanting to win and all of that. So I can very much see a situation where just because in this particular case, the prosecution hasn't popped off every single time there's a factual representation about something to go to the media and give their case, doesn't mean to me there aren't prosecutors all over the country that wouldn't do that in a second under a rule like that, where you get to laterally decide if there's something prejudicial out there in the media that warrants you responding. I struggle. Don't envy the judge on this particular issue. The fact that it's recent and not initiated by the state was another factor. So he says 3.6 is directly on point. It allows correction of the record. He says usually you do that in the courtroom, but sometimes you have to go to the press. Didn't really clarify that. Why would you have to go to the press? You might have to go to the press if it's really urgent, because court takes time and filings take time, and you gotta have a reason for the filing anyway, and then there's time for the media to pick it up, and maybe it's never going to be as big as it the correction is never as big as the original story. So that's kind of the only real reason I can see about why would you need to go directly to the press? It's time and your best opportunity to be able to get the message out. But it's not real clear to me that being patient doesn't solve a lot of these problems anyway. Just wait for it to come out. You know how this process goes. You know there's going to be an opportunity. I mean, I guess it goes back to relating to how big of an effect is this going to have on your potential jury pool. But it's just, I would have liked maybe a little bit more insight into his thought process about why do you sometimes have to go to the press? And how would you make the distinction between when I can correct this in court and when I need to go to the press? I mean, if that's the kind of part of the basis for the argument, I feel like that's an important distinction to understand a little bit better about. So why did you not go to the courtroom? He says, Mr. Ballard took the report, the ATF report, and he explained what it meant. That inconclusive just means there's insufficient material to compare. He says it's insufficient to include or exclude. Dude, you just misrepresented your own findings, okay? Because it is included. It is not insufficient to include it. It is very sufficient to include it. It's insufficient to exclude everything else. That's what identification means. We've identified this thing to the exclusion of everything else. That's what their testing can't do, but it very much did include it. So you're not helping yourself with your case here that's saying things in court. Ugh. To show that Mr. Ballard was circumspect in his response, hey, he didn't take the next step of arguing, actually, this is inculpatory. Actually, this is proof that he's guilty. Actually, they pointed out the 30 caliber stuff. Well, I mean, yes, I suppose that is circumspect, but it would have been a problem if he had done those things. It potentially would have been a much more explicit violation of Rule 3.6 because it does specifically identify categories of statements that are presumptively prejudicial, and that includes test results. If you say it in court, it's not extrajudicial. It's fine. But if you're going to be talking about it extrajudicially outside of court, you don't get to do that. So I'm not really sure that this is circumspection in the sense of like he could have done that and didn't. I think it's circumspection in the sense that he would have been in real freaking hot water had he done that. And so he, was a little bit more cautious, but maybe still didn't stay all the way in between the lines. The judge says he has a question now that you're talking about zealous representation, but isn't that for defense lawyers when they're representing a client? The prosecutor is a minister of justice. There is a whole bunch of case law out there, and some of it all the way up to the U.S. Supreme Court level. We deal with in the prosecutorial misconduct context, because it's talking about the zealous advocacy and how the problem when you're a prosecuting attorney relying on a duty of zealous advocacy is that sounds an awful lot like win at all cost, and definitely not saying that's the defense counsel's role. However, the defense counsel does get leeway in a criminal case to be able to do things, make arguments that other attorneys don't get allowed to do. And it's because of the importance of the liberty interest that you're representing, the due process required and so forth. You get to make marginal legal arguments. In fact, you're supposed to, and we're not going to see that anymore anywhere than in a death penalty case where everything is at stake. And so you're going to raise every marginal issue, even the things like the defense is arguing. Sixth Amendment prohibits use of reliable hearsay in preliminary hearings. This is an argument they are going to lose, period. Like, not even real difficult under Utah law, which Judge Graff has to follow. There is case law out of the Utah Supreme Court that says you get to do this, and it's fine. So Judge Graff is absolutely going to have to follow that. So why did they why did that file that motion? Because they are already thinking 10 years down the road to when this ends up in front of a federal habeas judge It was like, okay, well, the Utah court said that, but the Utah court isn't binding on me. I'm the final authority on what the Sixth Amendment requires. So I'm in a position to be able to say that Utah Supreme Court ruling is wrong. That's the kind of zealous advocacy you get to do as a defense lawyer, is you get to make these kind of marginal arguments that are pretty squarely against you, because there's a little bit of a gap there for you to argue, well, but the law should be different because. If you're like a civil lawyer making these kinds of arguments in your case, they're probably not going to fly very well. So it is a bit different. It is a bit different. Zealous advocacy to a prosecutor sounds a lot like win at all costs. With the defense, it's kind of contemplating this need to push the boundaries a little bit when it comes to what are the law, what are the facts. So Mr. McBride, however, being a prosecutor, and it's like so conflicted. So conflicted. Because I do want him to believe and to act like the prosecutor's duty is the duty to truth. Not to a specific client, the duty to truth. He's arguing it's even more important. We have a greater duty of zealous representation because the duty is to the truth. He's right that the rule does apply to prosecuting attorneys. Zealous advocacy is kind of one of the basic competence rules that all attorneys have to follow. Any attorney has to be a zealous advocate for their position. But he's arguing more, prosecutors more than anybody else. If that were reality, I struggle and often do, frankly, with legal issues between the aspirational standard that really it needs to be the aspirational standard. The prosecutor represents all of us. They have so much power, so much access to information and resources and stuff that we don't have. They get to do so much of what they do behind closed doors without public inspection. They're doing it on our behalf. So yeah, they have a really, really high duty to have the right motives and the right approach. That is truth focused. We have to have the aspiration. And at the same time, we also have to acknowledge that it's kind of rare to live up to. And I don't know where to balance that. So he says that the fact that Mr. Robinson is presumed innocent, in fact, he is, and you should say that. And he did. He kind of did, but other times he kind of didn't. He said that he believes the presumption can be overcome with the evidence that they have, and that that's not based on personal knowledge or experience like it was in Levitt, where he's like, for all the reasons that you'll never know, I personally believe it's totally fine because this witness is super credible and so forth. Says it's just based on the evidence, and it's to rebut the claims that the case was falling apart and that the evidence was inadequate, and that this constitutes nothing more than the Rule 11 certification that attorneys have to give in a case. Anytime an attorney signs your name to a pleading in a Rule 11 jurisdiction, which might be every jurisdiction at this point, I don't know. It comes out of the federal Rule 11, but the state rules often mirror that. When you sign anything you file in court as a lawyer, you are representing that all of the claims are warranted by the existing law. This is the catch for the defense, primarily the defense lawyers, or an argument, a reasonable argument for the reversal or expansion or modification of existing law, and that your factual claims have evidentiary support. Here's the thing, though. I mean, there's a lot of things that you could say consistent with Rule 11 that would not be consistent with Rule 3.6. And that's the whole reason is the difference is Rule 11, you're saying it in court. Rule 3.6, you're saying it outside of court. So I didn't really care for this particular argument. I don't think it's a real strong equivalent here, just because the nature of the statements are so very different. He says that Mr. Ballard's statements are very different from the ones in Levitt. I can't disagree with him about that. I do agree about that. They're very different. The degree of problematic in the Levitt statements was massive. Ballard, it's a lot closer to the line, but that doesn't mean it hasn't crossed the line. It's just not that bad. He says that the statement about, we believe the evidence is going to overcome the presumption of guilt at trial, so forth. He says that they believe that that is appropriate to ensure that the public is, reassured that there's adequate evidence and that the case is proceeding appropriately. So the judge asks, well, but isn't inculpatory and exculpatory up to the fact finder? And Mr. McBride's like, well, yeah, but I can't possibly see how that's an issue here because you're such a freaking prosecutor. The judge is like, the judge can see it. The judge can see it. He's like, so maybe we should be cautious about how we put ourselves in the shoes of the fact finder. Assuming that our interpretation of whether something is inculpatory or exculpatory is like definitive. This is so classic prosecutor to me. They can like only see the facts the one way. And that's why then it's like such a shock when they lose trials, because it never occurred to them that like the defense is gonna have a point. They're gonna have a take on this. They're gonna have an argument that this isn't as bad or as incriminating as you think it is. So basically he's just saying, I can't see it here. I could absolutely see it. I said it at the time. Mr. Novak said the same thing. Absence of evidence. Okay. You weren't able to match it to the gun. That's going to be the defense case. And in a lot of trials, that is the entire defense case. Because that might be all you have to work with. They got DNA, they got confessions, they got video. You'd be like, but there's no fingerprint. There should be a fingerprint. When there's all kinds of reasons why, there may or may not be a fingerprint in any particular instance. You haven't necessarily educated the jury about all that. But it's just a very common way to defend a case. He says that the defense is arguing that the state's only avenue in responding to a problem like this is to file something or to contact them. And he disagrees with that. He says that the ATF report, wasn't even mentioned. It wasn't like central. It was just this ancillary issue as part of their motion to continue, which was primarily based on the DNA evidence. And so when he's, as a prosecutor, making his argument, he's just going to make his judgment calls about what carries weight and what doesn't. This was not a good answer, because if it's your judgment call that this is an important enough fact to correct for the public, then it should be also important enough to correct for the judge. The judge is reading this. And if you think it's that big of a deal that you're going to have a press release and a little bit of a media tour, then surely it's important enough to correct for the judge. So you saying it's like not important enough to file something while at the same time it's important enough to go to the media about it. I have a hard time reconciling those positions. He says responding in the pleadings doesn't address the media frenzy. It doesn't protect the client or the jury pool from the prejudice. Again, this to me seems to be a timing issue. And that goes very much into the prejudice because, like in the Gentile case, for example, the one that deals with attorneys, the implications of these ethical rules that limit what attorneys can say extrajudicially about their cases. How does that get reconciled with the First Amendment? That's the Gentile case. One of the things that they point out is that yes, there is a legitimate government interest in ensuring fair trials. And so that justifies some kinds of restrictions on speech when there is a likelihood of prejudice to the fairness of the trial. But one of the factors that they look at under Gentile in evaluating if we have prejudice here is how soon is the trial happening? Because it's really common for people to forget things. or not pay attention to them, or it just, you know, by the time the trial happens, there's so many other twists and turns have happened that this particular thing we're dealing with right now isn't even really that important. I'm just not seeing the urgency. He says they knew the rule from the outset, from the day that Mr. Robinson was arrested. They sent out letters to the feds and to the state investigators about the rules and requesting that they, you know, comply with them and not make these extrajudicial statements. And they did that because they looked at the rule. They're committed to abiding by the rules and assuring a fair trial. And so far from what I've seen, I don't really strongly take issue with that. This really does, to me, seem like if I'm a defense lawyer, just watching how kind of this is unfolded and in the process and how people are dealing with each other and everything, this looks to me like a good prosecutor's office to deal with, because some of them are just nightmares. They're so obnoxious. They're so difficult. Nothing will be done in a collaborative way. In this case, we've got the, you know, quote unquote, open file discovery policy. We have the extremely polite emails back and forth. We have the cooperation. We have the meet and confers that seem to be able to resolve most things so far because we've had so little litigation about substantive issues or you know, discovery disputes and stuff like that. So I really do, you know, I do. I feel like this is sincere and they mean it. They do aspire to that. I would have to, from my perspective, say so far it feels like they're mostly living up to that. It's just that not clear that you did so in this case. I mean, I think their intention to stay within the line, maybe, okay, there's good faith there. I'm not really seeing evidence of bad faith, although that's exactly why the defense wants the email communications. But it doesn't mean that they did. Just because you wanted to play fair doesn't mean, you know, what you actually decided in your mind was fair is what everybody else is going to think was fair. Also, their client, the state, you know, when Utah gets a right to a fair trial too. Kinda. It's a little bit different. It's an important public policy that you know, that trials be fair and stuff. But as far as the Bill of Rights, the actual like constitutional rights that people enjoy, those are individual protections. Those are the defendant's rights. They're not equivalent rights on the part of the state. We are very cautious and will be more so in the future. If you need to be more cautious than you were in this, it implies you weren't being very cautious. And like, just frankly, this is to me, again, so like if this is over the line, it's not massively over the line. It's just, it's a close call. Okay. You were trying to skirt it. You didn't. Far from the most egregious thing we've ever seen. But if you need to be more careful than this in the future, you probably should just not say anything at all. Just don't know that's a good, I mean, yeah, you want to show remorse to the court or whatever, but do that at the next stage, the part where he's actually deciding if there's a problem. If not the point where you're arguing about sanctions. That's a very good time to argue about your good faith. We'll, you know, but volunteering that is like kind of inviting him to get to that point. I don't think that's what you want. So bottom line for them, given the context, he doesn't think that there is enough evidence to justify additional proceedings. The statements were soundly within the 3.6 subsection C right to respond, Rule 11, and the case law cited. So the point is well taken, and we will revise the way that we handle the media to avoid future problems. from a good faith standpoint, it's good, but you've just kind of like acknowledged that the defense is right to be concerned about this. And that's hard to reconcile with your position that there's nothing to see here. So he's really, I think, trying to have it all ways with all of this. And that's a big part of the reason I think that we probably are going to have a hearing. I think the judge is going to grant it. So the judge then wanted to know from him also what's, if we do have the order to show cause, then what's your position on this discovery that the defense is asking for? And he's very explicit. It's work product, period. This is pure strategy. He talked about Rule 16 is the discovery rule. There are some exceptions to the work product doctrine that the rule has eliminated. But there might still be this at issue exception, meaning that if the internal communications are at issue in the misconduct, then it would be relevant. And he says that counsel hasn't shown any basis that there even are any communications. Well, that's why you do a discovery request. It's your job to go and identify anything responsive to that request. So it's kind of normal to not know if somebody has something in discovery. So it's not, it sounds like he was not clear on whether this at issue exception even still exists under Rule 16, or if Rule 16 is just flat out work product, don't get it. That would be surprising to me because there usually are exceptions and stuff, but he wasn't really prepared, I guess, to go down that road at length. They're also making this technical argument that Rule 16 is about like discovery for the case, meaning the substance of the charges against Tyler Robinson, and not, this collateral issue of prosecutorial misconduct. And I can't say that I agree with that either, because this is all going to due process and the right to a fair trial. And I would think that he's got at least some right to investigate matters that relate to that. Judge also wanted to know from him how much time, and he's like, well, obviously it depends because they're the ones running the show. The defense is running the show. We would just be crossing maybe 3 hours if Mr. Ballard is the only witness, but the issue is the statements. And since those are already in the record, he doesn't think discovery is going to add to that. Mr. Novak got his reply. He pointed to the order itself, gag order when it was first issued, September 16th of 2025. It requires lawyers participating to abide strictly by 3.6. This tends to mean you need to follow it to the letter. And if there is a question about which side of the line your conduct is going to be on, you need to ensure you fall on the right side of the line. That's where I think the state is maybe getting into some trouble here. It does not give counsel leave to decide for themselves if correcting misleading media reports is appropriate. He says, counsel reminded me there's a whole other option here that we could have done. We could have come to the court to have a hearing to see if the court thinks that a media response is required. And if the court said yes, then there would be a judicially crafted supervision of that. But he says also, I think the judge would say, no, there's no need for a media response. I struggle with this. Is that the standard you would want for yourself in all cases? You are representing a factually innocent person. You have the proof that this person is factually innocent. You can show that the prosecution has been engaging in all kinds of shenanigans, that law enforcement has been lying and misleading and fabricating and acting super sketch and violating the rights of people. You want to go in and have to get the judge's permission to say that? I don't love it. I really don't. This is kind of one of the challenges of criminal advocacy, is having to balance the short term, what is in the interest of my client right here, right now, with the long term interest of what's really best for all of my clients, what's best for the state of the law in general. And that can be really hard to do. And how, where exactly the line is between, my duty to this specific client versus my duty to all future clients, and my judgment on how to best strike that line. It's not a bright line. There's not a lot of law in this, not a lot of good guidance. There's going to be a lot of personal variation about these kinds of things. And it shows up in all kinds of little ways. All kinds of little ways. I might have a really good argument to make for my client that's going to piss the judge off so much that, we run the risk, if we don't win the argument, the judge is going to hold it against us. He's going to punish us, so to speak. He's just going to look at us differently. We're going to lose credibility. We aren't going to win future motions, stuff like that. Comes up a lot. You got to think about that type of long-term thing. Or if I come in and I make this pitch to the judge for why he should grant my motion, sometimes in another case, I'm going to be on the other side of an issue. And so is the judge going to hold it against me that I'm litigating both sides? And it gets more and more challenging the more you're in a position to actually make law that will apply to lots of cases. Because at the trial level, it doesn't, typically work that way. It's not, the trial judge's decisions aren't precedential for anybody else. They're just binding in this one particular case, and that's it. But you start going up on appeal and making arguments, these are going to apply to everybody. And so what's in your client's interest versus what's in all of your future client and other clients' interests, these are very, very difficult. So I just question this standard about judicial crafting public statements, because I can't imagine wanting that in the bad situations when you have a judge goal. Okay? If my remedy is to go to Judge Gull and say, Judge Gull, please let me correct this misinformation in the court record, she's probably going to send me up on contempt or something, So that's the difficulty, is you got the best case scenario, but you also got the worst case scenario, and you got to contemplate all those. And I'm really, really struggling with this idea that going to the judge to do it is a universal solution. Might be okay with this particular judge because he seems, frankly, so awesome. I'd love to be in front of this judge on a regular basis, but you don't get the guarantee of this judge because there are Judge Gulls out there. And there are terrible prosecuting attorneys out there. There are Bingers out there and Nick McClellan's out there. Ugh. He says the defense team has strictly adhered to the principle of no contact, not making statements to the media of any kind. Everybody's in the same boat. We also get media inquiries every single day. We just don't respond to them. We didn't say that the ATF concluded there was no match. That was just the media misinterpreted, what the result meant. And frankly, the media as a whole, this is common, this is my comment. I don't think that's the issue. It was the Daily Mail. Okay. It's a yellow journalism tabloid rag that gets its viewership largely on, being salacious and controversial and often very questionably true. And of course, they're not the only ones, but certainly well known for not exactly being a bastion of principled and accurate journalism. So it's like a tabloid picked it up, and then lots of people talked about the tabloid picking it up. But there's also lots of correction out there as well. I mean, that was kind of in some of the motion as well, that in fact, I think the state, before they even mentioned the Daily Mail article, they mentioned the Deseret News article that was talking about the Daily Mail article and how stupid it was. How it was not right. And it's, a comment on the broader picture of publicity of criminal cases and all that kind of thing. He says that the massive media interest isn't an escape hatch under 3.6. As long as it's not generated by one of the parties, it's just what we're all dealing with. Again, I can't really agree with that because the rule doesn't say based on the parties. And there's lots of ways that, you know, there could be misinformation out there that's not based on something a party said, but could very much impair your, you know, ability to get a fair trial. If you have a key witness that's out there saying things, that's not the other side, but you might need to correct them. The exculpatory argument. How is this exculpatory? It's real simple. This was a great explanation. I loved it. No notes, would not change a thing. State has the burden to prove beyond the reasonable doubt that he's guilty, and the absence of evidence that the fact finder might find probative is exculpatory. In his examples, classic evidence, there's no fingerprints. Argument is that my client took a gun and shot somebody else and killed them, but there's no fingerprints on the gun. Yeah, the absence of evidence, you would argue that would be potentially exculpatory. And why could that matter? Maybe his DNA is on the gun, but maybe it's just a tiny amount of trace DNA. And maybe the gun belongs to, I don't know, somebody else in his house. So there's like conceivable, plausible, alternative explanations for why the DNA is there. But if the state's explanation is the correct one, we would also expect the DNA to be accompanied by a fingerprint, by his fingerprint. Some sort of other evidence of direct contact and not just a secondary transfer or environmental or something like that. Absolutely the kind of case a defense attorney would make. So he argues the inability to match is exculpatory. And obviously the parties see evidence in different ways. The only question that matters is what do the people in the jury box think? As far as the discovery issue, he said counsel referred to what Mr. Ballard might have done, but they don't have any kind of declaration or testimony about what led to this this media play. So he says can't let the state hide behind the notion of no good cause for disclosure because they have a non-frivolous argument of a serious violation in a capital case. And so that requires looking beyond just kind of what's looking behind the curtain is the way that he put it, to not just what happened, but also why. The court took this one under advisement. I'm going to schedule the future hearing to announce it. We took our 10-minute recess and then we came back for the motion to close the preliminary hearing. So bottom line, my prediction on this one, I think they're going to get the hearing. I think the judge is, I think he's signposted that. Obviously not always a guarantee, but I do think that it's certainly implied by his comments. It's on the table. If it wasn't on the table because there was so obviously no problem with these statements, I just feel like that may have come out clearer through his questions and kind of how he responded to these particular arguments. What the outcome of that hearing will be remains to be seen. But I do think they're going to get the evidentiary hearing on whether Mr. Ballard is in contempt of court for violating the gag order. So then we moved on to the motion to close the preliminary hearing and to seal the exhibits. Ms. Visser argued this one for the defense. Very graciously let us know she would not take the hour. Appreciate that. Laughed heartily at her own joke, which won her over in my heart as somebody who also laughs harder at my own jokes than pretty much anybody else's. Oh, my girl. I can relate. You know, when you're funny, you're funny. What can you say? So she says, first, the state and the defense are on the same page as far as the exhibits, which they are from the briefing. They're both like, yeah, go ahead and close off the exhibits from the public record. And also, by the way, even if you go in person to attend this preliminary hearing, you won't be able to see them from the gallery because they're not going to display them. They're not going to publish them in a way that makes them viewable in the gallery. So whether the cameras are there, whether you're there in person, apparently the plan is nobody is going to see the exhibits in court. So then the question becomes, well, then do we get to see them out of court? They're both agreeing, no, we don't get to see any of this at all. She says the standard protocol for the preliminary hearings is that they are withdrawn after the preliminary hearing, which kind of makes sense because you need them for the trial. I mean, if I'm presenting something, original evidence in a preliminary hearing, I'm going to need that for trial. So I need to be able to get it back. That seems kind of normal. On the other hand, the stuff that is the basis for the judge's decision normally needs to be kept a part of the record because judges' decisions are reviewable. And so at least in theory, even if it would be practically hard to kind of come up with a situation where it would apply, at least in theory, if he's bound over for trial, there's some kind of mechanism to review that. Maybe it's discretionary review. Ask the well, it would be the Supreme Court in this case because it's a capital case. Ask the Supreme Court to review the sufficiency of the evidence that was presented to support the probable cause determination. There needs to be some mechanism to review that. Now, if you don't do it as discretionary review, it's not uncommon for state rules or state courts to kind of have the idea that you don't get to challenge the probable cause determination or the sufficiency of that evidence because it just gets incorporated into the sufficiency of the evidence at trial. And so it's not really a separate issue. If they didn't have enough, evidence to establish probable cause, then they wouldn't have enough evidence to establish proof beyond a reasonable doubt. So if your defendant gets convicted and you think the evidence is insufficient, like you already kind of have that argument. But it sounds like, they don't anticipate anyway a whole lot of appeal process coming out of a preliminary hearing. So their standard protocol is to just withdraw them. But if they have to remain in the record, then the defense has provided a table in their briefing of private, protected, and safeguarded information. So I am going to go ahead and pull that up because this is the document that I only got it this morning. It's not posted yet on the Substack, but I will get it up there as soon as we're done here. But this is the chart that she's talking about. And so it basically tells us these are the things that they think are off limits, that they're sealed or, confidential or get some other level of protection. Private, protected, safeguarded. You have all these different levels of what you get to see under the Utah rules and kind of different reasons who gets to see it. What sort of process do you have to go through it if you want to be able to see it? And so this is the table. So no problem with a lot of these images, but then video of mom and kids in the crowd, they're arguing this is classified, some way, private, protected, or safeguarded because it's photograph, film, or video of a crime victim is private. And then there's children and witnesses that potentially appear on the video. And so that is apparently another reason. Written statement, the 1102 statement of AW. Don't recall, is this the, I think this is this is the retired deputy sheriff from Washington County. So it contains personal identifying information, should be safeguarded. Other information, disclosure of which would jeopardize the life, safety, or property of the witness. Don't know how, they don't spell that out, but that's kind of their justification. Also, the 1102 statement is an out-of-court statement offered for the truth. It's inadmissible at trial unless there is a hearsay exception. And so the substance of these statements would only become admissible if and when Mr. Robinson is given the opportunity to confront the witness. Testimonial hearsay, there's a confrontation right that attaches to it at trial. Doesn't necessarily attach at the preliminary hearing. That's the whole Sixth Amendment argument the defense is making. But unquestionably, they have the right to cross-examine him at trial. So therefore, it should be protected. Video of shooting from behind is depicting a crime victim, so it should be private. Written statement of TP. Not entirely sure who TP is, but I think it might go to foundation for the video. Not totally sure though. So again, video of the shooting from behind. Nope. Photograph, film, or video of a crime victim, so we don't get to see. Written statement from TPUSA, all the same thing, personal information and video of the shooting behind the booth. So anything that like shows anything, they don't want us to be able to see. The medical examiner report as a medical, psychiatric, or psychological record. I don't know that it technically is any of those things, but it is certainly going to include medical information. It's just that it's autopsy. It's not treatment. It's not existing condition. He's dead. It's cause of death and so forth. And these are, this is a condition that does not have medical treatment. But it is common for them to include, medical information, including, conditions that might not, are observable in the autopsy, might not be previously known and stuff like that. UVU surveillance and doorbell camera surveillance from the day of September the 10th. This could lead to the identification of this person who is presumably one of the witnesses who authenticates one or more of these videos. And then also just it will interfere with the defense's ongoing investigation and Mr. Robinson's right to a fair trial. This is kind of shorthand for it's bad evidence. And so if we have no other reason to exclude it, it's because it will make people think he's guilty and that will jeopardize his right to a fair trial. Statement of CN, personal information. Oh no, Mike Mitchell is the one who was the deputy sheriff, not this other person, whoever that was. So Mike Mitchell is the deputy sheriff. What's the other person now? AW. Yeah, I'm not sure that I know who AW is. Of course, all I can think of is Adam Waldman. It's not Adam Waldman, but he's on my mind today. So, yeah, all of these things, rifle is fine. Medical examiner report is not. These things are not. The written statement of Mike Mitchell, this is basically just the confrontation because he's not testifying in person. They don't think it should come in. But it should be classified as protected. Video at the Washington County Sheriff's Office on September 11th, 2025 should be classified as protected because it will interfere with the ongoing investigation and the right to a fair trial. Contains footage of third-party witnesses that could put them in danger, whether those are Tyler Robinson's family members who accompanied him to the sheriff's office according to the state's case, or other law enforcement officers or something like that. I don't know. But again, this seems to be a little bit more of a generic. This is not helpful to the defense, so it will be prejudicial to him and should be kept not public. Recorded statement, the 1102 of Lance Twiggs. Again, with the hearsay, he should have an opportunity to confront him, is the argument. The text messages should be classified as protected because interfere with the investigation and the right to a fair trial. And he says he notes that although the contents of the messages were publicly released by the prosecution at the outset of this case, they're in the information. The republication of evidence only serves to recirculate purported evidence that was improvidently released. This is now the defense. That's just your opinion. That's just like your opinion, man. Whether it was it's in the information. You may not like it, but it is. And it's part of their probable cause. So they are justified in putting their basis for probable cause in their documents. The Discord chats might identify witnesses through usernames that may or may not still be in use by the witnesses on social media applications. And then that could cause contact with those people. So it should be safeguards similar to like personal information that would jeopardize life, safety, or property. They also contain statements from non-testifying individuals. Not sure that those would be offered for the truth of the matter asserted, and so that they would be hearsay. They would more than likely be offered for context to Tyler Robinson. What they are arguing is Tyler Robinson's own statements. But of course, we don't know because we don't see any of it. The photo of the note we shouldn't get to see. No problem with the FBI press release photographs. We've already seen all those. Photos of the rounds from the rifle. Don't want us to see that because it will interfere with his right to a fair trial. It's too potentially destructive, too potentially damaging to his defense. Proof of round from the apartment. All of this stuff. Burnt note, targets, all this will just make it really hard for the jury to presume that Mr. Robinson is innocent. The ATF report, ATF DNA report. This relates to DNA recovered from the rifle and the cartridges. By the way, that had come up as a question kind of previously. I've seen it floating around. People wondered, why is the ATF doing some DNA and the FBI is doing some other DNA? And the reason why is because it's kind of common. We saw this in Karen Reed, where particular items of evidence are being submitted for different kinds of analysis, but it also might have DNA evidence on it. It's not uncommon, you know, to just go ahead. You deal with the DNA and you sample that and do that testing and so forth before you go through and like fire the firearm, because you might, you know, transfer or interfere with the DNA evidence in some way if you do that. So in this particular case, it's because the ATF, you know, had been submitted the rifle and the cartridges to do the tool mark comparison and other comparisons, that if you're going to be recovering DNA from those things and they have the capacity to do it, not every agency is going to have the capability of doing it. But if they do, then they would just go ahead and handle that before they go through with their tool mark analysis. The FBI's DNA stuff relates to these other items that are not the firearm, so would not have been submitted to the ATF. So on these reports, Mr. Robinson is in the process of procuring the expert witnesses for the preliminary hearing. Provided such witnesses are able to testify, Mr. Robinson does not include the report in his request for relief. If unable to testify, the report should be classified as protected under these other subsections because it will interfere with the right to the defense. So basically he's saying if we get an expert in to kind of give our take on it, then we don't care if the public gets to see it or not. But if we're only seeing the prosecution side of it at this part of the hearing, then it would be prejudicial for the public to only hear that one side. Ballistics report will interfere with their ongoing investigation. ATF DNA report as to the Dremel and the cartridges. This, again, likely went to them because it's tool mark analysis of the engravings. So he's likewise getting his own expert. If he gets it, fine. If he doesn't, then we shouldn't get to see it. And then finally, the tool marks report. It'll just be really bad for their defense if that's out. Not really sure why, because they were just telling us it's exculpatory, that it is in fact an absence of evidence, but it's really not, right? It's not really an absence of evidence. The 30 caliber thing is not helpful for the defense. There's really no question about that. So that's their chart that she was referring to. She says, you know, basically everybody, state, defense, they're on the same page about the exhibit. So that's not really the issue. The issue is about closing the preliminary hearing. That's a little bit more nuanced. I would say yes and no. It shouldn't be, but I suppose it is. And it's tied to another motion, you know, the other motion that they filed about the use of reliable hearsay that isn't fully briefed yet. But that's kind of part of their argument, is that if we're going to be hearing all of this evidence that isn't admissible and ultimately would not be coming in at trial, then it's potentially prejudicial to hear all that. I'm going to come back to that point just because this has been addressed in the case law before, and I'm a little annoyed that that didn't get a little bit more attention today. The Kearns Tribune factors. So Kearns Tribune is a case out of the Utah Supreme Court that talks about the standard for closing the hearing, and how likely is it that there's going to be prejudicial publicity, and what are your tools that you have available to mitigate that through the jury, basically through the jury selection process. So here, no issue. It's going to generate media. Already been a massive amount of media. The argument they just had already shows how the media can misconstrue the evidence. So they want to avoid publicizing stuff that might ultimately not be admissible. They are anticipating lots of litigation on the admissibility of this evidence, chain of custody issues, 702 / Daubert issues. These are dealing with the validity and admissibility of scientific evidence. They are anticipating a lot of that. We already kind of knew that. Most of the hearing, the preliminary hearing, is going to be based on reliable hearsay because they are just calling these 5 officers to testify about what they learned in the course of an investigation that involved hundreds of officers. And so they're going to be testifying about information I got from other officers who did other parts of the investigation. And at trial, no question, they have the right to confront each and every police officer over that police officer's role in the investigation and what they're testifying about. But that's not the standard for the preliminary hearing. The reliable hearsay includes statements to police officers from other police officers about the investigation. She says we aren't in a good position to know how much of what they say is going to be their personal knowledge versus what's hearsay statements from other officers. And that is fair because only the prosecution knows how they're going to present their case at this point in time. Their suggestion is to close the hearing and then provide the transcript that would account for evidence not being admissible. So kind of similar to what they did in the very first hearing in this case over the shackling, before the media was ever involved and before there was all this litigation over closure hearings and stuff like that. That's basically what they did. Shut the whole thing. And then later on, we got a redacted transcript. As far as the Kearns and Archuleta standard, the cases that they've been primarily relying upon, she says they're dealing with the presentation of evidence from the state without addressing the future admissibility of that particular evidence. And that's the problem. Those are kind of like the benefits from those cases. And so the only way to prevent misconstruing the evidence and the facts in the press is to control what comes out. I don't like this. I don't like this because misconstruing is going to happen. And under the marketplace of ideas, the remedy for bad speech is better speech. Correct it, fix it. Controlling what we get to see and hear and talk about, I'm just immediately hostile to this idea. Judge has a question for her. He says that under the Kearns case, as with any restriction of a constitutional right, the remedy has to be narrowly tailored. And doesn't closing the whole hearing seem a little bit broad? Not the intention of the standards that we just shut the whole thing down and then fill it in after. And Ms. Visser says, well, the alternative is to make objections as we go through the hearing. And her view, it's going to interrupt things and it's going to take longer, and kind of making this judicial efficiency argument, which may very well be the case, that it will be harder and more complicated. But if that's what you have to do, then that's what you have to do to narrowly tailor it. I appreciate the court being kind of instantly hostile to this idea of just shut it all down, fix it later. Because that is not what is contemplated in the case law. Mr. Grunander spoke next. In generally, the state favors the open hearings so that the public can trust the process. It increases public confidence. And also acknowledging, however, this is mostly the media's fight. They aren't going to fight super hard for our right to be able to see this stuff coming out of the preliminary hearing. So Kern's Tribune makes it clear, recognizes there is a constitutional right to access the preliminary hearings, but the closure is based on the realistic likelihood of prejudice to the defendant's right. When there is such negative publicity that the jury can't, the jury pool would be affected and the jury wouldn't be able to be impartial. And there's no feasible or effective basis to ensure a fair trial. So those are the two factors. You see, he says previously in previous hearings, many times we've talked about voir dire, we've talked about jury questionnaires, we've talked about calling in lots and lots of jurors. And these are the standard remedies for pretrial publicity. As far as shielding the public from some exhibits, they favor denying physical access or copying of exhibits because of the Archuleta case that allowed those types of restrictions. The reasoning in that case was that it might disrupt the process. It's, the clerk has to manage the exhibits and stuff. And yes, it might potentially be disruptive if people are coming up to try to physically handle things. But also jeopardizing the right to the fair trial. And the case hasn't been tried yet. So having the media try it in the public based on what gets presented at the preliminary hearing isn't, and it's not a fair trial either. So that's their position on the exhibits. We shouldn't get them. We shouldn't get to see them. We shouldn't get to copy them. Nothing. But closing the preliminary hearing is different, he says, because the public has the right to attend and report on everything that's presented in court. So he thinks it's different from access to the exhibits. But sitting in court, you'd be able to see what's admitted. You'd be able to hear arguments about admissibility and stuff like that. Okay, now I will just say personally, having recently made my way through a court proceeding where I sat down there in the courtroom in Los Angeles watching the divorce from hell, where I do not have the ability to see the exhibits because their format in this particular court was that everybody would get a binder of the exhibits that were being proposed. Everybody, meaning the judge, the clerk, the witness, and the people sitting at counsel table. And so anytime they would talk about an exhibit, everybody would just flip to their page in their binder and nothing, gets displayed in court or whatever. And so a lot of times people would be looking at things and they can read the whole thing and see it, and they might not tell me what any of it is. And so it makes it very, very difficult to follow the logic and flow of a particular issue when you don't get to see what the evidence is. And so it really undermines this whole confidence in the court process rationale, because a big part of the rationale is my ability to understand why the court is making the decisions it's making. That's why we're monitoring the court. If the court is sending a bunch of cases through for trial on bad evidence that shouldn't meet the standard, how would I ever know that if I don't get to sit in the hearing and meet the standard? And then how am I going to be able to advocate for something to be done differently? So I really take issue with this argument that sitting in court and seeing the fact that exhibits are admitted is good enough, and that achieves the goal of transparency and having confidence in the process and the decision. He argues that if the court closed the preliminary hearing, you would necessarily then be limiting the electronic media coverage. So his argument is that you also have to consider the factors for electronic media coverage as part of whether you close the hearing as a whole. And so going through a lot of those factors, doesn't think the presumption is overcome. I see the kind of correlation, the relationship between those, although I don't think it's quite to the point of the judge has to actually apply these standards, but it is a related issue, right? If the cameras can't be in there because the public can't be in there's some crossover. As far as reliable hearsay, it is allowed at the preliminary hearing. The important thing for him is that we should all understand really what the purpose of the hearing is, and that it's just to move the case forward or not. It's not a final determination of anything other than whether the prosecution is justified. So if the court closes the preliminary hearing because of the use of reliable hearsay, he argues that swallows the rule of the public's right to be present. And this to me is a very good point. It is, because the rules are crystal clear. The prosecution gets to use this kind of evidence in Utah at this type of hearing. And so if the use of that type of evidence per se means that now we can't have a fair trial, then you are essentially saying in any preliminary hearing where they use reliable hearsay, the public can't be there and can't be informed about it. And that's far, far broader than, what the access rules seem to contemplate. He says the prejudicial effect of introducing exhibits at the preliminary hearing is different than at trial. They're not going to broadcast or publish the autopsy report, the lab reports, the 1102 statements. So they're going to keep this kind of away from us in the courtroom anyway, is what I'm hearing. The parties, it's going to be exactly what I just went through in LA, where the parties all get to see it and look at it and understand what they're talking about, and we don't. We sit in the audience blind because we don't get to see it. And I got to tell you, it's really not helpful. It does not fulfill this goal of engendering confidence in the process, because confidence in the process comes from seeing the work. Show your work. What have you relied on? And when we can't do that, and it's just trust me, bro is the antithesis of having confidence in the process, because it's transparent and I can see it working and I can evaluate it as it's happening. But that's what they're planning to do anyway. So everybody now is on notice. Don't expect to get a lot of substantive evidence out of this preliminary hearing. So he's saying that's mitigating the prejudice of, the public being there, because we're not going to learn that much anyway. They are asking for the exhibits to be sealed. He says the specifics of lab reports are likely to come up in argument. And there's a difference between hearing arguments on the evidence versus having direct access to the exhibits. I really don't know why. If we have to argue about what's in the ATF report in order to know if the ATF report or the substance of what ATF did is going to be admissible in court or not, then why is that fundamentally different than just reading the report for myself? I don't see it, but that's the argument. The judge says, since it's your burden to present the evidence at the preliminary hearing, do you anticipate presenting any evidence that would require closing the hearing? And Grunander says no, he doesn't anticipate testimony requires closure. They are presenting the 5 officers. They're relying heavily on the 1102 statements, on personal observations, on observations from other officers, providing foundation for exhibits. He says there is one video recorded 1102 statement from Lance Twiggs. We already knew that from the exhibit list and the witness list. He says, but there is no reason to close that portion. Are you not going to play it? Are you just going to give it to the judge and be like, Judge, it's an evidence, watch it for yourself? Kind of the impression I've gotten from how they have suggested this hearing is going to go forward. But maybe not. I don't know. We'll see. So the judge says that Grunander is pointing out we provided all the exhibits to the court, and the judge is like, yeah, by the way, I gave those back because I don't want to have any of the evidence before the hearing. That can create, potentially create an issue. Ex parte, considering stuff that's not part of the record of the hearing. You want to keep it clean. Don't create any question at all about whether the judge is going afield of what the parties are presenting or not. As far as 2 of the videos depict the killing of Charlie Kirk, he says they are sensitive because you're watching death. You're watching the violent killing of a human being. Let us not forget that. Let us not forget. You're watching the violent killing of a human being. This is not a good thing to be like all in, desensitized too, all like cavalier about, oh, you know, death. I want to see more death video. Like, it does bear some reminder that this is not good stuff. However, he says he wouldn't say it's as horrific as in Archuleta. Archuleta was a really freaking bad case. It was a terrible case, and that was a big part of the justification for sealing things off. Also, got to kind of look at the time and the context because this was this is quite a few years ago now. I don't even remember when the Archuleta decision came out, but it's been a while. And this involved gay stuff. It involved gay stuff, and we were in Utah. But yes, torture, bad, really bad case. And so that was part of their justification for keeping it closed in that particular situation. Also, I got to point out, Archuleta was before these whole court rules came about publicizing, court access and the sealing processes and all of that type of thing. Archuleta like predated all that. So I'm not 100% convinced that like all of the reasoning of Archuleta is still good law, because they have superseded that by the adoption of these rules. But anyway, he's like, but we could solve that by just turning the monitors away from the public. Just turn the monitors away if we gotta watch the video. Public can't see. I hate where this conversation is going. I really do. So then the media got their say, and they say, public, yes, right of access. By the way, I'll pull this up now because I did see this one and star it from all eyes. My question on that point is always, isn't the defendant's right to a public trial where the public's right to access proceedings comes from? Or is the public's right a distinction without a difference? These are different rights. The defendant has a right to a public trial under the Sixth Amendment. It's one of the enumerated rights that you have with a criminal trial, a right to a speedy and public trial. And so if the courtroom is closed to the public, the defense has often an argument in an appeal context that's a structural type of error, because this is a constitutional guarantee that they have to do all of this in public. The public's right to attend court proceedings arises out of the First Amendment. It arises out of primarily the right to petition the government for grievances. And it's just the general kind of philosophy that, yes, we get to monitor what our government is doing and talk about it. And so if court all happens behind closed doors, then that severely limits our ability to meaningfully participate in kind of what is one of the branches of government, kind of fundamental part of how justice is done in the country. So these are different rights. And I just saw that. And so wanted to pull that out and address it because, yeah, a lot of confusion about that, but it is very specifically the public's right of access under the First Amendment that has been recognized. He cites the press enterprise case. There's two press enterprise cases. Press enterprise 1, I think, I forget which order they are, but one is dealing with jury selection. One is dealing with the preliminary hearing. So let me go ahead and pull that case up. Here's where we are. So this is Press Enterprise from 1986. This is early 80s is when all this First Amendment case law is really starting to get fleshed out by the U.S. Supreme Court. So it's a U.S. Supreme Court case. And what did they do? They closed the preliminary hearing and then, litigated whether the party gets a transcript or not. That was the only remedy that was available in that context because, the hearing had already been closed. And so the public was already excluded. And the only possible remedy for that is to get some kind of access to the transcript to see what happened. So long decision about it. as they say, 41 day, 12 counts of murder, death penalty case, alleges that this guy murdered 12 patients by administering massive doses of the heart drug lidocaine. And so the Supreme Court, or the California court, initially closed the hearing. The court at the state level all said it's totally fine. So it went up to the U.S. Supreme Court, and the U.S. Supreme Court said there is a constitutional right of access. And this is where they talk about it. The right to an open public trial is a shared right of the accused and the public. It's not the same thing. It's related but different. So in Waller v. Georgia, they looked at the Sixth Amendment right to an open trial. And does that mean that you can close things over the defendant's objection? It says no, and also noted there is a First Amendment right of access that would, in most cases, attach to such proceedings. And so these are different but the same, similar, different but similar. And so this case, they're just pointing out this isn't a Sixth Amendment case. We are now dealing squarely with a First Amendment case. And so they look at two things in the First Amendment context. They look at whether the place and the process have historically been open to the press and the general public. Is there a tradition of the public being able to sit at this type of hearing, read this type of document, etc.? And if so, does public access play a significant positive role in the functioning of the particular process in question? Does it help for the public to be able to see it or not? And when it comes down to most like substantive aspects of a criminal case, it almost always is going to come down on yes, because of these benefits of transparency. And the situations where they've been inclined to say, well, no, not really, it's not really helpful, is typically when they're arguing about things like procedural stuff, stuff that just goes less to, is the person guilty or innocent, and more about things like, I don't know, should this person get, should there be a protective order on discovery? Like might be an example. So that's the test for the First Amendment. History and tradition of being able to see it. Does access play a significant positive role in how the process functions? So First Amendment had been first recognized in this Richmond newspapers in the Globe case. And so they conclude that this right of access applies to preliminary hearings as conducted in California. There's a tradition of accessibility. And the question is whether public access plays a positive role in the actual functioning of the process. Think about this. Like, the public has no role in a preliminary hearing and in whether there's probable cause or not. You're literally just there as an audience member. You're a witness to what's happening. You don't do anything other than just see what the parties are doing. So how does it bring, how is it favorable to the process? Well, because they've already said that public access to criminal trials and the selection of jurors is essential to the proper functioning of the criminal justice system. And California preliminary hearings are sufficiently like a trial to justify the same conclusion. So just like in Utah, if you're going to bring a case to trial, you can do it by grand jury, or you can do it by a preliminary hearing that establishes probable cause. So you have a variety of rights. If you choose to go with the grand jury route, which is confidential. But if there is a preliminary hearing, so it looks like in California, either way, even if you have been indicted, you still get to have a preliminary hearing. And you get all of these similar rights, like we see in Utah as well. You get to personally appear, have counsel, cross-examine, present evidence. This is a different one. Exclude illegally obtained evidence That is a restriction that they don't have in Utah. Utah, they say you don't get to litigate whether evidence has been illegally obtained or not. They don't want to have suppression issues, you know, basically complicating the preliminary hearing. So that is a distinction between their processes, but otherwise a lot of similarity here. If the magistrate determines that probable cause exists, the accused is bound over for trial. Such a finding leads to a guilty plea in the majority of cases. This is important, okay? It seems like a little bit of an afterthought, but this is important because it's going to why this is an important thing for people to be able to witness. It is true that unlike a criminal trial, the California preliminary hearing cannot result in the conviction of the accused, and the adjudication is before a magistrate or other judicial officer without a jury. But these features, standing alone, do not make public access any less essential to the proper functioning of the proceedings in the overall criminal justice process. Because of its extensive scope, the preliminary hearing is often the final and most important step in the criminal proceeding. As the California Supreme Court stated in this other case, the preliminary hearing in many cases provides the sole occasion for public observation of the criminal justice system. If Tyler Robinson pleads guilty, this is going to be the closest thing to an evidentiary hearing that is ever held in court. That's a big part of why it matters. This is like potentially the only opportunity we have for insight into the evidence and, you know, the prosecution's arguments and interpretations and things like that. Now, Utah has pretty generous public access rules, GRAMA. Pretty good likelihood that if Tyler Robinson pleads guilty, to the extent that things are not currently being publicly released because there's an active investigation going, the investigative exemption, is going to terminate with the closing of the case. Pretty good argument anyway. So it's very possible that, at least some of this evidence, public can get it through PRA kind of after the fact. But this is really not the same as sitting in a courtroom and listening to the case that the parties are presenting. Listening to the arguments in support of it, the arguments against the interpretations of things and so forth. In the absence of a jury, long recognized as an inestimable safeguard against the corrupt or overzealous prosecutor. Oh, overzealous. Yeah, prosecutors can be overzealous. And against the complaint, biased, or eccentric judge, we definitely know about those. Duncan v. Louisiana makes the importance of public access to a preliminary hearing even more significant. People in an open society do not demand infallibility from their institutions, but it is difficult for them to accept what they are prohibited from observing. Denying the transcript of a 41-day preliminary hearing would frustrate what we have characterized as the community therapeutic value of openness. Guys, the whole reason we have criminal trials at all is for the community. It's not something we do for victims. If we did it for victims, we would empower victims to do it themselves. We would have private prosecutions. People would bring their own criminal complaints and proceed like that. We don't do it. We have a set of rules that we've decided, we as a society, through all of these, complex representational government processes that we have adopted these basic rules, and it is in all of our interests to enforce and to vindicate the rights of people under those rules. And so it is to all of our benefit to see that justice is being done. It's for us. Community therapeutic value of understanding that this terrible thing happened and it wasn't supposed to happen, and here's how it did, and here's what we're doing about it, and then we can assess, Is this working for rehabilitative purposes? Is this working to sufficiently punish this person? Is this going to deter violations like this in the future? It's for all of us to be able to do that. That's the community therapeutic value. Criminal acts, especially certain violent crimes, provoke public concern, outrage, and hostility. When the public is aware that the law is being enforced and the criminal justice system is functioning, an outlet is provided for these understandable reactions and emotions. In sum, the value of openness lies in the fact that people not actually attending trials can have confidence that standards of fairness are being observed. The sure knowledge that anyone is free to attend gives assurance that established procedures are being followed and that deviations will become known. Openness thus enhances both the basic fairness of the criminal trial and the appearance of fairness so essential to public confidence in the system. We therefore conclude qualified First Amendment right of access to criminal proceedings applies to preliminary hearings as they are conducted in California. Does this not presume the ability to be able to evaluate the decision being made? That's the whole point. We'll have confidence in it if we can see how they do it. So if all we're allowed to do is sit in there and hear them say the magic words, I'm finding probable cause, I'm not finding probable cause, and we don't know what that's based on, we don't know if that's fair or not, we don't know if it's right or not, we don't know if the process is working the way it should or shouldn't. That's the problem. So the counter argument is, well, this stuff may ultimately not come in at trial. And so how is that fair to the defendant to have a big public hearing based on stuff that that ultimately the public, you know, isn't necessarily going to play a part in determining if he's guilty or innocent? And if it's, you know, really bad, then that could prejudice you and so forth. So how do you reconcile that? They talked about prejudice, what prejudice means. In Gannett, we observed Gannett involved suppression hearings. Motion to suppress, like literally the whole point of the hearing is this evidence something that the, you know, public should get to hear or not? And held there's a right of access. Gannett was a Sixth Amendment case, not a First Amendment one. But still, publicity concerning pretrial suppression hearings, such as the one involved in the present case, poses special risks of unfairness. The whole purpose of such hearings is to screen out unreliable or illegally obtained evidence and ensure that this evidence does not become known to the jury. Publicity concerning the proceedings at a pretrial hearing, however, could influence public opinion against a defendant and inform potential jurors of inculpatory information wholly inadmissible at the actual trial. This is the problem. Everybody's aware of it. Everybody recognizes it. But this risk of prejudice does not automatically justify refusing public access to hearings on every motion to suppress. Why? Because you have jury selection processes. Through voir dire, cumbersome as it is in some circumstances, a court can identify those jurors whose prior knowledge of the case would disable them from rendering an impartial verdict. And even if closure were justified for the hearings on a motion to suppress, closure of an entire 41-day proceeding would rarely be warranted. The First Amendment right of access cannot be overcome by the conclusory assertion that publicity might deprive the defendant of that right, and any limitation must be narrowly tailored to serve the interest. They know that this is an issue, but how else are you going to be able to evaluate the process as the First Amendment allows you to do? I wanted to go down that rabbit hole just a little bit because I did not like the media's argument here. I didn't like the argument that basically, you know, okay, great. Then don't share the exhibits. The exhibits are really critical to this process. So context-wise, there has been at the US Supreme Court level, there has been this kind of distinction in the case law between access to sitting in court hearings and access to court documents. And there's two separate things going on. We have, like what we just looked at, the First Amendment right of access. That is most narrowly construed as the right to go and sit in the courtroom and watch and see what's happened. There is separately recognized by the US Supreme Court a common law right of access to what is called judicial records. And judicial records are defined as basically those things that are part of the adjudicative process. And so if it's the kind of thing that the judge relies on in making a decision, there is a presumptive public right of access to it. And that kind of avenue for access to documents is limited by things like, if it's not about the ultimate case, if we're once again, we're litigating the discovery protective order, not necessarily going to have that common law right of access to it, because it's not going to bear on what the judge decides on guilt or innocence or not. But exhibits at any hearing are pretty squarely within what the judge is considering in order to make his decision. There was a case out of the US Supreme Court. It preceded Press Enterprise, I'm pretty sure. In fact, no, let me just look it up to be sure. Nixon versus Warner Communications. Here it is. Nixon versus Warner Communications. Yeah, it was 1978. So this was a case where, like, we have nominally at this point in time recognized that there is a First Amendment right of access to court proceedings and stuff like that, but it hasn't really been fleshed out and developed, and Press Enterprise is still in the future. And so in Nixon, what happened was this was involving a criminal trial of one of Nixon's campaign advisors. And he was being prosecuted for, I forget, like perjury, I think, obstructing maybe, some of those types of charges. And so the White House tapes, remember Nixon was taping all the conversations in the White House. The White House tapes were being used as evidence in this trial. And so parts of them were being played in court and stuff like that. And the media wanted access to them. And so the Nixon versus the Warner Communications court really didn't grapple at length with this First Amendment issue. But what they basically said is that the court has inherent authority to kind of determine how to handle exhibits, because the court is the custodian of the exhibits. Same kind of arguments we heard here. It's going to be disruptive. It's going to be difficult to manage for the media to get these things. But an issue that I think was really important as a fact in Nixon that is part of the reasoning for why the U.S. Supreme Court in that case said the judge can restrict access to exhibits, is because in that case there's a separate congressional act relating to presidential records that was going to make these tape recordings publicly available at some point through that process. So it's like there's already going to be a way of accessing it. By the way, the press had received transcripts of every single one of the recordings. Like, these were specially prepared for the media. Obviously got to report on anything that was played in the courtroom that they actually heard. But they wanted more. They wanted, the recording so that they can hear tone of voice and things like that. And so in that particular case, the Nixon court said, besides the court being the custodian of the exhibits and having discretion to decide when and how to give access, there's also this other legal mechanism to get it. It's not like essential. This isn't the only way that you're going to have access to these things. Well, that's really not our situation here, is it? I guess there's grandma. Is that the argument? There's grandma. And so maybe someday we would be able to get access to these exhibits. Kind of doesn't sound like that under the defense's argument that these things are private under the rules. And so there's limitations on public disclosure. It's all quite murky to me. And I've gone down this rabbit hole so many times because there is a lot of difference in the different federal circuits about like, when do we look at court documents as a First Amendment issue versus when do we look at it as a common law right issue? How do those things compare? What does it mean? How does it all play out? Some jurisdictions just, default knee jerk cite this Nixon versus Warner Communications case, say, no, you don't get exhibits. Others go through the history and tradition, analysis of the First Amendment right of access. Is there a history and tradition of access to this particular type of document? If there is, then you go down that road. So there's just a lot of inconsistency all over the place with how these things get fleshed out. But from my perspective, Nixon is a very limited case for those reasons. One, it predated a lot of this, what was coming out in Press Enterprise and these other cases dealing with the First Amendment right of access. And it had this, other alternative way of getting the information that the media wanted. And lastly, the media was already getting substantively what the court was going to rely on to make the decision. Because it was, getting the transcript. It got the transcripts of the recordings. So it's not like a situation where we're blind about the basis for the court's decision. That to me is very different from where we sit in Tyler Robinson's case, where what's kind of being suggested here is we're going to have a hearing where evidence will be presented for the judge to make a decision about whether the prosecution is justified in going forward or not. And we are not going to get to know why. Regardless of which way he decides. He decides, yes, it's enough. He decides, no, it's not. We are in a trust me bros situation because we aren't going to be allowed to see what he's basing the decision on. And that can't be reconciled with this reasoning of transparency promotes confidence in the process, allowing us to see for ourselves. The fact that if Tyler Robinson pleads guilty, if he did, this would be like the closest that we get to understanding the case against him. That to me is real important. Because boy, if there was a plea, there's going to be a lot of thoughts and opinions about that and why. And is it a good idea? Is it justified? Major topics of conversation. And we're not apparently going to really be able to get any insight into, well, how good, was the case against him and what were the odds of conviction? And I don't like it at all. So that was a sideline. I'll go back to my recap of what the media was saying. Points out, often the sole occasion for the public access to the proceeding. Whereas closing the hearing perpetuates ignorance of the facts in the case, the process. It cuts off a full understanding of the criminal justice process. Yeah, if we're just here to be like, okay, I guess this prosecution gets to go forward because the judge says so, that's not really helping people understand what is probable cause. How does this evidence meet that standard? Why is the decision a good decision or a bad decision? You're just having to accept the decision and go with it. So when seeking departure from the any constitutionally recognized right, the defense has to identify the specific evidence that is likely to be problematic and the reasons for the closure. And then the court has to make specific findings about that. He's arguing that's the Kearns Tribune requirement. And so the wait and see approach, he says, won't work because you got to make closure findings. You can't just close it on a whim. You're going to have to make specific findings, and doing that on the fly is probably not going to be feasible. He says he can imagine specific evidence or testimony that would warrant closure, but the burden is on the party seeking closure to identify it. And frankly, that's where I thought we had left off with this particular motion was that the defense was going to have to identify specifically, and then they were kind of going to go back and forth about that. But it seems that is not how they have decided to go forward. Media says the party who wants the closure needs to show the problem with the publicity, and they need to show, these are the Kearns Tribune factors. They need to show the effects of potential jury procedures to address prejudice. He says you hear about things during pretrial hearings. It's normal. Hear about evidence, hear about case. And the ordinary presumption is you deal with it by jury selections, what we just read in the Press Enterprise case. So the party seeking sealing needs to show why this isn't enough. He turns to Archuleta and says, well, this is a different type of request. In most cases, the media wants to occupy the role of sitting in the courtroom. They just want to be the proxy for the public who is there in court and report about it. So he says, well, the public wouldn't be allowed to hold an item of evidence or copy it. And that's what's at issue in Archuleta. And the court said, we'll treat that differently. And we don't seek hands-on access or copying to any of the exhibits. Why the fuck not? What are you here for, if not to provide the information about the case? You're not going to ask for the exhibits? What's the matter with you? You're not functioning very well as a media if you're just here to show us what the camera is going to show us anyway. And that's going to bar any deeper understanding of why what is happening is happening. I couldn't believe that. So media is throwing the exhibits away. Media is not going to fight for the exhibits. We are once again in the boat of relying on Judge Graff to be the advocate for public access for us. He has before, right? When everybody was like, sure, go ahead and close off these parts of the disqualification hearing. No problem with that. The judge says we're not doing that. He threw away everybody's stipulation, including the media's. We're not doing that. We're taking it case by case and we're dealing with it accordingly. So we, I guess, still have some hope that the judge will do that with respect to the evidence and the exhibits, the things that he is going to rely upon to make his probable cause determination, which is going to be very controversial, whichever way he decides it. And so is there going to be facts that underlie it that people can talk about or not is kind of the bottom line as I see it. But the media is like, hey, we don't care about copying the exhibits. And apparently, they're not going to show them in the courtroom. So you would normally want to get a copy. It's what I'm doing down in Alice Evanson's case, down there in that divorce from hell. Yeah, I have a right to see the exhibits. There is a right. In the Ninth Circuit, they look at it more under the First Amendment than under the common law right, but they do recognize both. And these are adjudicative materials, things the judge relies on to make the decision. So I have a right to see them. So I'm asking for them down there in LA. You media aren't going to ask for it here in Utah. It's just wild to me. I'm just continue to be less than overwhelmed at the media's kind of continuing function in modern society. So he said that the cleanest path is to just say that what is presented should be open unless there's a specific exclusion that's required. That's the constitutional kind of default framework. Final admissibility at trial isn't a bar to public access, and being careful isn't a justification to close the entire hearing down. Ms. Visser got her reply and she said, they proposed the solution that kind of portions could perhaps potentially be preemptively closed and then, the rest opened or something like that. But she thinks that there does need to be caution as far as admitting some private or safeguarded exhibits. And she's at least assured we're in like the most Mormon court ever, that the state doesn't intend to do an end run around those restrictions. They can actually like engage in good faith with each other, it seems, so far. So it's not always a universal, guys. It's really not. Like, I cannot emphasize enough how like watching this process, this to me as a defense lawyer, this looks like a good prosecution team to be working with. And they seem to like be continually telling us this, you know? Problem with discovery isn't the state, it's their experts. The state's not going to try to, you know, do tricky stuff, which they probably could from a gamesmanship standpoint. Oh, it's, you know, sealed if I admit it as an exhibit, but if I just have somebody read it on the stand, it will be open. And so there are so many prosecutors in this country who would play that game and make the end run. They don't have that concern about this particular prosecution's office. So I don't know, whatever that's worth. As far as the electronic media coverage, she's like, that's not before the court yet. It's going to come up. There's a whole process now to deal with that. And so it's separate. It's a separate issue from closure. And so that was our recap of our arguments today. We will be getting the ruling June the 1st at 10 o'clock a.m. on WebEx. And then we are having the next evidentiary hearing on June 12th at 9 o'clock. That will be on the argument on whether hearsay, using reliable hearsay in Utah is a Sixth Amendment problem. And if they do the evidentiary hearing on the order to show cause, they will be doing it there as well. I predicted they will. So I'm expecting it, but we'll see how all of that unfolds. Yeah, another day, another bunch of disappointment with the press. What else is new? See what you guys have been saying. Nick Stero, tool mark analysis is a shit science. You know who knows how shit it is front, back, sideways? Michael Burt. Michael Burt. We talked about this in my last live when we watched just looked at his background, watched the closing argument that he gave in Lyle Menendez's case way back in the day, 33 years ago now. Anyway, he was one of the first people to litigate how shit it is back in 2009, like back when the National Academy of the Sciences criticism was fresh off the press. He's out there arguing that it's a shit science and shouldn't be used. It's not that it's completely trash. I mean, there is some logic to the idea that a thing will produce marks, right? A hard thing will produce marks on the softer thing. And at least a possibility that perhaps those marks might be distinct, maybe only in some cases, maybe in other cases. That's where the gray area is. And that's where the problem is that we don't know how distinct the marks are or are supposed to be. And so there's really no way to assign strength to a conclusion that like, oh, these marks are really similar. But that doesn't stop them from going into court and testifying. These marks are so similar that I've decided no other firearm could produce these marks. And the only basis in the standard that these analysts apply for thinking that is just the fact that they think that based on their own experience. So it is a shit science. I pulled this one up. Snarkastic Sam. Some prosecutors need a refresher on the zealous advocacy of the truth, in my opinion. Yeah. Absolutely. I mean, how many days go by without hearing about, some exoneration or some, other just issue, a trial getting bombed because of prosecutorial misconduct? They've withheld evidence. They falsified things. They're just so focused on winning that takes precedence over justice and over truth. Could not agree with that more. Boundless Millennial, I'm sorry, but the fact that they decided to go to the media violates the order. They should have put it in a filing. They are trying to Alan Jackson this case. I would turn this back around. What if Alan Jackson wasn't able to say anything at all? What if David Yannetti wasn't able to say anything at all? Where would Karen Reed be? I mean, she had Turtle Boy. Okay, she had Turtle Boy to like be able to pick up on the court filings and things like that. Most people don't. Most people don't have that. I get it. I really do. I'm just so on the fence about this because I want the same standard for both sides, and I want the defense to be able to speak freely when they think that it's in their interest. I don't want them to have to pre-vet it with the court. I don't want them to have to launder their public statements through court filings. But, if I'm going to let them do that, then it's hard for me to say the state shouldn't be allowed to do that as well. And I'm much, much more uncomfortable with that state of affairs. So hence my, my ambivalence about this motion. And, I guess my gratitude that this is outside of my pay grade. Judge Graff has to make the call, not me. Jen U. Wine, welcome to the channel, Jen. Thank you for joining us. Sean is here, potentially criminal. The Sixth Amendment mandates that one party is entitled to a fair trial. If the public doesn't like the state, oh well. Yeah, yes and no. Yes and no. It's absolutely true. Sixth Amendment right is an individual right, and there is nothing in the Constitution that says you, the state, are guaranteed the right to a fair trial, and that there's like some kind of remedy if you don't get that. But it's really not in our interest, societally, for the state to not get fair trials. I mean, if trials have a reason at all, then if the state isn't getting a fair shot, then the function, the process isn't functioning the way that it's supposed to. It's not giving us the community therapeutic, result that is at least ostensibly the purpose for it. So, I mean, this is one of those things where, yes, technically 100% agree, no question. Nothing in the Constitution says you, the state, have the right to a fair trial. But at the same time, I don't think it's quite fair to say they don't have something, at least similar. It's in all of our interests for there to be fair trials for everybody. But yeah, this also, this goes to what I was saying before about the kind of the presumption is a little bit different because the defendant has the prejudice is a little bit different because the defendant has the right to be presumed innocent. Hey, if there's misinformation out there that inclines the public to think that he's innocent, that's still kind of more consistent with a fair trial than with there being bad evidence out there that makes them think he's guilty. To Truth for Liberty. Question: if all the people, state, society, etc., are the prosecutor's client, why do so many clients want the prosecutor to fail in quite a number of cases? Oh, it's the prosecutor is a representative, and so that means they can be elected by 51% of the public, and then 49% of the public doesn't feel represented by them, doesn't feel like a client of them. It's kind of normal for a political position. But there's an old saying that is the difference between defense lawyers and prosecutors is that defense lawyers have clients and prosecutors have cases, and it's really the difference. You'll get a lot of variation as well with prosecutors' offices in terms of how closely do they work with witnesses and victims and stuff like that. Like, there will be places and there will be prosecutors who will show up for trial having never talked to any of their own people. They've just read the reports and they've, expected certain things based on what happened in the past. And they have kind of, I don't know, I guess imagined in their minds sometimes, filling in the gaps of the report. Like, so how does this person present and how is this person going to come off? If you're just reading a statement that somebody gave to a police officer that's written down in a report, you have no insight into that. Like at a bare minimum, you really should probably chat with your witnesses to get a sense if any of them are like a major train wreck waiting to happen. But I'm just here to tell you, it's not really that uncommon that they never do. And oh man, the whole like idea that prosecutors represent the victims. This is like a whole other category, because the one time you will see absolutely crystal clear that that's not the case is in the DV case, where the victim doesn't want to cooperate and they'll subpoena them into court and they'll get a material witness warrant and they will throw them in jail to force them to testify against their will. That is not representing that victim as an attorney would do. This is representing something else and using the victim as a means to that end. So no, it's really not. I mean, to the extent that they represent the public as a whole, that is an ambiguous thing that already doesn't encompass 100% of people. At best, it's like I represent the majority of the voters. But even then, you're just talking about the elected, the people that are actually doing the line work in the office. They were just hired. They're just kind of your ordinary civil servants that don't have any accountability like that. So it's a complex thing, the whole prosecutors role and who and what they represent and whatever. CH, what would be the sanction or remedy if Ballard is found in contempt? That's a great question, because we haven't heard any of that, have we? We haven't heard really anything to suggest what the remedy might be. The defense hasn't proposed anything that they've suggested. Remedies could be things like he gets booted off the case. Remedies could be things like maybe he has to issue a corrective statement. Is there something to correct? Does that re-ring the bell, so to speak? Sometimes it's kind of like the limiting instruction you get in court. You don't always want it, because all you're doing is reminding the jury about, what they heard in the first place that you would rather they hadn't. So they're going to have to sort that out. If he is found in contempt, what's the harm and how do you remedy it? And that's frankly one potential out for the judge as well, to be like, yeah, there's a violation here, but what's the remedy? The remedy is a jury selection, and that process. Maybe the remedy can be it's not uncommon for there to be remedies to like be able to ask additional questions and jury select. Like, it's just that's all so far down the road that it's kind of hard to contemplate what might be appropriate when and if they ever get to trial here. So this is a great question, and it's not one that I think any of us can answer at this point. Duncan, Idaho, Big Lebowski reference tax. Dude, always. Just your opinion, man. Duncan, Idaho. It was really eye-opening to me how many of the people I grew up with were either tongue-in-cheek or outright celebrating after what happened to CK. Also very alarming and disappointing. I've been thinking about this kind of thing a lot lately, and I'll tell you why. I've really had the sense of what Scott Adams used to say, and I just feel very strongly he would be saying if he were around to be saying things today about people watching different movies. That people are watching completely different movies in this case. And I will share with you part of the reason why is this. Oops, let me get it up here. This here. I got, or I saw, I guess I should say, this post from Kara Winicki's law office. Kara is one of the attorneys who was involved in the Richard Allen case. I have so much respect for Kara. Admire her professionally, like through the roof. I think she's an awesome person. And she is clearly like super perplexed with my take on the case, just as I am very like perplexed with hers. And so I didn't want to get into like a I don't know, smear match or just, the yelling back and forth that all too often Twitter stuff can devolve into. But at the same time, I respect Kara so much that she warrants a response from me, but also a careful and considered response. And so I wanted some time to kind of let this sit and let me think about it a little bit before I responded to it. But I do want to respond to it again, just because I respect her to such a high degree. So this is a repost. She's reposting this basically. I did all of this stuff in Richard Allen, reported, etc. That's why it's so hard to understand her stance on Tyler Robinson. There's so many gaping holes in the Fed slop narrative, so many red flags. But Andrea goes above and beyond to try to explain them away. A state conspiracy was plausible in Delphi, but it's a ridiculous premise in Orem. I'd argue it's more likely to have more corruption involved. So Andrea, I'm just really struggling to understand why you're so quick to shut down any indication that the Fed slop narrative is just that slop. You have the same attitude toward people questioning Tyler Robinson's guilt as others had against you for questioning Richard Allen's. So she wants a collaboration with Barron. I'll just tell you right now, I don't anticipate that happening because I limit my engagement to what I consider to be in good faith. And I don't have a lot of trust that there would be a good faith engagement with Barron, but I have absolute trust in Kara for good faith engagement. So she responds to this. She says, I am struggling too. I assume the well-intentioned on the FBI side of this narrative really liked Charlie and want to see justice. I have probably watched every debate Charlie ever did. I live the art of debate and he was good at it. I disagreed with his position, but I appreciated the fact he brought the art of debate back. I never met him and never attended an event, but I bawled like a baby when he died because he was so young. I want justice too, but the narrative is too neatly packaged and there are way too many holes. This feels like a wrongful conviction in the making, and it has all the signs of a classic railroading. I understand people in the true crime community eating the slop, but criminal defense lawyers? No, we are skeptical by nature. It is one of our greatest skills. Question everything, check and double check it all. I just read a transcript today where a lawyer told the court that he had no reason not to believe something a prosecutor said, but he needed to check it out for himself. That's just good lawyering. I understand not believing Israel or France or Egyptian planes or the White House is involved. But when do we ever take what the government says at face value? The reason why this got me thinking about the whole idea, the Scott Adams says idea about the watching the different movies. There's a lot of things in this post that kind of highlight that for me. First off, the emotional aspect of this case is very emotionally charged. A lot of people felt very strongly when Charlie Kirk was killed. A lot of people had very strong feelings about him, very strong feelings about what happened to him, who was responsible for it, what, kind of culturally was going on that led to it. And it's that part of your comment that got me thinking about this, this comment from Kara in the first place. Because this was my reaction to it. I also I can't stand politics, guys. I hate politics. To me, it's like one of the most superficial ways of being able to engage with other people and evaluate their thoughts and opinions and stuff like that. Like who somebody votes for is to me just a not particularly good proxy for, are they good people? How do they think? What do they believe? Like most people are just more complex than, are you a D or are you an R? And I think is probably particularly the case for somebody like me who doesn't really feel like I have a political home. Like I don't agree with the R's, I don't agree with the D's. So what do you have left in our system? You're just kind of stuck, stuck out here without anything really to work with. And so, but what affected me about Charlie Kirk's killing, which I was also, unfortunate enough to log into Twitter on September the 10th and see for myself happening on video in front of my eyes way too many times than I would really want to. See Charlie Kirk getting killed and then see the reaction to it. And I'm with you, Duncan. I saw, the celebrations. I saw the T-shirts. I saw the jokes. I saw, the cartoons. I saw all of this making light of something that destroyed a family, destroyed a human being, took him away from his kids, took him away from his wife, took him away from the work that he was doing, that whether or not I, agree with it being like good and valuable work, at the same time was obviously very important to a lot of people. And just because I think, politics is stupid doesn't mean everybody else does or should or anything. So it was a really big deal. And that's how I emotionally engaged with the case. And so I do think that might be a little bit different than, people who were more perhaps attached to Charlie or, have more of a like grieving for Charlie kind of response to it. So it makes sense to me that if we've got different like emotional ties to the situation, that's going to be affecting the movie that we're watching in different ways. So now, what about this is about the movies? This right here is where I'm like, we are watching different movies. We are watching different movies. The narrative is too neatly packaged. There are way too many holes. This feels like a wrongful conviction in the making, and it has all the signs of a classic railroading. I couldn't see like less evidence of a railroading if I were going to like write it as a script. This is so different from Richard Allen's case in my view, like the movie that I'm watching. This is so completely different. We have a judge who is amazing. Okay, who is awesome. He's been so fair, bend over backwards fair, bend over backwards patient, gives the defendant massive benefit of the doubt, lenience, treats everybody respectfully. No indication at all that like their ability to do their job is being affected by this judge at all. My read on the situation. He has outstanding lawyers. Okay. Some of the best lawyers in the country for capital litigation, Michael Burt, Richard Novak. They're at the top of the game. They have a contract which allows them to basically go out and do their own investigation without having to do the whole thing where you go to the court and convince the court to give you money to be able to go hire an expert and stuff like that. This was how Gull was able to limit a lot of what the defense was able to do. No, I don't think you need a forensic pathologist of your own. Not a good use of public funds. I don't think you need that much investigation of the cell phone forensics. You can have a little, but not more. She was able to play all of these little games with the right to the defense by controlling the purse strings for the investigation. They don't have that in this particular case. Richard Allen's case, very first act that the defense attorneys did was that press release of, here's more to the story, and here's the bigger picture, and here's who Richard Allen is, and here's the stuff that the state didn't tell you in the probable cause affidavit, and so we're asking you to keep an open mind. And of course they got, slammed by the court for doing that, but they did it. And that's kind of the reason why maybe there was a little bit of skepticism about that case from the outset because the defense lawyers are telling me there's a problem with it. I don't have the defense lawyers here doing anything remotely equivalent to that. Now, yes, there's a gag order in place. The gag order didn't get entered in Richard Allen's case until after he made that statement. You have all of your pleadings. The defense filed a massive Franks motion, for example. We haven't seen any of that from the defense. What we've seen is like the one instance where we're having a hearing on something kind of unrelated, on the motion to disqualify the prosecuting attorney's office, and Kathy Nestor slips in through the question. Didn't you know were you aware that the evidence, the DNA evidence found at the scene was a mixture of 5 different individuals? That was new information I didn't know before that was dropped into the record. That's kind of a common thing to do. If you've got something good, you use it. And we're not getting anything like that from the defense. So one of the counter arguments to this, I understand, is where we are at in the process. We are still pre-preliminary hearing. And like they just talked about in this hearing, preliminary hearing, you don't have the right to exclude evidence on the ground that it was improperly collected. You don't get to raise suppression issues at the preliminary hearing. But that doesn't mean you don't get to raise any issues at all. We have already seen the defense has raised two motions in limine dealing with the preliminary hearing, asking for, evidence to be not used for a variety of reasons. Hearsay is, unconstitutional under the Sixth Amendment. This is, like I said before, this is an argument they are plainly going to lose under Utah law. They are literally doing this just to paper the file. But if there was evidence of fraud in the production of like the Discord messages and so forth, I don't buy that a competent defense team isn't going to raise that in any way possible at every opportunity that they can, both because, one, the duty of zealous advocacy and the ability to get your client a fair trial does, at least to some extent, contemplate the public perception of all this stuff. If the jury pool is getting a tainted, incorrect view of the case, and you've got something that's going to set it right, and you have a mechanism to do that, I feel like you would. Brian Koberger's lawyers did. They took the opportunity to file in their court pleading that, like, hey, it's been months since they did all of these additional search warrants, since he was arrested and so forth. And by the way, did you know they found nothing, no connection with the victims, no victim blood or DNA in the car, in his apartment, anywhere. They found nothing. And so the defense called that out in the pleading, not because it mattered to what was being litigated, but because it mattered very much in the court of public opinion. So lawyers can do this anyway. But the fact that these particular lawyers, like, they have shown they are not helpless. They don't look at this case as like, oh, well, the Utah rules say that reliable hearsay gets to come in, so therefore throw up my hands and let it come in. No, they will literally litigate that with an eye to future federal review. I cannot imagine a scenario. I just can't, as an advocate. And I honestly, because I have so much respect for Kara, I really do think, like, Kara, if you were litigating this case, I know that you would do these things because you're a damn good lawyer. You would absolutely be litigating prosecutorial misconduct, due process violation. You would be making these arguments to draw attention to the fraud that supported this prosecution. You would be like shouting that at every opportunity. You would be coming up with every creative legal argument to be able to flesh it out. That's what a good advocate would do. So to me, the movie that I'm watching where the defense is not doing any of those things, that's a big deal. That tells me a lot. And that's not me taking what the government says at face value. I have no idea. And I've like said from day one, I'm just assuming, if we assume the prosecutor is going to be able to deliver on what they say they have, here's what the problem is going to be. But I'm really going to defer to the defense on what the defense is. And that's a part where it's hard for me to contemplate as a defense lawyer. If like the world is out there constructing defenses for me, that's not necessarily a helpful thing, because people are now expecting me to deliver on stuff that I may not be able to deliver on because the facts may not be there. If people are going to come into this case and expect the defense to be presenting evidence that the feds made up Discord chats and things like that, and then I'm not able to deliver that because that's not true, there's one of two ways that's going to go. People are going to be like, oh, guess I was wrong. Or people are going to be like, oh, the defense lawyer is in on it. The defense lawyer is now one of the nebulous they, who is, the suspect, the real suspect in all of this, the they, because there's nothing more specific. So now the defense lawyer is part of the they. Is that helping me? Is that helping me, the defense? Is that helping me do my job for my client? What if my only case here is mitigation? How are you helping by making up a defense that doesn't exist, by stepping on my toes? I don't find that helpful at all. That's a big part of the movie that I'm watching. And so the last thing that Kara said that I agree with 1,000,000%. 1,000,000%. Yes, defense lawyers are skeptical by nature. That is literally our entire job. And I'll tell you how that works for me. When I am looking at and analyzing a case and figuring out, what do I think? What's a good defense? Where do I go? And stuff like that. It's always comes down to what is reasonable doubt. And the framework that has just always worked for me in terms of thinking about that and communicating it to juries and so forth is the existence of plausible alternative explanations. Plausible alternative explanations have to account for all the facts, not just some of them, not just ones that are really convenient. It has to account for all of them. But if you can do that, if you can come up with plausible alternative explanations of the facts, example that I gave earlier in the show here, there's DNA on the firearm, but no fingerprint. Is it a plausible explanation that the DNA was transferred by the real shooter, by environmental contamination, whatever, because a fingerprint would be there if my client put the DNA there by pulling the trigger? I think that's plausible. Ultimately, it's going to be the jury that decides. And so that's what I think for me anyway, as a defense lawyer, what I am doing is I am engaging with claims that are made. And so this is where then we have a little bit of a difference between I, as a defense attorney, am defending against the state's claims. The state is claiming XYZ happened. And I'm saying plausible alternative explanations for the evidence. You can't prove that. But then there's also things like affirmative defenses, where now I am affirmatively asserting something. I am saying this is self-defense. That's not necessarily the greatest one because the state does have to disprove self-defense beyond a reasonable doubt, but I have to raise at least some evidence, right, that suggests it was self-defense. Maybe a better one would be something like involuntary intoxication. Okay, I'm not legally responsible because somebody, spiked my drink, and so I wasn't making voluntary, decisions and things like that. I didn't have the required mental state. I am not legally responsible. I have the burden to prove that. And so I am now in the position of the prosecuting attorney, having to rule out plausible alternative explanations for all of the facts. And so if my client, is on video not drinking anything the entire night, then that's not going to be a particularly good theory. It's not going to explain all of the evidence away. If my client, is on video, completely rational and coherent and doing field sobriety tests and pass them all, just example, probably not going to be the best theory because now I can't rule out all of the plausible alternative explanations. What I am seeing in this case in the movie that I am watching is I am seeing a lot of people, a lot of commentary that is acting like prosecutors, making a lot of accusations. And many of them aren't particularly specific because, again, I've never seen, and I invite an alternative, plausible alternative explanation that accounts for all the facts. And not just cherry picking things out that, may or may not be good evidence anyway. Things were being searched in Israel, that's not how the Google stuff works, just by way of example. Even if things are being Googled in Israel, you still need to provide a mechanism that explains the evidence we already have, which, if we take it on faith, to the extent the defense isn't arguing with a lot of this stuff, video evidence and so forth, has Tyler Robinson on the roof where he's not supposed to be, has him making statements you wouldn't think he would be making, has him surrendering himself as the shooter. You need to account for all of those facts as well. And so what I'm seeing is I'm seeing a lot of people acting like prosecutors, okay, making accusations that have not ruled out plausible alternative explanations, which can often be as simple as there's some human error in every human process. Human error is often going to be a very plausible explanation for things like, oh, I don't know, what do bait stamps say? This is why I don't care at all about some bait stamp argument as support of fraud, because it's always going to be plausible. Somebody just wrote the wrong thing down, or somebody just cut or pasted the wrong thing. Extraordinary claims require extraordinary evidence. And so for me, yeah, if you're going to be accusing people of fraud because I'm a defense lawyer, I don't like accusations. You better be pretty damn sure. You better have ruled out the plausible alternative explanations. I don't like when people call people liars, because there's a lot of reasons why people can be incorrect about the facts. And not all of them are malicious. And frankly, a lot of times, even like we saw with this whole inculpatory versus exculpatory, even what's a fact versus what's an opinion or an interpretation is often a bit muddied. So I don't like people jumping to make accusations of wrongdoing and fraud and lying and so forth if they haven't ruled out the plausible alternative explanations. And that's what I see in this case. This is why I am as baffled by Kara's position as Kara is baffled by mine. because that's a prosecutor's mindset to me. Why would I not be just as skeptical of those claims as I would be of the state's? They're not like uniquely bad just because they're the prosecution. This is just the nature of evaluating information and trying to figure out what the truth is. The defense team does not have any kind of monopoly on truth. I mean, far from it. So that's how I wanted to respond. I just have to reiterate for the last time, I have so much respect for Kara. I'm not at all going to tell her that she's wrong. I just disagree. We're seeing very different things when we're looking at this case. We are watching different movies. I think these are some of the reasons why, and I just wanted to take the opportunity to share a little bit about why I see my perspective on this case as very much being consistent with the defense lawyer's perspective. I don't think that automatically means I'm on the side of not guilty. You wouldn't be a defense lawyer. You wouldn't be a good defense lawyer if you looked at every case starting from, the defendant is not guilty. You got to think about whether you're going to be able to prove that or not. What's the evidence for it? What's the evidence against it? What's a jury likely to do with it? What are potential problems with the evidence that I could poke holes in? What are the likelihood that I would win that motion or not? All of these types of evaluations go into the strategy of how you handle the case, because I got to advise my client. And if my client shows up at arraignment and he gets a plea offer from the prosecution and they say you have 10 days to decide or it's off the table, I don't have time to do like the full, litigate the entire case and know where we would stand when those decisions are made. You have to be able to predict and project as best as you can, or you're not going to be able to give your client good advice. So it doesn't mean taking everything, in the defense favorable light. It just means, what are the plausible explanations for the evidence that we have, the facts that we have at this point? The facts are allegations, right? They haven't substantiated any of this, but they're going to have to. And we know the implication of them asserting this as fact is that if they don't substantiate it, that's going to be called out. It's going to be caught, guys. Somebody fabricating Discord statements, that's going to be caught. You can't fake a cell phone extraction. You can't go in and fiddle with it. And so where does that leave you with? I guess what, somebody had his phone and typed it in his phone. You're going to have evidence from your client. Maybe you won't be able to use it. He's got the right against self-incrimination, but you're going to have your client's perspective, his story about what happened. You're going to have the video of what happened in the police station. It's about plausible explanations for things. And we just have a big difference of opinion on that. And I think the core of that, some of it, I think, just relates to, again, this emotional aspect of this case. The fact that my emotional response is very different from Kara's emotional response. But also just different things are going to be a point of focus. And I happen to know, from previous conversations with Kara, I know that she's extremely skeptical of the idea that this was caused by a 30-06. And I understand a lot of people are skeptical about that. I'm not particularly. I will wait to hear from the medical examiner. But to me, it's like, it's not impossible. Might not be the high probability outcome, You know, you wouldn't necessarily, you know, if you're staging this crime, say, you know, anticipate that this is how it would come out. No, it probably wouldn't. It's not the high probability outcome, but that doesn't mean that uncommon things, rare things don't happen. They do. And they can. And to me, you know, bullets, rifle bullets fragmenting are not a rare thing at all. It's so common that not only the forensic pathologists know the signature, you know, the lead snowstorm, they look for it on the x-ray. The wildlife pathologists have been studying this for decades too. Why? Because they're interested in lead poisoning. So they need to know what bullets do, and they need to know things like, you know, you shoot a deer and your bullet fragments. How much of that meat do you need to clean out? You know, you need to trim to avoid the risk of, you know, ingesting lead or something like that. So these to me are not, I don't know, it's not something I'm particularly skeptical of. And so I will wait and see. I will see what the medical examiner has to say. I have expectations, which I've stated based on the totality of the facts that we have so far, that I think they're going to continue to tend to corroborate the things that, in my view, have so far already tended to corroborate the state's theory of the case and the evidence that they have. And if that's the case, the autopsy is probably going to show us lead snowstorm. And if not in those specific words, we're at least going to see, you know, we're going to see medical evidence. So that's where we're at. We're watching very different movies. I think that is some of the reason why. But I, like you, Duncan, I also was very alarmed at the reaction that I saw. I was very disturbed and troubled by it. It's one of the reasons, just seeing the processing, you know, that was happening in public. It's one of the reasons I decided to follow this case in the first place. Because I knew right off the bat a couple things. I knew that, number one, this is very politically charged. And because of that, it's going to be more prone to misinformation. People are going to want to use it for their own purposes. So it's that much more important to get the accurate story of what's going on in court, what the process actually is, and what these things mean. But also just because I was aware of how emotional this whole thing is in so many different ways for so many different people. And I'm not going to I don't know. I'm not going to pat myself on the back huge, like, oh, I can turn down the temperature or anything like that. No, I don't expect that. But I do think I can help present this and talk about this stuff in a way that is not really emotional. Just because that's literally what you learn to do as the defense attorney, compartmentalize and just try to look at things as objectively as you can. So I may not always get it right. I'm definitely not making any claim to perfection, but shared that perspective, reminded me of that response I wanted to make to Kara, and reiterate for the last time, she is amazing. I think highly of her. I hold no difference of opinion against anybody. Respectful disagreement is like one of my favorite things. It really is. It's being assholes about stuff that I'm not a fan of. But when people can talk about stuff in good faith and openly and directly, I think that that disagreement generally makes us better. Maybe you guys agree with me, maybe you don't. It is what it is. And at the end of the day, this case is going to unfold how it does, and we'll see. We'll see. Nope. WMO pan. I can't say that. Nope. Yeah, can't say that one. Sorry, but The argument I'm hearing from one side of this is government did wrong in one case state, therefore government in other case state is doing wrong without analyzing it on a case by case basis. Every case depends on its facts. I see a lot of like, you know, people will be like, oh, that Burkhart, you know, she's always so like pro defense, and then like literally I'm not. And it's somehow that's like bad on me or something. I don't know. The cases that I have looked at up to this point happen to have been cases where I'm a little bit skeptical about the proof, and variety of reasons why. The proof in and of itself is real thin. There's plausible alternative explanations. The defense team is telling me I should be concerned and that there are problems here. You know, I can see for myself when I have John O'Keefe's autopsy photos that like this man was obviously beat up and chucked on the lawn. Like, who on earth is trying to say this is a car accident? It's ridiculous. Plausible alternative explanations. Every case, yeah, depends on its facts. And so I feel like it would be extremely not just bad commentary, but bad analysis, bad logic. It would be the definition of biased to just be like, oh, I must be on the defense side because there's a case. No, everything depends on its facts. I assure you I was not on Darrell Brooks's side just because he was the defense. There are plenty of cases that I look at and I'm like, yeah, even ones that are close. The ones that are close are probably the hardest for me because they don't come down to whether there is any alternative explanation of the evidence. They come down to, is that explanation plausible? I'm already kind of anticipating this with Murdoch because I didn't watch the first trial, right? He's going to get retried. I'm going to kind of be forced to watch it. I think maybe I'll get lucky and get to watch it with Ian Runkle and he can fill me in on the stuff that I'm missing. So I don't know all the ins and outs of the case. I only know little bits and pieces that I was able to pick up. But that's kind of what it seems like to me, is that it was largely a circumstantial case. And so the question is, how plausible are the alternative explanations? I don't know yet. But they may not be plausible. To me, other people might disagree. I don't know. Rex Heuermann, Long Island serial killer. Didn't have a lot of doubt for me about that one. Also a circumstantial case, but also one where there is layer after layer after layer of corroboration. Just like, although not to quite the same degree, but very similar to what I see in this particular case, where you have physical presence is corroborated by DNA, by video, by his own statements that he did it, by his actions that he took in turning himself in. This is why when I talk about the evidence in this case, I often talk about it in terms of like, this is a challenge for the defense. And the reason why is because when you have all of these different levels of corroboration, okay, I might be able to knock out one, but I still have, you know, what's left is still a big problem for me. Okay, let's say the defense is able to go in and knock out the DNA. Let's say they're able to get the DNA thrown out. It's a mixture. It's too complex. Can't, you know, no statistical validity to being able to draw assumptions about it. So no testimony, no evidence coming in at trial that Tyler Robinson's DNA is anywhere, but certainly, you know, not on the rifle, not on the cartridges or anything like that. They're still going to have video. They are still going to have Tyler's statements, you know, putting the rifle where they found the rifle, more or less. Tyler acknowledging having the rifle in the first place. You're still going to have the bullet fragment recovered from the autopsy, the jacket fragment that they say is .30 caliber. You're going to have his various writings and once again, his decision to surrender, to turn himself in as the suspect. That's still a lot for the defense to overcome, even if they can throw out the DNA. So I see this as a very difficult case for the defense because, yeah, they would have to get most, if not all of that out. And so when they're talking about there's going to be substantial litigation about the admissibility of a lot of this stuff, that's why. Because they have to. A lot of stuff has to be thrown out here for there to be good, plausible, alternative explanations for what remains. That's the movie I'm watching, guys. I'm in no different position than anybody else in terms of like, you know, my perspective is more true, more right, you know, whatever. Like how fucking arrogant is that? We're all people. We're all watching the movie. It is a movie. Our perceptions are being skewed by things that some of them we share, some of them we have in common, some of them are unique to us, our own background and perspective and stuff like that. But you know, we're all watching a movie. I'm not over here saying I'm not watching a movie. You guys are all watching. No, like we're all watching a movie, and we gotta wait to see, you know, whose movie is I guess closer to whatever objective reality is than the others. So I guess I went a little bit longer than I thought I was going to just for a hearing today. I mean, this is the bottom line, I think. I agree. Autodoc 911, every prosecution will have holes. The only answer is whether there is enough to overcome them. Does the hole undermine the explanation entirely? You know, it's very common to have holes. The example that I gave of no fingerprint on the firearm where there's DNA, totally normal hole to have. It's fingerprints, all kinds of variability in when they show up, why they show up, whether they get preserved, how they get preserved, who produces them, who doesn't. Like there not being a fingerprint on something is not particularly good evidence. Mr. Novak pointed out, and I agree, yeah, this common defense strategy that the absence of evidence is, is reasonable doubt, can be reasonable doubt. But it does require some assumptions. It requires the assumption that the evidence should be there. If it's perfectly normal that the evidence would be there, then no, absence of evidence is not evidence of absence. These aren't the same thing. Beautiful messy ball. Would you ever consider going on a channel that isn't against Tyler, like Baron Coleman or Candace? Well, what I said before is that my pretty much limitation on kind of engaging with anybody is, are you engaging in good faith? I need a show of good faith. I keep my circle small. I, not necessarily going to trust people to act in good faith. And so I question, whether either of those particular channels that you have named would be suitable for me, because I don't trust them. I don't have a reason to. It's nothing against them. I'm not, by the way, saying anything really about them. I'm just saying about me. I don't trust them. I don't know them. I don't particularly watch them. The little bits that I have seen, not to my liking, not to my taste. I personally, frankly, find most of it just is like some catty stuff. Very catty. That's not my thing. It's not my taste. Other people enjoy that type of thing. Go forth and watch Candace and Baron. I'm like the last person to tell you not to. But it's not my thing, and so I'm not going to. We have precious time on this planet, precious energy to guard. I don't find that watching this particular type of content for me is positive and inspiring and beneficial. Fills me with, optimism and idealism and desire to go out and do good in the world. It's not where I want to spend my time. I find it catty shit. So I'm not particularly interested. But yeah, my circle definitely includes Runkle. Runkle is in the circle of trust. I would happily talk to Runkle about anything at all. And again, not because I agree or disagree with him, but because I trust him to engage in good faith. That's why I engaged with that long comment that Kara had left me. Oops, I didn't mean that. Always seemed fair. I do appreciate that. I'm not blind to facts and information and stuff. And like to think I'm not only not a really super opinionated person to begin with. Like, I think, maybe this gets to some of it too, is just we all project, right? We all kind of assume that everybody else is much like us. And I'll tell you one way that I didn't realize that I was projecting this a lot. And I came to understand that that the world is not actually the way that I envisioned it in my mind. And it's like the Myers-Briggs, right? The Myers-Briggs test, the whole like EN, ES, TP, FJ, all of those. Introversion, extroversion, sensing, perceiving, thinking and feeling, perceiving and judging. I think that's what it is. I'm spacing a little bit off the top of my head. Anyway, it's that very last one, that very last category, the perceiving versus judging. And I'm a perceiver. I don't enjoy judging. I don't like it. It makes me feel like a little bit uncomfortable to be like judging, accusing. It's why I would be a terrible prosecutor. The whole like j'accuse thing is like so not for me. I don't like it at all. And so I just kind of assumed that most people are also like that. And I didn't realize until I started looking into, what is like the prevalence of these different Myers-Briggs types and so forth. Overwhelmingly, people are J. Like most people do judge, and not only do, but like it and get a positive, a beneficial type of feeling from it, a feeling of safety and security and stuff like that. To me, it's like the exact opposite. So that's an example of something where I think maybe I projected a certain non-judgmental quality to the world that isn't real. This was just me hoping and not realizing that the rest of the world doesn't engage like that. They do want to judge. And so I think we all do this, right? And so I think it's also entirely possible that many people have very strong opinions about this case already. Good example, if you really believe it's not possible that this was done with a 30-06 rifle, then you're going to have strong opinions about the case, because that's a pretty critical fact in the prosecution theory. And so if that fact fails, then you're going to have a lot of skepticism about the mechanism of all of this. I don't have strong opinions about this case. I think maybe people assume that I do. I think some of that might be projection. I see us very much as still in the wait and see mode. But there have been representations made about what it's going to be. And there's this total factual context here where a lot of those details haven't really gone challenged. There is the layers of corroboration and so forth. And so that puts me in a position to predict stuff. That's what I feel like I do. I'm like predicting what I think is going to happen. But that is at best, probabilistic. I'm not saying I've figured everything out and like know, how the trial is going to go and stuff like that. Lord, you never, even when it's your case and you have all of the discovery and you know everything that there is to know about the case, you still don't necessarily know how it's going to go at trial. You just predict the best you can, and sometimes chaos emerges anyway. It just happens. The unpredictable happens. So that's kind of how I consider my perspective on this. Probabilistic information, probabilistic assessments, they change with new information. When you watch, like you watch the fight or watch the ball game or whatever, and they're always like, you know, they're always trying to get you to do the sports gambling now. But you can literally watch the odds change as things go on. And that's because you're acquiring more and more information. The odds in round 8 of the fight are not the same as the rounds were before anybody threw a punch. I think that's the best I got for you guys. I mean, this is where we're at. This is how we're all kind of making sense of the information in different ways, processing it in different ways. I'm not here to tell anybody that they're wrong, they're doing it wrong, or anything like that. I can definitely point out when I think there are some like bad conclusions being drawn, or you know, assertions of things as fact that are not. They are interpretation, and the interpretations may not be plausible for any variety of reasons. You know, we can all have opinions about this stuff, but like, you know, Andrea's got a firm opinion about guilt or innocence. Like, no, we haven't even had the preliminary hearing yet. At this point, it sounds like the preliminary hearing might not even matter in terms of what we learn, but we haven't had the trial. I'm not going to rule out that there's plausible alternative explanations for all of this stuff. But number one, I'm going to let the defense be the lead on that. Like, this is what is just, you know, I continue to be overwhelmed by what seems to me to be disrespect to the defense. You know, just like flat out disrespect. And the defense themselves seems to be kind of seeing things this way. There is a reason why they are in the court hearings themselves or through their witnesses, minimizing, distancing themselves from the wacky conspiracy theories, terrible conspiracy theories. These are quotes, these are their words. They don't consider them helpful to the defense. And so, you know, to me, like, yeah, substituting our judgment based on absolute minuscule information relative to what the parties have in their possession about the case, substituting our judgment about like what's the defense, what's there to work with factually and isn't. To me, this is so overwhelmingly arrogant and stepping on the feet of the people whose job it is to make sure that he's treated fairly, to make sure that he gets a fair shake, that the plausible alternative explanations are evaluated, are investigated, they are developed, they are presented to the extent that they exist. But how on earth, like, I could think I'm in a position to decide what that is over them? I would never do that. This is not believing the FBI. This is me having so much respect for this defense team. The one last thing I guess I'm going to say on this whole topic, until probably somebody gets me spiraling again, but at least for now, the last thing I think I'm going to say about this particular topic is If you're using the word Fed slop, you've already turned me off. You've already indicated to me that this is not, you're not open. You're not open. And I'll tell you why. Fed slop in and of itself is not a useful term. It is not analytical. It's not logical. It's not doing anything. It is literally a thought terminating cliche. It is a characterization without explaining or justifying or anything. But what it has also become is a slogan. It is sloganeering when you use the word Fed slop, because it's the kind of word that's not going to persuade anybody that isn't already in your bubble. Why? Because you haven't explained what it means. You haven't justified using the term. And we'll go around and around in circles where people will throw, oh, well, but the, you know, the this and the that and the, you know. But you have to explain the totality of the facts. You don't get to just cherry pick pieces and be like, ooh, that's a whole, therefore the whole thing fell apart, therefore it can't be Tyler. No, it's just a whole. Because you still do have to explain in your theory of what happened. Why is he giving the note to Lance, allegedly? Why is he texting with Lance, allegedly? Why is he driving the 4 hours or whatever it is up to Orem with the rifle? Why is he on the roof? Why is he on the video? Why is he turning himself in? And if none of those facts are true, then you're really going to have to explain, how is all of this being fabricated? Because just a generic, they did it, he's a patsy. No, you need to flesh that out. How is he a patsy? Who set him up? Who told him to do it? How did they tell him to do it? How did they coordinate it? What was the reason? This needs to be fleshed out for this to work. And so Fed slop is the antithesis of all that. It's stop thinking and just emotionally respond to this word. So it's a slogan, and it's the kind of thing that just generates division. Because you're either, you know, one of the people for whom that word has emotional salience and it resonates with you, and you're able to like relate to what that means to you, or you're not and you're another. You're outside. So that's a real big tell for me. Just for those of you out there who care, maybe nobody, entirely possible. And entirely okay too, if it is. But if you want to get my attention and, you know, my engagement on the merits of your position, using things like Fed slop as arguments, this is counterproductive. This is not achieving. This is rhetoric, not logic. So kind of my last thing to say on this particular subject. Well, I don't know. I'm going to maybe be worried about reading back through the chat on this one, but I don't know. Maybe not. We've got a good chat, guys. We've got a great chat here. Like I said, disagreement is fine. Totally fine with people not agreeing with me, not liking what I have to say, not liking what other people have to say, and debating what the truth is and what's right and what's wrong. What we're not okay with is just people being assholes about it. But strong opinions in and of themselves are welcome. Oh, yeah, I can already see where things are going. That's okay. Like I said, agreement and disagreement is fine, and that's really the point. That's really the point. More talk is good, more speech is good, more debate is good. And that's why the things that tend to shut it down are the things I don't like. Being assholes to people, name calling. I'm not into the name calling. not into the sloganeering. It's just not helpful. This is the same shit that pollutes the politics and makes it kind of pointless for me, you know, as a policy exercise. I'm such a hey boomer, you know, talking about the merits of policies like nobody does that anymore. And that's exactly why I don't have a political home, because to me it's about the quality of what's under debate. And sometimes one side has it right, sometimes the other side has it right, sometimes they both, you know, are kind of off and need to find somewhere in the middle. And that doesn't work well in our political system anymore, because it's not really focused on the merits. But I would hate for our public discourse to degrade to the same level as our politics. That would be very unfortunate. Well, guys, I think that was quite enough for today. So I am going to go ahead and hang it up now. Another beautiful day here. Sun outside. We got our irrigation back on. I had to haul hoses around for about a little less than 10 days. Actually got the water back on earlier than they had projected, which was like a shocker. Had not expected that. So now the water's back on, and lots to do in the garden, lots of things to do outside. I got grandma to check on today. Yeah, all kinds of other stuff out there in the world that, all right, last thing I'll say, last little piece of advice I'll give that I always give, which is, guys, the internet stuff, it's as real as you want it to be. And as soon as you find it's not beneficial to you and to your well-being, absolutely justified within your right to turn it off and go ahead and live your life. So much more to life than arguments that are happening online, and people getting emotional about stuff that they may or may not know and that may or may not matter, and all of that. So you can always turn it off anytime you need to. I will support you in that, and I will welcome you back anytime you decide you need to check back in and see what my take is about stuff. Maybe you just want to check on the movies that we're watching. Yep, okay, we're still watching different movies. That's totally fine with me. That is absolutely acceptable. But it is becoming, I don't know, less and less of an analog world these days. And it's just so much easier to get dragged into digital life. And I'm not 100% convinced that this is really a great thing for all of us in terms of our well-being. But hey, me yakking more online isn't going to help any of that. So guys, I want to thank you all. Thank you all for being here. And thanks for following. I will get the archive updated. Like I said, I'll get that new document up, check and see if there's any others as well, but probably not, since they've been in court today. But I'll get that uploaded for you guys. Feel free to hit the the thing, the code thing up there. Get access to the archive, read through it all. You don't have to pay anything. It's something that I'm trying to do to improve the public access and information about the case. So feel free to check that out. I will continue to update it. Guys, I'll be back on June 1st. Definitely we'll be back on June 1st. We'll be back on June 12th. Definitely won't be missing those hearings. I'll get them on my calendar ASAP. Not sure. I'm never prepared to talk about what's going on in the meantime, because I'm not sure really that a whole lot is, but oh, there's a Mickey Steins hearing. Yeah, Mickey Steins is going to be back in court on June 5th, guys. So that we've had a good record of those hearings getting live streamed, assuming that they are. I'm definitely going to be watching that. This has been off the table for so long because it's just been sitting waiting for the ruling on whether the judge had a conflict of interest. And so that got ruled on. They decided he does not. So now we can finally actually get the case going again. And the judge seems eager to resolve a whole bunch of the stuff that has just been sitting on the table. There's a motion to change venue. There's a motion where the state wants a second psych exam of the defendant. He had the psych exam that is provided for by the statute. It's a quote unquote independent psych exam that's done by the state hospital. Seems the state doesn't like the results of that. So they want a second one. And there's something else too, but now I'm spacing that off the top of my head as well. So anyway, that could be very interesting in terms of finally getting some kind of moving forward progress in that case. That one's been sitting for like a couple of years since that happened. I don't even remember now when it was. It's been sitting so long that the civil case that was kind of related to all of this, the lady that was suing the sheriff's office, that case was going to go to trial and then settled like the day before. So when your case has outlived the civil case, okay, civil cases are like notorious for, at least to me anyway, for taking forever. Then you know your criminal case is really dragging. So I will plan to likely be back live on June 5th for that. Before that, not sure. Not sure. So do the things, do the things to get notified if something comes up. Otherwise, again, appreciate all of you joining me for these hearings. Great feedback, great comments, great chats, great debate. Appreciate all of you mods so much. Keeping things in line, to the extent that we have the rules, which are pretty nominal, the don't be an asshole rule. We really do depend on the mods to help us with that, but also to just set the tone, help us set the tone for the kind of conversations that we want to have here. And June 1st is going to be before June 5th. So June 1st will be the rulings on these motions. June 5th will be Mickey Stein's. Then June 12th will be back for the evidentiary hearing in this case as well. So that's our immediate schedule that we know about. Guys, appreciate all of you. Appreciate your interest in the case, in the topics, in the conversations, and all of it. It still like never ceases to amaze me that like people will tune in. There's still 477 of you sitting in here right now, like listening to me talk. The fact that many people are interested in my thought process and what I have to say about stuff, it really will never cease to amaze and humble me. So I do appreciate that. And thank you. And even if you're hate watching, like that's okay too. It's fine. I don't mind. The fact that you're that focused and attentive is enough for me, really. So I do appreciate it. I do thank you. I do thank everybody. And we'll be back soon. So do the things, but also don't forget to give yourself the space from the internet that maybe you disagree. I, for one, think that it's still an important part of the human condition to have our real analog lives that we enjoy. So I'm off to go enjoy some of it. Please, everybody, have a wonderful day. And I will see you guys soon.